Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Our game commentary on the case. Dahil mihi Anglican police, verbal slap. That's literally not true. I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It is a beautiful day. We have a few things to talk about, so we started just a tiny bit early because there's drama in the Sarah Boone case outside of what we're seeing in court. I'm excited. I'm not cold. I'm excited. Also, today we have crazy things going on. There's a very high likelihood that we're going to be referred to once again in court in the burn pit trial up there in Georgia with Melody Ferris. So I'll be like crossing my eyes and watching two streams at the same time. We'll be recording that one to see what happens. But we're following today. We're following the live trial from Sarah Boone because we're almost at the end. What that means is I don't know, and Thomas, my podcast partner, doesn't know either, exactly what tonight's going to look like. We might have a regular podcast with the Not Relevant podcast. It might have to be converted a little bit to the Relevant podcast instead of the Not Relevant podcast, just depending on what happens. For those that aren't familiar with the Georgia v. Ferris trial, Melody Ferris, the defendant, accused of murdering her husband, throwing his body on the burn pit, and pretty much burning it up. They thought it was an accident until they looked in the bones and saw a .38 special bullet casing lodged in one of the ribs. Then it became a murder investigation. They can't find the gun. They have no idea what the gun is, which gun was used. Well, we were watching court live. We were commenting on it before the Sarah Boone trial started last week. And while we were watching and commenting, Rusty, who happened to be Melody's boyfriend, even though Melody was married, she had a side thing going on. Rusty was on the stand testifying, and Rusty was talking about his stepmom, Martha Jane, who, and it happened very quickly. He mentioned that she owned some firearms, and one of them was a .38. And I said, that's it. That's where Melody stole Martha Jane's .38 special. That's where it came from. And I said it on the channel. All of us were thinking the same thing. I just have the microphone. Okay, so I'm not taking credit for doing some gumshoe detective work here. But I said it out loud, and you all heard me say it, and someone else heard me say it as well. And the person who heard me say it was Martha Jane. Yes, the very same Martha Jane happened to be watching our live stream, and she calls it Court TV with the man on the corner with the headphones, and she said, I heard him say my name, and that's where she got the gun. And she said, and I knew that my .38 special had gone missing, and she hadn't told anyone. So guilt got the better of her, and she made a call. She made a call to the police and said, I have to tell you something. I know you came to my house. You never asked me about my guns, and I never told you. But Melody knew where my .38 special was and some other things. A lot of stuff went missing when she was up here, and that gun was one of the things that went missing. So that testimony from Martha, who was not going to be a witness up until then, that testimony comes in today. On the case. It comes in today. She will be on the stand. They brought her down. She will be testifying. She'll be explaining that, and she might explain why she made the call, which would include us. So the man in the corner with the headphones might be mentioned in court today. If you want to hear that whole story, how it played out before, we did a live stream a couple nights ago where we put all those pieces together where you can hear the original audio. You can hear her call to the police, which was recorded and played. And then we're going to be watching the testimony. So if that develops the way we, I'm watching, Julie, I'm watching. If that develops the way we think, we might cover that tonight during podcast time. All right, we have a couple things we have to do. First of all, AES, congratulations. First in chat today, the internet is all yours, my friend. Good luck, because it's going to be a crazy day. I need you to keep it working for all of us, and if you can do that, there will be no complaints. But help yourself. I think this is not your first offense. Come to think of it, I think you've got a prior offense, which means a prior experience. Better for us, bad for you. Thank you, AES, for doing that. Also, we have some birthdays to sing to today. We like to do this every morning, so please join with me as we sing to some amazing people who are celebrating their special day today, and that would be, Harper, who is 2, RF, Easy B Wama Mama. Wow, is that right? Easy B Wama Mama, that's how we're going to say it. Buns and Melody Barnett, all celebrating their special day today. So warm up with me, if you will. La 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 la. There we go. All right. We are all going to sing. Stand up, take a deep breath, project your voice to the back of the room, blend your voice with your neighbors, wherever you are. Join in singing happy birthday to these fantastic people. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday to Harper, RF, Easy B, Mama, Buns, and Melanie Barnett. Happy birthday to you. Easy B, Wama Mama. Oh my goodness, that was a tough one for me. But Harper, Buns, Melanie, and Easy B, congratulations. This is your special day. It's finally here. I realize there are a million places you could be and a million people you could be celebrating with, but you've chosen to be here with us, and that makes us feel privileged, honored. It's wonderful. Hopefully we can return the favor and make your day a little more special. Help yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, possibly McDonald's, but it might have to be a 5-finger discount. I'm not sure if they honor that whole birthday pancake thing. No, I don't recommend stealing anything. But happy birthday. Have an absolutely great birthday. Have a great Thursday. The weekend is almost here. Harper, by the way, 2 years old, big 2. Congratulations. The world is your oyster, Harper. You can be anything you want to be. So start thinking on that. Wonderful. All right. Happy birthday. We are going to do the drum solo here in a little bit. We are also going to be going back to court as soon as the feed is ready, which has not yet come on from the courtroom. So we're going to be jumping to Sarah Boone. But we have things to talk about Sarah Boone before court starts, because there's been some drama, there's been some filings, there's been some talk, and now we have to dig into it just a wee bit and see what in the world is happening between Sarah and her lawyers. Oh yeah, good stuff. All right. I don't think this is the last verse. Here we go. Last time. Here we go. Yeah, this is the drum solo. Drum solo is coming up. Everyone get your air drum sticks and participate with me if you will. The air drums are one of the easiest instruments to play. You can practice in your car while you're a passenger. And you can practice now. Here we go. Beautiful, beautiful, beautiful. Thank you very much. That was wonderful, all of you. Oh, I need to fix this. That's the wrong one. So I teased this a little bit, but let's dig into this. I have to pull up on my document reader, which I think is on camera 2 now. Yeah, we had issues, so camera 2 is now. Camera 2 and 3 had to change places, and my brain has not adjusted to that yet. This is where we're going to go. Right here. You ready? We have a brief reading. This is in the state of Florida versus Sarah Boone. Comes now. State's request for in-camera hearing regarding financial arrangements between defendant and defense team. Now, when it says in camera, as much as I would like that to mean on camera, it actually means in chambers. I wish we got to see this play out. I wish we got to be a fly on the wall and hear every word of this discussion, but we're not. But the state is saying, we have a question. We think, Judge, we all need to meet in your chambers where it's nice and private and talk about this arrangement financially. And here's their motion. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. 1, the defendant is indigent. She had several appointed lawyers prior to forfeiting her right to an appointed attorney. The defendant is receiving costs money from JAC because of her indigency. Apparently, only investigator Billy Lane is being paid with JAC money. The defendant has secured the services of 4 attorneys and a jury trial consultant, and perhaps more people that the state is unaware of at this time. The defense team is expending tremendous amount of costs, having traveled from Milton, Florida to Orlando, Florida for a several-week trial. The team returned to Milton, Florida prior to the arrival of Hurricane Milton in Central Florida and then traveled back after it had passed, incurring additional costs. The state is concerned about a potential conflict of interest between the defendant and her team. Rules regulating the Florida Bar 4-1.8, Section D. The only way for the court to know if there's an actual conflict of interest, rather than a potential conflict of interest, is to review the financial agreements between the defendant and her team. If there is an actual conflict, the defendant can waive this right with the clear, unequivocal, and unambiguous language, stating that, gives case law. For a waiver to be valid, the record must show the defendant was aware of the conflict of interest, that the defendant realized the conflict could affect the defense, and the defendant knew of the right to obtain other counsel. The state is requesting the court to conduct an in-camera examination of the financial arrangement to ensure there was no actual conflict of interest. And if there is an actual conflict of interest, the defendant validly waives any actual conflict of interest. I certify a copy here, too, has been furnished to Mr. James Owens, Kevin Beck, and Tony Henderson, as well as the court. And this was filed on the 21st, just a couple days ago. So what are they saying? Why is the state suddenly so worried about Sarah Boone's deal with her defense team? Because what we thought was that she was not paying for them. We thought this was pro bono. But there's been talk, there's been chatter, there's been a little bit of whisperings that perhaps her attorney, Mr. Owens, might be holding the rights to her story for a movie production. That's his payment. That he gets it on the back end with media rights if they sell the story to Netflix or whoever else wants to buy, because there will be bidders. There will be bidders. And suddenly we have an issue. Suddenly we have a situation where, guess what? That could be a problem. And you say, why? Why? Wouldn't it be a better story if she wins? Isn't he gung-ho? Yes, it would be a better story if she wins this case. But wouldn't it also be a better story if it was a close call? Wouldn't it also be a better story if there was some drama? There is a massive conflict of interest potential here. And if Mr. Owens is holding the rights to Sarah Boone's story, he might have some problems with the Florida bar. So I don't know how this is going to play out. What the state is saying is that Sarah Boone has to file this motion saying, we know, I accept it. And why would the state be concerned? Why would the state be concerned? Because they want a fair trial too. They don't want to have to do this again because of an appeal, because there was a problem. There was a problem. And right now it's just chatter. Right now it's just talk, water around the water cooler. I have not seen any evidence that this is happening. But this motion means that what the state is hearing is serious enough that, hang on one second. Let me see if, let's see. Sorry, we're waiting for the feed to come in from Florida. is serious enough that they're willing to file a motion to go in chambers and say, Judge, you should check this out. You should check this out. So let's see. I'm going to try to dig a little bit and see exactly what this says. Florida bar. Let's see. We don't have a camera out of court just yet. We're waiting for the cameraman to turn on the camera in court. Let's see. Let me copy that. Sorry, I'm very slow at this. Using a trackpad instead of a mouse because my mouse battery died. All right. Conflict of interest. Rule 4-18. Just like Blindside. Just like Blindside. Business transactions with or requiring interest adverse to the client. This is under the conflict of interest prohibited and other transactions heading. Okay. A lawyer is prohibited from entering into a business transaction with a client or knowingly acquiring ownership, possessory, security, or other pecuniary interest adverse to a client except a lien granted by law to secure a lawyer's fee or expenses. So he should know right there, 0, not allowed, not allowed. But the state's saying, hang on, who's paying him? Now it could come out that the state has egg on their face and Mr. Owens says, no one. I'm footing the bill. It's coming out of my retirement. It's coming out of my personal earnings. I'm taking the hit on this. I'm just doing what I think is right. And the state's going to have to say, all right, you got nothing. But this is basically, Mr. Owens' name cannot come up as an executive producer on the Sarah Boone story when it comes out. It cannot be there. This is not something that can happen. The transaction, let's see. The transaction and terms on which a lawyer acquires the interest and fair, reasonable to the client are fully disclosed and transmitted in writing to the client in a manner that can be reasonably understood by the client. The client is advised in writing of the desirability of seeking and giving a reasonable opportunity to seek the advice of independent legal counsel on the transaction, and the client gives informed consent in writing signed by the client to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. A lawyer is prohibited from using any information relating to the representation of a client to the disadvantage of the client unless the client gives informed consent, except as permitted or required by these rules. You've got gifts to a lawyer or the lawyer's family, prohibited. Acquiring literary or media rights, this is Part D. This is specifically the section they listed. Prior to the conclusion of representation of a client, a lawyer is prohibited from making or negotiating an agreement giving the lawyer literary or media rights to a portrayal or account based on substantial part on information relating to the representation. Prior to the conclusion, he's not allowed to negotiate. So he can't even have a deal that says, look, if we win, you sign over your media rights. You cannot go there. And the state's thinking, I think he went there. Judge, we need to hear. We need to hear from Sarah Boone herself if this happened. But this is going to happen in closed chambers. If there was something there, if there's a problem, it will show up. It will show up as a reprimand on Mr. Owen at a minimum, because this is a blatant violation. And it could show up as a problem in court with them, like, dare I say it, a mistrial? Dare I say mistrial? Wow. I don't know. They say you can't cause your own mistrial. So, anyway, that's where we're at right here. Let's see. Go back. We're seeing if we can get a feed from court. Waiting for looks like the camera just got turned on. The feed is there. I'm refreshing on my end. Live view connected. Go live. Launching right now. Okay, give me just 5 seconds to make sure everything is functioning properly. Looks like we have 4 modems, 2 AT&T, T-Mobile, and Verizon all connected with a great bandwidth. And we're up. Checking the live stream. Sorry, this is what I do every morning. I'm just telling you. This is how we connect everything in the morning. A big shout out once again to Trial TV Live. We have Chris down there in Orlando. Okay, go live, and it's up. Beautiful, fun little dance we do to make that happen. But now we have our court feed. Oh, my iPad is not running. There's our counter. There's the bless you. This gives Owen's previous statements about Sarah owing him a whole new light. This is crazy. It could come to a mistrial. Owen's about to retire anyway, so he doesn't care if he gets disbarred. They need a new name for an ambulance chaser now. The news is bizarre. This might be handled first thing. I don't know. I did not hear in the past couple days, because this was filed. If we look at the dates here one more time. Hang on one second. I don't know who's connecting. Is this Amber? Nope, it's not connecting at all. Looks like this call's failing. Oh, we faded to black. Sorry about that. That was my pushed the wrong button. Who turned out the lights? I don't know if this will be handled first thing. It will be handled in chambers. Peter talked about it yesterday and at the live stream. So it might be happening first thing this morning. Looking at the filing, if we just check really quickly, it was filed 9:30 p.m. on the 21st. So the judge is aware of it, but I haven't heard him say we're going to have a in-camera meeting anywhere. Let's see. Oh, it's Mathis.
Call from
Mathis.
Mathis, how are you doing this morning?
I'm doing well. It's in the afternoon for me, and I have a call at the top of the hour where I have to do some creative explaining to do for future vision at my job.
Nice.
But it's going fairly okay. I just wanted to comment on a couple of legal things that I found out, which are very interesting.
Yeah.
So Florida self-defense jury instructions are actually fairly simple. It's, did Sarah have a reasonable belief that if she let him out, there would be a danger of serious bodily harm? There are then, it seems that battered spouse evidence is only really there to explain her state of mind. And you commented a couple of times on this overt act factor in the law.
Yeah.
That's only relevant for admissibility
in
of
court.
reputational evidence
In court, right.
So you can have a scenario like this. Suppose you're let's say in a bar, and there's a guy that shows up, announces himself, pulls out a weapon, and let's say it's a gun, and shoots someone, and then he disappears.
Okay.
And then a week later, the exact same thing happens. Guy shows up, dressed in the same clothing, announces himself in the same manner, announces himself, pulls out weapon, shoots someone, please. Let's say this happens a couple of times, a sufficient number of times that you're satisfied that this person will always kill someone when they show up. Now suppose you have this case. Guy shows up, you see him, as he's announcing himself, like he's shouting something like, "It's me, guys!" Like you think he's going to kill someone immediately. So while he's shouting, "It's me," you pull out a gun and shoot him, and he dies. Your defense would be, you would claim self-defense, but for this individuals, for this obvious serial killers, very obvious history of violence to be admissible in court, you would have to testify to an overt act that would put you in fear, that would put a reasonable person in fear. Like, it's me, guys. And I think at that point, you have a failure in the law. Like, because without the reputation inference, there's nothing you can do to to explain it. And I see there's a camera feed.
Yeah,
So maybe Florida law is defective.
I like that you say there might be a failure in the law, because I too look at this situation and say something's not right here. Somebody should be allowed to defend themselves, and not have to say, but the instigator didn't happen today. Right? There's been a history, and looking at especially at domestic violence, which is absolutely terrible. I told my wife yesterday, I said, do you personally think, she asked me, do I personally think that she should be allowed to someone should be allowed to defend themselves if there's been a history of abuse, and then they get the opportunity and they take it even though the abuse isn't happening at the moment. And I said, yes. But we're dealing with the Florida law. I don't know if the law will allow that, and the jury might decide that. Yeah. So.
It seems that it really is ultimately kind of a jury nullification argument, because in many ways, if you stress in the depending on how you word the jury instructions, if you could clarify the law in a way that branches off, there's a fork in future jurisdiction, and you could clarify it in one way or another. Both are consistent with the past, and one basically could kill battered spouse as a defense. And it seems, I've read in a couple of articles on this by Florida lawyers, it seems basically the reason why the statutes in case law isn't so great, specifically for battered spouses, is because most self-defense considerations are more of like a cowboy shootout armed robbery sort of thing, and less there's less sympathy for weaker person, like a woman that has to kill an abusive husband or brother or father.
Right.
So there seems to
in this
that
case,
seems to be where the history comes from.
In this case, like I just said, I believe that somebody should be allowed to, when they get an opportunity, like somebody, for instance, somebody who's kidnapped, they should, when they get an opportunity, anytime they kill their kidnapper, I think it's fair game. Mm-hmm. I don't think Sarah Boone's, I'm not confident Sarah Boone's case matches the requirements that I was just spelling out.
Yeah, it's an interesting case.
It has the elements of
because
revenge.
There are. Yeah, I don't think at some point, if you want to do a StreamYard Talking Heads stream like during deliberation, I can explain how I feel about that in more detail. I think it's not quite like you say, but we can talk about that another time.
Mathis, thank you.
But ultimately, it seems. Suppose you have.
Judges here.
Suppose you had like. Okay. Then we'll talk another time.
We'll talk later.
Have a great day.
Good luck on your call. Thank you, Mathis.
Bye.
Love hearing you call from Germany. Thank you. Bye-bye. Mathis is a thinker. He studies U.S. law and loves it, and not just like watches cases, but he digs into the case law behind the arguments and does a great job at it. So I appreciate him calling in. Thank you, Mathis. Let's hear what's happening today. Judge is on the bench, takes a sip of whatever is in his cup. It must be goodness. Sip of goodness. Somebody asked about my Venmo. I do have Venmo if you prefer to donate that way. I think my mods can put it in chat. Oh, there it is. It's right there. Thank you, Diana. I appreciate that. It does bypass the tax, not the tax collector. I still have to pay taxes, but it bypasses the intermediate collector before the tax collector. So I appreciate that thought. All right, here we go. All right, we're not going to be running replay on today. I am recording 2 trials simultaneously. Replay machine is working on Melody Ferris, and we'll be handling that tonight after it's done. I will stress once again, no spoilers in chat. Don't spoil it for us, okay? This is a pretty exciting day. Anything about the Melody Ferris trial, about somebody taking the stand, about what's happening next, or you'll be so excited, can't wait for you to watch. Unfortunately, that will get you a 24-hour timeout. And our mods have talked about this last night, and they're very serious about this. We have a lot of people who want to watch both trials. Spoilers ruin it for everybody. So please don't, even if you don't think it's a spoiler, even if you say, well, I didn't say anything about it. If it says the Georgia trial, if it says Melody Ferris, if it says Martha, if it says you were mentioned in court, it's a 24-hour timeout, and that's the only way we can handle that. Please don't be offended that we timed you out. Okay, I realize I get excited and blurt things out sometimes. I'm hopefully not going to get timed out myself. But let's enjoy the court we're watching now. This has been amazing. We will be back and we'll catch up on the Melody Ferris trial when it happens, and we're super excited to do that with all of y'all. Love my grandkids. I don't think she really thought he would die. I think she was very drunk, but she's a narcissist and a little bit crazy. Yeah, the alcohol part, though, in Florida is not a defense. There are some states it is. Like you watch in Michigan, you watch Cedric Simpson's court, and people will make pleas like, sorry, I have no recollection, I was drunk. And that's a factor. Not so in Florida. You can't claim that. All right. Today, the way this starts, we expect assuming there's no pre-trial motions that need to be worked out. The defense case is still open. When the jury comes in, defense has two documents that they want to present. There are those no contact orders that the court issued to George about no contact with Sarah Boone from previous altercations. Assuming they have not changed their mind and brought in new witnesses, which they have the right to do up until when they rest their case, they are then going to rest their case. It then flips over to the state for rebuttal, and we should spend most of the day with rebuttal, most of it being video. We're going to see a lot of video. Some additional video on the phone, I think possibly body camera footage. I don't know exactly what it is, but we'll have a couple experts, and that we believe that we're going to have closings this afternoon. If there are no more stalls or crazy breaks or things that have to happen, we might have closings this afternoon. If not, it will be closings first thing tomorrow morning, barring some unforeseen circumstance, and then on to verdict watch and jury and deliberation on Friday. There is a small chance that they could be done with everything today, and the jury takes this tonight. A small chance. What you just described as retribution and revenge, that is not justified because there's a time in between to leave the environment. It depends on the state. Some states do not have a requirement to try to flee. Stand your ground laws. There's some states require you to try to flee. If there's an option to get away, they require you to have at least attempted that option. Yeah, jury instructions would be in there as well. Also, somewhere in there, we have to fight over the wording of the right to use lethal or non-lethal, force. That's going to be a battle today as well. So you're saying there's a chance? Yes, there is definitely a chance. And Sarah Boone is all smiles this morning, like she's nearly grinning from ear to ear. She's even talking to Mr. Henderson, which I haven't seen her do the entire trial until this point. It's always just been Mr. Owens. And the two ladies that help her as well. Snackless Sarah, what a name. Snackless Sarah, oh my goodness. Gifted one membership. Thank you very much. Welcome. Appreciate your support. Sarah is snackless. That's funny because Sarah Boone did ask for snacks. Sarah just peeking around back to the jury makes a quick wave to somebody back. Might be her friend from jail. That's with us again. Let me make sure my feed from Topmark is the highest resolution it can be. And it is. The court's just a little fuzzy on our end. That's the camera, I think. Everyone's pretty jovial except for Mr. Owens on the defense team. Prosecution's pacing a little bit. Judge is studying. deep in thought, probably perusing case law, as he's known to do. When an issue comes up, this judge is amazing because in this trial particularly, almost every motion that was argued verbally in front of the judge has had no supporting case law from either the prosecution or defense. Zero. It's just been an argument. We should be allowed to do this. And no, like, as you know, the history has shown or the Supreme Court has upheld, none of that. And then the judge in his response has all the case law. Here we go.
Case number 2020 CF 2603, the state of Florida versus Sarah Boone, and after names for the record, beginning with the state.
Chief Cacciatore on behalf of the state.
William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah.
Ms. Boone, raise your right hand to be sworn. Please be swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Ms. Boone is seated at counsel's table, buttressed by her attorneys, wearing a black suit and pink blouse. All members of our jury are present this morning. State, or is there anything we need to address before we bring in our panel?
No, sir.
Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated to. One is, you did a marking course of any.
Correct.
Okay.
Right now, your ID is AD as in boy and EC as in
Defense Identification AB, Judge, which is the order dated June 16th of 2019. It's a no contact order. And then identification to AC. And it is a no contact order dated June 19th, 2019. And then I'd like to introduce them into evidence. And then I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. And then I believe we're going to rest our case, but at some point, I guess you would excuse the jury because
Need a colloquy.
Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do we want to do that now before we bring the jury in?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised. We'll use our time accordingly.
That one of the six?
I don't believe so. Give me a moment and I can check. That is an alternate. It's alternate seat 4.
Thank you.
Defense, do you have any motions?
Kathy, thank you very much for the gifted membership.
Just out of abundance of caution, I would renew our motion for judgment of acquittal pursuant to defense resting. I'm going to go do that now while the jury is still out.
Okay.
I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge in the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment, and I'll get those out right now.
Samantha Terry, one of our great mods, thank you. A very, very generous donation of 10 memberships. Getting people in green this morning. Thank you so much. Sarah, but not Boone, is here. Welcome to the gallery.
Is there
Sarah.
anyone else? The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them around.
Okay, all right, very good.
Pam Jams, thank you also. 5 gifted memberships. If you are wondering how to receive a gifted membership, we'll have one of the mods type !gifts in chat. The link that shows up as a response from me.
All right.
Something you can click and turn the setting
can we go ahead and
on.
bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand and bring in our panel, please.
We will bring the jury.
There's the link. You have to click it in the chat box. Once you've slid that slider over to the right, it just tells YouTube that you're eligible or you would like to receive a membership. It doesn't mean you will get one, but participating in the channel, being here, sharing it, liking the stream, all things that will help you receive a membership by what we've heard from the algorithm. And of course, generous donations make that possible. Debbie Wilson gifted a membership. Thank you. Thank you. Jennifer Blueniper. Jennifer Blueniper also gifted a membership. Thank you both. Good morning, Carol. Welcome to the gallery. Thank you. It's raining memberships. Claudia, thank you very much. Gifted membership as well. Regina Crawford, making it rain in here. You guys are amazing.
Jury's entering.
Here we go. Here we go. Color Michelle. Yes, here we go.
State, you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, I do.
All right, thank you. Y'all can be seated. Good morning, members of the jury. Good morning. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning. And then we'll go from there. Okay? All right. Thank you very much. Mr. Owens, you may proceed, sir.
Judge, at this time, I would move to introduce defense identification exhibit AB into evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to...
You may proceed.
The first is Defense Exhibit 19. We'll just review it and pass it down.
Thank you, love my grandkids. Appreciate the super chat. Iris, thank you. Kay Scarpetta, appreciate that. Defense is about to rest. As soon as they rest, of course, we'll get just a couple minutes for the jury to review the restraining order.
Next document is Defense Exhibit 20.
I don't think she will. Generally, that would not apply. I've not seen anyone get back pay for being held pending charges. God, yeah. I'm not sure if you're that's a huge bet. Go Sarah, go. Everybody in gray is saying go Sarah now. Yeah, be careful. I'm not going to hold you to that one. Thanks for all the likes this morning. You guys are amazing. It really does help the channel out. We're about to hear the defense rest and then on to rebuttal, which could be spicy. Florida is a death penalty state. This is not a death penalty case. She's only charged with murder 2. And we believe there's some lesser includeds in there as well. Because she turned down a plea deal of manslaughter with a 15-year sentence. Time served would probably only be about another 7.5 years, I think. But she turned that one down. So we'll see if that was a wise decision or extremely painful mistake. Master Ayden, thank you for the gifted membership. We have not heard the outcome of the conflict of interest issue. I do think that if Sarah Boone had to file a notice of waiver of that conflict, that would be on the record. I have not seen that. So there might be no truth to that rumor, and the state just did that out of abundance of caution. According to the law, after the case is over, the lawyer can negotiate for movie rights, but not before. We'll catch up with the Ferris case after the Sarah Boone verdict. Any spoilers about the Ferris case today will get you a 24-hour timeout. We're really strict on that one today, so don't even mention anything about it. This might be too much, Midlife Mania. We'll give you a pass on this one, but let's not talk about that case right now.
Thank you, members of the jury. Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
No, sir. On behalf of Sarah Boone, the defense rests.
Thank you. State, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
Pickles, Dr. Tanya Warner.
Jump straight into an expert witness on rebuttal. Kathy says, I'm shocked that she's happy with her defense. This is the longest Sarah's been happy with any lawyer. And welcome, Kathy. Kathy has a channel as well called Gossip, Rumor, and Innuendo. And it has all three of those things in it. Welcome, Kathy.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tonya, T-O-N-I-A, Warner, W-E-R-N-E-R.
Thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law, so anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And When did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut. While I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have.
Approximately how many?
Thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are?
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that. Avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
Objection.
You can rephrase.
Calls.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase, and that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access to funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes.
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there wearing a dark suit and a pinkish top.
May the record reflect she's identified the defendant?
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida?
Yes, it was.
And subject to a court order?
Yes.
And where? Who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, her work background, her marital background. I go through health, psychiatric background, any substance use issues, I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just
Elaborate
questions
further.
to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes just
if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch, and she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother. And according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him, and as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And
some water for the witness.
And so she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
To refresh your memory, just put them down and then tell us what you remember.
Just read the whole thing, Doctor. You've got a great memory. She left out one bottle of wine. I'm not sure if Sarah told her about the other bottle of wine.
Okay. She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out, and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to use a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because, again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
It can affect your memory, it can affect your reactions, it can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Judge, if we could approach the bench.
Yes.
Once again, defense does not state the legal objection. They just want to approach. So we're left to speculate why. The moment they objected was, or at least asked to approach for the sidebar, was if this particular doctor had diagnosed her with PTSD, and the doctor's response was, no, I haven't seen enough, and she hadn't given me enough evidence to show that that existed to diagnose that when I evaluated her. Now, granted, this was, 2.5 hours she spent with Sarah Boone, not 9 visits. But it's because she said jail. It's already out that she's in custody. I thought she already said that she was in custody. Gran, hello. Hello to South Africa. Ooh, what's for breakfast? Fried eggs and yogurt. So it's the jail reference. See what happens there. That's not something, you can't unring that bell. Good without that. What are you going to do? Ask for a mistrial now, Mr. Owens? Yeah, it's already out. Sarah said it first. I think for sure. It's a long sidebar. Wager says, Sarah said it in reference to her weight when the attorney mentioned it, plus the witness said, I interviewed her at the Orange County Jail at the outset. I think she's still happy. She's just got a serious face on right now. Sarah Boone is really excited. It was 2.5 hours. I think it was 2.5 hours she spent with her, but still it was just one visit at the jail. The story's a little different, though. Key points that Sarah Boone told the state's doctor was that he stuck 2 fingers out, which means the idea of him sticking his whole hand out didn't occur to Sarah or her defense team until they couldn't get their self-defense evidence in and needed something more overt. Perhaps 2 fingers was not overt, or else she would have had they needed that previously or known they needed it, she would have told the state's witness that he stuck his hand out. I don't think we're going to get to 12 days of trial. I haven't heard that song. Yeah, it didn't come up until she needed that defense. The lawyer implied by his actions that his whole arm was nearly out. Oh yeah, George was emerging from the cocoon. Imminent destruction was about to occur, according to the lawyer, I think, the way he presented that. She also skipped over the videos. Yeah. Much easier to stick to the truth than to remember a lie. I want to say a huge thank you to Jules, who has been our court watcher thus far. I think it's public, so I don't think she will be upset with me sharing this. Jules is fighting a major battle with a medical battle that is taking a ton of her energy. She's not able to be in court with us today. She feels terrible about that. She's resting up and watching here. Jules has been amazing. I would recommend you follow her. She loves watching court and has done it for a long time. We found her at the Maya trial. She's just incredible. I got to spend a lunch with her down there in Florida when I went down for a hearing. So keep her in mind, and please follow her on TikTok if you're over there. That's where she does most of her stuff. But she's been amazing, and I just can't say thank you enough. She's also on X right here. There's the link. Thank you, Samantha. Jules checked in with me this morning. We've texted back and forth a little bit. She's resting up right now. Sound is muted right now because there's a sidebar. Yes, the court has turned off the microphones while the attorneys are at the bench discussing whatever objection the defense raised. Could be that she mentioned that it was in jail, but that door was already opened. Sarah has a bad case of cross-examination. I think that phrase came about in the Karen Reed trial, right? I love it. Whoever thought that up, that was amazing. The notorious Jules. She's been instrumental as well. As we have equipment down in Florida bringing you this live stream, we didn't realize the particular setup that's unique to this courthouse that puts our tech guy, Chris, outside for the live stream, not in the courtroom as we normally are. And Jules initially provided the vehicle so Chris could get out of the sun and we could have, house our equipment out of the weather. Jules, thank you very much for that. Waiting for the court audio to come back. It looks like Mr. Beck is not involved in this particular discussion. Judging from the legs, it looks like just Mr. Owens up there with both prosecutors. I know it's a little late in the game, but I could create an on-screen logo to let you know that court is muted right now from their end. Let's see. Does anyone else have issue with the story that Sarah tells about her being it and running and hiding in the shower and waiting for a long time and George not coming to look for her? And then she finally gets out of the shower from hiding and goes down the stairs to see where George is. And George is just then climbing into the suitcase. Like the entire time Sarah was hiding in the shower, George was just looking around frantically for a spot. And finally, he found one right when Sarah's coming down. The house rules she plays under are wild. A couple things could be happening.
Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you. Y'all can be seated. Thank you. Mr. Owens, if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
She hadn't provided this opinion before?
It applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnosis after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens. I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41 that addresses specifically opinions as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it.
judge
Line
correcting
7, the
his
witness,
reading is
Dr. Warner
hilarious.
says absolutely. And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, you know. That's how she answered. She goes through a little bit of that. And then, paraphrasing, she talks about the grandiose component or criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Warner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples.
Judge, excuse me for interrupting, but can we lasso this back into...
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
All right, page 46. Line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13, on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look back through my notes to see if she fully met the criteria. Question, line 17. Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer. I may. Number 25, question. Okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay. That's a good argument.
So at the time of this deposition, when I asked her specifically...
So what's the legal objection?
He has to say it. It's not the judge doesn't see it.
What are the legal grounds of the objection?
I would not take that deposition, Judge. And she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions. If this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
what are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
Failure to disclose an opinion. The judge is not going to make
I understand the
objection.
backdrop.
He says if Owen says the right words here, this witness could get thrown
I don't know
out.
if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to
Consult.
because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well then, my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing, and once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a definitive no.
Attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
Okay, that's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time?
Exclude the witness.
Mr. Owens.
Strike the witness.
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor?
Yes.
Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
Judge,
Owen should swing for the fences here.
Number two is a discovery violation.
There we go. There we go. Getting closer.
What is the legal opinion?
Closer.
That post-traumatic stress disorder doesn't apply in this case.
No. The legal.
Dr. Harper.
Legal objection.
Did, and that's what experts do.
I would like to have known that, and that was going to be her opinion before today.
Failure to disclose an expert opinion is a major issue.
That's not a change in testimony.
Where is that a change in the deposition?
You're going to have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20.
He needs to make a legal objection.
Let me know when
The
you're
judge
ready.
will not, even if the judge sees it, the judge will not do it for him. And if
Yes,
he
sir.
just doesn't call it,
Page 66, line 20.
It flies.
Question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23. No, sir. Not that I'm aware of. Line 24. Question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1. Yes, sir. Question. Then I go into fees. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified if there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I'd have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course.
you can't talk while she's reading this back because she can't. I'll both take notes and read notes at the same time. Previously in trial, there was times when there was a lot of objectionable moments, but nobody called it. And the judge said basically, there's been a lot of problems, but you guys haven't filed an objection, raised an objection, so it goes. I think the judge could make this argument very well for Mr. Owens, a winning argument for Mr. Owens. And I'm not trying to get Sarah Boone, set her free type thing, but I do want a fair trial. And I think Mr. Owens is blinded by the topic that he's objecting to instead of the legal argument that the judge needs to agree with his objection. Laura, thank you very much.
Court's going to step off for a moment while Madam Court Reporter is able to provide that reading.
So now she has to type. Okay, so let's start out right here. The audio is down from court right now as the court reporter's going back because the court reporter's recorded everything that happened on this little discussion. Once the jury left, she takes all that down. So now she's scrolling back to find the exact question that was asked of the witness, and we're trying to see if the question and the answer violated this discovery rule, which is the closest we've gotten to the objection. Mr. Owens may have a very, very valid complaint. And if he does, instead of saying, hey, I should be allowed to do another deposition with her right now, just quickly, let's do a deposition so I just know what she's going to say. No, Mr. Owens, swing for the fences. Go for the home run, not the base hit. Instead, you should ask for the witness testimony to be struck, and that she be removed as witness, that her entire testimony is struck and she's kicked off. I'm not sure if you'd actually go for a mistrial on this, but let's see. We've got Jules calling right now. Hang on one second.
Call from Jules.
Jules, how are you doing today?
I'll be fine. I'm going to be heading out to my son's very shortly.
Yeah.
Let me give you a brief thing from yesterday afternoon, leading up to this morning, because I have someone in there, and I did get new information as well on my own.
Okay.
Okay. So the jurors that will be deliberating is an older gentleman. I'm going to guess maybe 50-ish. Somewhere in that age range. He has been very stoic throughout the entire trial. He looks, he always has a serious look on his face, very firm, and takes notes. Then there's another gentleman, I'm going to say maybe 30-ish, 40-ish, that will be deliberating. Again, he took notes. I'm going to say not a whole lot, but he was taking notes.
Yeah.
The remaining ones are 4 women, and yes, it is the infamous DV woman.
Yeah, juror number 13 from Friday.
She will be deliberating.
Yep.
Now,
What can you tell me?
Go ahead.
So what can you tell me about this? There's the chatter, the motion that was filed about possibly Owens negotiating for media rights to Sarah Boone's story.
That is the buzz. Now, you know me. I have no problem approaching anyone and asking questions, but that was the buzz yesterday, and I just felt like if I asked Mr. Owens that question, I may have been crossing the line, so I hesitated to do so. However, someone else did.
Yep.
and he was. I don't want to say he was not forthcoming, but he skirted the question. He skirted it, which leads me to believe that there may be something to it here on that. But I cannot confirm it because he didn't confirm it.
Yeah, that would be a violation of the rules in Florida. They're not allowed to negotiate for that prior to the end of the trial. After the trial's over, they can, but it can't happen before. So we'll see what happens.
True, but I wonder if he can skirt around it by having a discussion with her in regards to that, but not getting anything in writing from her.
It depends who reads the transcript on the discussion, because negotiation even is not allowed. So just saying, hey, if we win, I'd like to talk to you about this. That's beginning a negotiation.
He made it clear Sarah will be paying me in the end.
Wow.
So what does that mean?
Yeah.
You know, I think he is negotiating something, and he may have gotten his hand caught in the cookie jar.
Yeah. Crazy. Jules, thank you very much. We are waiting right now. Mr. Owens is trying to
I've been watching you. I've been watching.
Awesome, thank you. He's been trying to
but
make
here's
a valid objection and get possibly this
Okay.
witness thrown out. That's what he should ask for.
But I was listening to what you were saying, and you were spot on. He's not citing any laws. What you said is what he should have said, and he's getting lost in the weeds trying to make this argument, and that's my opinion.
Yeah.
I will say this. My source, because I did leave a source in the courtroom, and I said, you need to be messaging me blow by blow, because I have a commitment, even though I'm not there. I have a commitment to
Jules,
report on this.
your commitment is to your son and your health right now, and we
I know.
love you for it.
I know.
We're praying for the best for you to get rested up, and we'll see you again in another court.
I will. I will. But 2 rows have been roped off, my source tells me, with reserved signs, and the only person that is sitting in there is the victim's advocate. So I will assume that at some point today, George's family will be coming in, because she's the only one sitting there, and she was there with his 2 daughters the other day. So I would imagine at some point his entire family will be in the courtroom.
Yeah.
Today, because those rows were roped off.
And that's probably because they would want to be there for the end of the trial. And there's a small chance, it's getting smaller every time we have a delay, but there's a small chance this could all end quickly. And we could have the jury deliberation begin right away.
I know when I spoke with Mr. Owens yesterday, he said he is bound and determined to get through everything today and get it into the jurors' hands today.
Yeah.
But now that this came up, I don't know. So
It'd be interesting. Thank you very
We'll
much, Jules.
see.
Take care of
You're
yourself.
welcome.
Take care of yourself. Get healed up. Get feeling better. Thank you so much.
Yeah.
All right,
You're welcome. Have a great day.
Bye.
Bye-bye.
Jules is amazing. Love that she made a connection, made a source there in the courtroom. We have a couple people down there, which is awesome. Thank you. All right. Judge stepped off the bench where we are right now. This was not a normal break. The judge stepped off the bench because the court reporter is trying to find a specific point in the witness's testimony where a question was asked and an answer was given. The answer that was given was different than what the lawyer, who is an officer of the court, told the court he was expecting. And the answer that was given would be more along the lines of a conclusion the expert reached that was not divulged during the deposition that expert gave with the defense. So defense is complaining about that and trying to get some mileage from this. Unfortunately, Mr. Owens, maybe he thinks his case is weaker than it is, because the judge has given him a lot of time on this one, and the judge doesn't like stalling. This judge is very very efficient with his use of the time, especially when the jury's waiting. Because the judge has given him time, I would think that his argument has some validity, or at least the judge could be persuaded if given the right objection or argument. The judge sent the jury out. They've argued about it again, and he's asked a number of times. He's prompted Mr. Owens, what is the legal objection? What is the specific legal objection? Mr. Owens instead is focusing on, she said, she's making this PTSD decision, which she said in the deposition she didn't. That's not the legal objection. Those are the weeds. Okay, the objection is a high-level objection, undisclosed opinion, and he got close to that by saying a discovery violation, and maybe the judge will sort of allow that to be enough to consider, especially if it's something the judge considers is a violation, is objectionable. So we're waiting for the court reporter to find that portion. We're also waiting for the judge to come back because he did step off the bench briefly for a little break. And when they come back, we'll see the conclusion here, see if the judge is willing to do this. The judge also asked Mr. Owens, what would you want done? Okay, which would be an indication that he's leaning towards Mr. Owens' direction. What do you want? What's the remedy that you're asking for here? right? You've got this motion. What's the fix? There's a problem. What's the fix you want? At that point, it might seem crazy, but that is the time to put your best batter up and swing as hard as you can at every pitch, because you might hit a grand slam. And instead, Mr. Owens at that point just asked for, well, I'd at least like to do another deposition. Really? So you get like an hour's notice to see if this happens again? It already occurred. This is when you need to go and say, strike the testimony. Ban the witness. Say, sorry, this is a violation. This is pretty serious. And then, he might not get all that, but it gives you a starting point to negotiate from. And it also goes to sort of, in a way, bolster your argument to say, look, this is how serious it is, Judge. Get rid of her. We need to strike this. We need to unring that bell for the jury. I want a curative instruction given to the jury to fix this. And he didn't. By him just saying, well, I'd just like to check and see if there's anything else that's changed since I talked to her last. It's like, oh, that's all. Yeah, we can give you 10 minutes to talk to her. Wah, 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 wah. Yeah, a little bit of a failure there. And it's not that I'm fighting for Sarah Boone here. It's not. I love the legal system, and I love it to be fair. And I don't like seeing a failure. Honestly, I mean, there's a point. If this is something that's clearly obvious, if there is a objection, a legal objection that should be made here that any first-year lawyer could see, and he doesn't make it, now does Sarah Boone possibly have, if she's convicted, a path to an appeal for ineffective counsel? Nobody wants to go back and retry the court again. Let's see. We don't want an appealable error for sure. These lawyers have not had 5 years. I agree. They're on working very short time. I'm giving Mr. Owens a ton of credit because, first of all, coming in here being pro bono, well, at least we thought he was pro bono, that's huge. Being able to take on a case that, by all accounts, was untouchable from anybody who was offered it. They've done an amazing job. Working with Sarah Boone, she's not an easy person to work with. We know that from her letters. We know that from the motions of her previous attorneys begging to be let off the case. And throughout this, Sarah Boone, they've not only worked with her, they've kept her happy with how they're doing things. Lee's on the phone here. Let's see if we can talk to
Lee.
Hello, Lee. How are you doing? One of our other court watchers.
I'm good. So I'm not a lawyer, so I don't know this for a fact, but to me, this is not a discovery violation because to me that applies to the lawyers turning over materials.
And
Isn't this just and then he stated that yesterday and this morning she did not express that opinion to him.
Right. So
isn't this just a simple case of a witness changing opinion?
Yeah, but there's an objection you can make there, though, especially with an expert opinion who's responsible to turn over their findings beforehand. There is an objection to be made. It's not on the lawyer, which would be the discovery violation. That's why I say maybe the judge is going to allow him to say, yeah, that objection was close enough to let me address this and make a finding. But
isn't the usual remedy? I mean, isn't this basically he can impeach her? Owens can impeach her, right? He can say, your opinion you said before was X, and now you're saying Y. Is that not enough?
The problem is she's an expert. And this court has been doing things differently. All the experts, they haven't used the regular terminology where they say, I move them to be accepted as an expert in this field. The one time we heard that, it was objected to and sustained. So I don't know I don't know how they're handling that. I believe she is an expert. Judge is back. Lee, we've got to go here, but thank you very much.
Bye-bye.
Appreciate it. Bye.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone.
Kevin Beck on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Yes. Okay, you may proceed.
She's not mic'd, so we've got to be careful here.
By Mr. J. Question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Question. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question. If you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question. All right, that's it.
I don't think that's the very beginning before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. 1, 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back. When it was first going on, when a question was asked, and I believe she rendered an opinion, and I, again, like that to be reread back. What the initial question was, what the response was, because it didn't. I know I objected. I can't even remember it now. But I know I objected because I knew it was inconsistent with...
You asked to approach, and then you explained that the question was it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like...
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any... Can you reread that? So I can...
Let's just reread the entire proffer, just so that it's a clear, soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind.
Soup to nuts, here you go.
Yes, ma'am.
By Mr. J. Question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer, that it's not related to the incident as she reported it. Question, okay, and if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial.
I'll play the initial for you. Ready?
Yeah. In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Yes.
That was the playback of what happened initially, just audio-wise. And what was your opinion? That she did not give me enough to diagnose her with PTSD at the time I evaluated her at the jail. So that's a no opinion. Let's let the court reporter find that same part and read that back. What's funny is even though the court may have access to an audio recording, the official transcript is the record of court, and it will be as read back by the court reporter instead of as played back from the live audio recording. So in her Mathis has listened back and forth. Mathis is a thinker. He says, listen to both parts multiple times. Owens is 100% right. Her opinion contradicts the depot where she said she has no opinion. So now she has an opinion that she did not exhibit that. Not enough to make a finding. It's very similar, though.
Are you ready, Dr.
Can we talk about why Owens has a
I was waiting on you. Please, go ahead. Sorry. Pay no attention to me.
He did bring a stick.
My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
Judge is working the court.
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Make a strong argument.
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have been noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end some general, if you have any new opinions or anything new that differs from what you've said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
There we
Any
go.
response?
There we go.
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was, irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about.
specifically asked you, Mr. Owens, to point out for me excuse me. I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified.
The ones that I expressed, and that just the understanding that we had, that she, in the pages that I have talked about previously here today, in the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had, in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J?
Nothing.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the readback of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
He didn't win the Richardson.
No, other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay.
He's not going to win the Richardson.
All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial, although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens.
Strike. Move to strike. Move to strike.
Because my question is, do you want it struck?
Yes. He got a win out of that. Owen's got a win about that specific thing, not the larger issue.
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you.
It is worth so much more mileage to have the judge say, jury,
with regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry?
With regard to the proffered opinions,
we get a
the
live
court will
depo.
oversee a deposition now.
We get a live
And
depo
you may proceed.
right here.
Right now?
Yes.
Right now. Are you prepared to ask the questions?
With regard to the proffered opinions. And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren.
Yes, sir.
Good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed.
Whoa!
That I didn't have enough information.
That's discovery. That's a discovery violation. He knew.
And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes.
When did you form that opinion?
That hadn't
When
changed?
she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail.
I heard had changed.
After the
Was it
deposition?
hadn't?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right, and I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically?
No, sir. I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes.
is relating to a central issue in this case.
Correct.
You're aware Sarah Boone's on trial for murder.
That's correct.
And you had this opinion when I was taking your deposition. And I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
She's gone.
Mr. J, anything else?
I'm just making sure he doesn't want to inquire.
This is your opportunity, Mr. Owens.
Because that was more just about...
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases, and now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom.
Yes, sir.
And we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today?
Don't say
under
intend.
oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who is on trial for murder in the second degree?
Judge, I'm going to object. The catch-all, vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge.
Yes, sir.
We're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial.
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
Can I continue with my deposition?
Yes, sir.
Dr. Warner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So, narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome.
Alcohol use disorder.
Alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Oh my goodness.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I'm leaning towards the adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
Doctor, does she bill double for deposition and court time here? Is she going to double dip on this one?
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May.
What?
So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively you can't say?
There's a history of her having that, yes.
Owen's
so you
gonna
agree
flip
she
the
suffers
witness?
from battered spouse syndrome?
Yeah.
Boom! Wow! He's going to flip the witness in front of the jury.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
He dragged it out of her.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can...
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
Does it need to be on the record, or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying again since they've been here in court this morning.
They're still under defense subpoena.
I asked Mr. Henderson if you guys were calling Detective Copsell again, and he said no.
And we're not. In our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed their presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your basis? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in a rebuttal. But
That doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant is pursuing.
Okay. Anything else, Mr. Cacciatore?
Okay. Yeah, it's my call.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much.
Wow, kicks out the investigators.
Anything else, Mr. Owens, we need to address?
I don't think they're going to get Sir rebuttal.
Anything else, State?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
I was not expecting this morning. What morning? Holy cow. When he said from soup to nuts, he meant it. That phrase actually, I think its earliest reference in books is from about 1890, where it was referring to things you should have at a meal, both soup and nuts. Not necessarily the one has to be at the beginning and the other at the other end. So that was, I believe, the traditional method at the time. Sir rebuttal is when the defense gets a second bite at defense, where they call additional witnesses. I moved to strike my previous statement. God, yeah, it's so stricken. Thank you.
Bless you.
Oh, we gotta bless you. We gotta bless you. It's a great day. 2 dozen. 2 dozen. Thank you, everyone who's clicked on the like button. That helps the channel a ton. It is free. I appreciate that.
Jury's entering.
Looks like about a third of you have clicked on the like button. We've got, well, a little more than that. 1,369 likes. Thank you. I Googled it with safe mode turned on, Mr. Fix-It, because I was not sure. I was not confident.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Yes. I thank you all. You can be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
What? Oh, look at this. This is a chess move. Okay, this is crazy. What they just did. That entire fight we just had, the state knows that the defense is now going to get more mileage out of that on cross-examination. Okay? They want more mileage on cross-examination, and they don't want to lose. And now they're asking to strike their own witness's statement, which was in answer to their question. I think it was responsive. The judge should not strike this. They want to strike it so it takes that opportunity away from the defense. So they can't go into all this on close. This is epic chess. This is unbelievable. What a smart move, first of all. That was an incredibly smart move for him to try. I don't think the judge will grant it. I don't think he will. Oh, my goodness.
Your objection's overruled.
Boom.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's been asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent, there was an imminent risk of harm that she needed to protect herself.
Truth there.
Yes.
This is being fought vigorously. Oh my goodness. This is why Owens can't flip her. I thought that she did not disclose previously that Sarah Boone had battered spouse syndrome. I think that's the grounds that Owens gained through the deposition, where she admitted that she had the symptoms. She had those things were present. And so she has to say, yes, this is a battered spouse. That's powerful. Now she's saying, yes, she has it, but it doesn't apply because the way she told the story didn't fit. And I hear that. That resonates with me quite a bit. That's my personal belief as well. The way she told the story didn't fit battered spouse. Oh, wow. This witness, I don't know what she's getting paid. Usually an expert witness has a fee for depositions, they have a fee for travel, they have a fee for testimony. What happens when you're on the stand under oath in court and you're giving a deposition? Do you get to double dip? I say yes, because I think she's earning it here. I'm not on the defense side. I still do not believe that Sarah Boone should be found not guilty. I believe the state has proven their case to me. I love legal battles. I love courtroom drama. I love the chess game. I love a fair trial. And this has delved into some areas we don't normally see in court, which get me excited. Build two separate parties. And we still don't know if Mr. Owens has the movie rights to this whole thing. This is tricky to explain everything that just happened because it happened over about an hour. She gave a answer to a question. The question was, do you have an opinion? What opinion you have reached? And she gave an answer that was different from her deposition a little bit that hadn't been disclosed. It was slight, and it was that her answer was that I didn't get enough information to make a finding, to get an opinion whether she has PTSD. And through the deposition, which the judge allowed him to do right there in court with the judge presiding, which is amazing because normally there's not a judge at a depo, right? Normally you've got two attorneys and they make objections and they sort of fight about the objections after the fact, but they just proceed as if the objection was overruled. It's crazy, right? It's really crazy. But here the judge was there and calling balls and strikes. I've never heard of a depo happening right there in court like that. This was, the witness has been a little cagey. That showed when she says, you ask me the right questions and I'll give you the right answers. It's like one of those, an iRobot, where, when they're trying to solve the puzzle and the robot says that's not the right question, you need to ask the right question. The witness did that a little bit, which I understand. Okay, the catch-all, a question asking a witness, tell me everything you might think about this case. Okay, that's a big question. But Owens was able to turn back on her and say, what additional information would you need from Sarah Boone, about Sarah Boone, to reach that finding of PTSD? And she said, well, I would need evidence of this, that, this, that, this, that. He said, but you didn't ask her that, did you? About any of those? And she says, well, I asked her a catch-all question. Is there anything else you want to tell me before I leave? And so she, on one hand, is saying, you have to say specific things to get the answer from me as an expert. On the other hand,
members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
She used the catch-all in diagnosis, which I think is, I think can be argued as unprofessional. To not ask about areas of, and obviously you don't want to prompt somebody who's feigning. Well, have you had any migraines, persistent migraines? Yes. You don't want to prompt that.
Y'all can be seated. Thank you.
Let's see where this goes.
Madam Court Reporter, when you're ready.
All right, the judge is looking probably for case law right now, but we don't know what the objection is. This is crazy. This is crazy. Give me just 1 second. I want to see what some of the people we know are talking about right now about this case.
Yes, ma'am. Just read it from the question, answer, question, objection. Let's just have we can buttress it.
Here we go. Listen carefully.
Go ahead.
By Mr. J, question. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or BSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
Judge, it's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time despite his mental illness because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony, Judge.
Any other argument, Mr. Owens?
That's totally wrong. The prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and the answer to the jury, and I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
Object to the readback.
It was asked and answered.
Overruled. There was a pending objection. Allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for mine.
We're going to begin your cross-examination after we're done with after the state advises the jury in open court that there are no more questions. Let's go ahead and bring back in our panel.
Okay, I would not be surprised at this point to know that there was a back alley boxing match scheduled between Owens and Jay after this court is over. These two do not like each other, and tempers are a little bit hot. He originally said he was only going to have half an hour of cross-examination of this expert witness. Now saying it's going to be an hour, possibly because of what he got in the deposition, the mid-testimony deposition. He did sort of want a recess to prepare. That's not going to be granted. I think he's got enough material that he can get at least to lunch break, then get a break and get a sort of regroup at that point.
Jury's entering. You will bring the jury.
This is why we watch courts, guys. This is amazing. It is sad in all this that George does not seem to focus at all. But
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, you may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
this is what they're going to close on with this witness.
Question by Mr. J. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or ESS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and ESS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, The whole part where she's describing the part of about playing hide and seek, they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Dr. Warner, good morning.
Gloves are off on this cross. They have to be for Mr. Owens. He cannot
What all did you consider
do poorly
collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copsel.
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
sustained.
You said you considered some text messages from Sarah Boone's phone?
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection. Any reproach?
Yes.
That a smile. Oh my goodness, that is not a smile. That is not a smile. Wow. She keeps touching the mic. She is moving it away from her. She's quiet. I think it is wrong here to say, hang on. Oh, Amber, I think I hung up on you. No, you're calling back. Let's see. Why is it coming in on the wrong phone? I have to change the plugs here. Can you hear me now, Amber?
I can hear you. Am I live? Or?
You are. You're live. So
I
keep
am
it
live.
family friendly.
I want to make sure that the chat understands that we, under no circumstances, reach out to people related to cases.
Yeah. Please.
That is not something we encourage. So please don't do that.
Yeah,
There's lots of
I didn't
talk
say
and
anything.
chat.
I wasn't reading chat.
Yeah.
We're back. But
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Another question, sir.
Did it
quick voir dire of the
apply
witness.
to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information.
Yes.
the documents. You read the documents.
Yes.
You read all the text messages.
Correct.
And you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had...
Yes.
I'm loving this. I need some popcorn. This is wild. What Amber was saying. I have so much respect for the court, the legal system, for the court process. There are times to speak to people, and there are times that are not. When court is in session, when someone is facing charges, I don't want to get involved at all. I realize that, as far as YouTube goes and getting views and likes and eyeballs on it, it might be good for the channel to talk to somebody like that, but it's not good for media access as a whole, which is something that I hold very, very dear. We strive to raise the bar when it comes to media access. We want our behavior in every situation to be reason to allow more access than to restrict it. So please let's not have anyone reaching out to people mid-trial. They've got their hands full. Okay, Mr. Owens has his hands full. He might reach out to us, as he's reached out to Jules and things like that. But we're not going to try to interrupt in the middle. We all win. We all win if we can follow this rule. We all win if we, as far as access to courts, we're going to see more courts where cameras are allowed. We're going to see more media access, and I think that's a better solution than getting an inside scoop in the heat of the moment that could cause problems in the courts. So that's my reasoning there. I appreciate your support on that front. I need to go to the post office on lunch. Apparently I've got a package, and I'm excited to see what it is. I think I might have some yummy candied jalapenos that somebody sent. Just saying. Bite Me, Sarah Boone Book Fund, The Truth About Sarah Boone. Ghost written by somebody, and the author is going to be Mr. Owens. What? Witness is getting defensive body posture. This witness knows that she's going to be picked apart on some of the, and she knows what areas this is going. And so how she answers these questions is going to be very interesting. It might also go to show, it might be perceived as a bias by the jury, depending on how she answers. Oh, good old-fashioned air popper is my favorite popcorn. Although I've been known to do a microwave quick fix. Only 6 jurors will deliberate. That's true. There are 14 jurors who are seated. None have been dismissed. None of the alternates were dismissed. So 14 are there. 8 of them will not be deliberating. There's Smiley Sarah. She is happy. And she should be. Her side has had some wins today and this week. I think the biggest win this week was that I think in the overall exchange of her testimony, I think she ended up better off having testified than not testifying, and that is extremely rare for a defendant. Judge is not going to strike the entire witness. He said that was draconian and extreme and frowned upon by Supreme Court rules in Florida. But he could strike portions, although he elected not to strike the portion that the state elicited, was objected to, was overruled, and then the state objected to, which, wrap your mind around that. Both sides objected to that comment, and the judge let it stand. Oh. One question I have is, why didn't she watch the testimonies? Well, what Mr. Owens, I think, is hinting at here is there was additional materials available that would have possibly shown that Sarah Boone met criteria for a specific diagnosis. And the limited exposure that this witness got with Sarah Boone, she said, based on that, there isn't enough criteria to make a diagnosis. So he's trying to point out that the information was there, it was provided, she had access to it, both legally and physically, but she chose not to look, and then made a finding. She made coming up to an expert opinion with what a reasonable degree of are they going to ask that question? Reasonable degree of medical certainty that this is the result, that this is what's there. She made that finding without looking at everything that was available, and so this is a good attack by Mr. Owens on this front, and he's going to get some mileage out of her admitting that yes, that BSS was a proper diagnosis. The jury is there right now. Jury is present for this one. That's why the mics are off and they're up at the bench. Jules O. In Minnesota, I believe. In my opinion, I don't think the previous lawyers would have fought this hard for her. I agree. Bird says the doc doesn't have to agree, even if she did look at everything. Professionals frequently disagree on diagnosis. Yes, but the tricky part is this professional is going to have to say, I looked at a narrow portion of what was available about Sarah Boone, and I made my finding based on that. And that finding was that there wasn't enough information. And that's going to be, that sort of is counterintuitive, because he's going to say, but you had more information you didn't look at. Are you sure that there wasn't something in, how do you know there wasn't something in that other information, that her testimony, that would have answered that question for you and filled in enough blanks that you could make a diagnosis? Michael says, Ari, you need to remember that was brought up yesterday. An expert for defense can meet unlimited times, but a state expert is only allowed to meet once with the defendant. We're not talking about meeting with the defendant additional times. We're talking about listening to her testimony, listening to the testimony of the expert who did meet with her 9 times, and looking at the additional evidence that was provided. Jenny, this is $1 million question. Should she have listened to the testimony? It depends what result you want. If you've already found the result you want and you don't want that to change, I would say no. Don't listen to any additional testimony. Base your opinion on what you've seen. Look back to the, well, it's a bad example, but look back to the Maya trial, where the hospital brought in a expert witness, and they gave him the narrowest sliver of information, and he made a finding based on that everything was fine at the hospital. It wasn't, but that's the result they wanted, and they limited the scope of his vision using the available information. They had more, but they didn't give it to him, so they wanted that result, and I think we're seeing that a little bit with this witness. They wanted a specific result and provided information that would lead to that end. Judge will get mad. I love that. I love that the judge is mindful of the jury. Owens wanted a lunch break. We're getting closer and closer to lunch. Probably next 15 minutes or so. Maybe half an hour. It depends how long.
Objection's overruled. You may proceed.
Thank you, Judge.
State's lost a couple.
Ma'am, is it fair to say, in your evaluation of Sarah Boone on October the 2nd of 2024, that you felt like the text messages that you received from the state attorney...
Objection beyond scope.
Overruled.
Are not relevant to your evaluation of Sarah Boone.
Withdraw.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the texts in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes, that's
And we discussed that these were the phone records from Sarah Boone's phone.
Yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it. If you just refer me to the page.
Just a moment.
May I have voir dire?
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any...
Let him finish. Let him finish.
Well, I'm going on. I'm going to ask another question about the text messages, Judge.
You just said line 5. Approach.
Judge is calling balls and strikes here. They are fighting over this witness. The voir dire motion, that came from the prosecution. So what we have right now, defense is asking questions in the cross-examination of the state's witness in the rebuttal case. The defense is asking questions about these text messages, and mid-text message, state asks, "Can I voir dire? Can I ask some questions about the witness?"
Refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone?
Permission to voir dire?
Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's talk. First, you said no.
As I said, it made me aware that they had a volatile relationship. It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence, was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not my complete answer.
At the same time, Dr. Warner, at the same time you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct.
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot, for overdrafting her account.
Correct.
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, we need to object. We need to approach.
Wow. The witness is... Okay, she's an expert. She's an expert. She knows this game. The proper time to say that wasn't my complete statement is when the state gets back up on redirect and says, now, he said your answer was no. Wasn't there more to that? Would you like to elaborate? That's where it should come in. And she's fighting instead with him, which makes her look a little bit stubborn and makes her look like she's unwilling to say what's actually on the page. That makes the jury think a little bit. Now, he's being quite aggressive with her, and that might backfire on Mr. Owens. But this is great. She's earning every penny right now. She's earning every penny of whatever she's charging. Heard something about relevance. Thank you, Bravo Chick, the swear jar fund. That was the idiot comment, right? The camera's been instructed not to show the conversation with the judge at the bench because people can read lips. That's why we'll see the witness, we'll see Sarah Boone, we'll zoom out, but generally we will not see their conversation back and forth. If the judge finds out people are reading his lips and hearing what's happening at the sidebar, he'd turn the camera off. The text message doesn't help Sarah. He's working on impeachment here. That's what he's going for. He's trying to impeach this witness and say she testified one way and then the other. So it's not necessarily. He may actually elicit testimony that looks bad for Sarah, but is worse for the witness's testimony because it impeaches her. Does that make sense? Now you're flipping your story. It's Owens and Sarah winning. That's a tough one. There have been some moments where Mr. Owens, I think, could have done much better today than he did. But overall, I think he's a little bit ahead. Right now, I'd say the prosecution is on their heels. Indicators of that would be the fact that they moved to strike their own witness's testimony, direct answer to the question they asked after the prosecution asks the question of the witness, defense objects. We have a huge fight over it. The judge, after the judge rules, the prosecution then says, I move to strike. I moved to strike it, and so it's in. He knows that this is coming out. It's going to hurt him. In this rebuttal or in this cross-examination of the witness, Mr. Owens is asking these questions that's getting to this part that will hurt the state, and the state is asking to voir dire their witness. Hey, can we make sure? I want to ask a question before they go that far. I think there's some legal grounds that we need to cover and establish that there is proper foundation for this. It's their own witness. Voir diring your own witness during cross is a desperate move to try to steer the conversation or steer her answer. Let's see. She needs to stop rolling her eyes. I think it's the grin, the forced grin that the jury is probably not smiling back at. People for Real says, this is starting to feel like O.J. Simpson, an obvious case that's now becoming cloudy. Is there a better way? I'm not aware of a better legal system than one we have. A trial by jury where the state has to prove the case. And I don't know. It's a smart move. I think it's smart. They're trying everything they can. They're breaking it up. They're making objections. The witness, I would say, is not flustered. She is an expert.
All right. Members of the jury, it is 11:55. At this point in time, we're going to go ahead and take our lunch break.
Owens wins.
I'm going to give you a similar instruction that I've given you throughout the last couple of days. give me a moment to pull it back up. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device.
He interrupts himself.
You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service.
Interesting. A longer break. Looks like we might be fighting something out outside the jury's presence. Because it's only 12 right now. That's an hour and a half. Looks like we might duke this out here for just a minute. So we might not have break right away. Love that. Bless you, though.
Y'all may be seated. State, anything else?
Nope.
No, Your Honor, thank you.
Defense?
No, sir.
All right, we'll see you at 1:30. Thank you very much. Court's in recess.
Judges needed a long break. This is a gift. This is a gift that falls right in Mr. Owen's lap because he wanted additional time to prepare the cross-examination of this witness, and now he gets it.
I think that's what happened there.
We're not going to take a lunch. I'm going to step off for a minute. We're going to keep the live feed from court continued all the way through the day. This is we're fine with that. I've thought this one through. We'll do a little bit of a recap as well. But my mind is reeling from the number of objections and spicy battles that happened back and forth this morning. And it is getting intense. It's getting really, really intense. This is some crucial moments, both for the state and for the defense. Realize the state has now the burden of proof to show that this was not self-defense on Sarah Boone's part. As soon as she reached that threshold where she could bring in that evidence and say, hey, this is what it was, she's raised that defense, the burden shifts back to the state to prove that it was not self-defense. And this is very, very important to them. It's obviously important to the defense as well. So they've brought in this. They've raised the issue of rebuttal, which I do not think the judge will allow. We've seen that in some cases. See, I can't think of the last one where we saw it a lot. Was it the tattoo guy, with the face tattoos, Wade Wilson? I can't remember. There was one where there was like ping pong back and forth, rebuttal, sir. Yeah, it was crazy. It was back and forth. Whoa. Camera just got kicked. It's all right. We've been righted. We're back up and righted and focused, so we're good to go. Let's see. I want a couple of your opinions. We've got some people calling in right now. Let's see who's first.
Call from Fractured 23.
Fractured 23. Thanks for calling. What are your thoughts on this morning so far?
There's just one thing I wanted to, I think I said it in chat a little while ago. I'm not sure if anyone saw it or not, but so when the defense put up that doctor, well, she wasn't a doctor, she was a psychologist yesterday. And this is a psychiatrist. And I'm not sure that everybody's really well aware of the difference between the two. Because and that's what they had her explain that in the beginning. And so as someone that's had extensive, I'm 44, not to age, or I just aged myself. It doesn't matter. But I'm 44 and I've been, well, I think I just told I don't know,
a couple thousand people. You're good.
Yeah. Almost 3,000 people. Hi, everybody. Hey. Anyways, but I've been seeing a psychiatrist for decades.
Yeah.
30 years. Okay. And so I've had multiple psychiatrists. And psychiatrists, when you meet them, they ask all of those open-ended questions and like let you just like, you know, they'll ask you about this event and you know, that event and, you know, whatever. That's what they do. They ask open-ended questions because they're psychiatrists. They're, you know, waiting for you to give them the information that they need. And if you give them, you know, a piece of information that could lead to a diagnosis, they will elaborate on that or like dig into that. Yeah. But if you don't touch anything, they're not gonna ask you, because a lot of people, I mean, especially nowadays, we research everything, right? You know, most people do anyways. And they're not gonna like, so psychiatrists, because, and especially like she's a forensic psychiatrist. Mm-hmm. So this is her job is, you know, she's not going to give her anything. She's waiting to see what she's going to say. And what she's saying is that Sarah.
Yeah. Sorry. Let me ask, we're talking about this expert witness, her evaluation of Sarah Boone. And there were areas that she did not address, or that Sarah did not show any, you know, report anything in that would be a required, you know, symptom aspect of having that, you know, PTSD or whatever it may be. And she didn't ask those. So her asking specific questions about what about, you know, intrusive thoughts would have possibly
but she doesn't want to plant that seed.
Right. Okay.
And that's like, but most of us, and I don't want to say that or say it like that. Generally speaking, people that have intrusive thoughts, when you're talking to a psychiatrist, you're going to bring that up because intrusive thoughts are scary. Yeah. You know, like those three things that she identified are things that, generally speaking, I don't want to say everybody, would bring up. Like, I have 5 diagnosed mental health disorders, and my psychiatrist, like, for me personally, my psychiatrist is the person that's going to help me. So I don't like, and I understand in her situation though, like, you know, this person is there to evaluate her, but giving that person all the information, even though it's ordered by the state, she could have helped herself by divulging information, and she chose not to. Like, you see what I'm saying?
I hear you. Let me ask this question. I honestly don't know the answer. Are there methods of questioning or ways that a psychiatrist could ask without, I mean, like, for instance, saying, tell me about your day. What's your go to sleep routine? You know, is there something that they could ask that would, if there was something intrusive, that would raise it without saying, do you have trouble sleeping? You know, does that make sense? Are there ways that they could get that information other than just like, is there anything else you want to tell me?
Yeah. I think that, like, you know, I mean, my psychiatrist, I mean, granted, I've had him for 5 years. He's an amazing man. He does like CBT and all of that stuff. He's got his hand in everything mental health. Phenomenal doctor. Anyways, but they'll just like, I'm not saying that you can ask everything, but in this situation, and especially when Sarah's trying to use like a battered spouse or any, like a self-defense, like, even if she hadn't gotten that idea of battered spouseship, but she had a self-defense, one would imagine, and I just read somewhere someone said that she wasn't forthcoming with information, but if you're trying to get someone to believe, like does that, like, am I making sense? Like, if I want you to believe that I have, and I see this is my mental health, like, I'm struggling to find words because right. I have horrible anxiety. So if you notice, like, my voice shakes, if you could see me, I'm physically shaking because
you're doing a great job.
I don't make phone calls. You're literally the only person that I actually call.
Fletcher, you're doing fantastic.
I don't call anybody else because you guys are amazing. But she should have been more. One would have thought she would have been more forthcoming, especially when you want the state's psychiatrist to believe these things. And maybe I'm just speaking.
I think if she had a copy of the DSM-5 TR in jail to reference, she would have done a better job on this interview as far as exhibiting the symptoms that would lead to this conclusion. I don't think she had the information knowing what to say to her to get the result she wanted.
Right, but see, and that's the thing, is that people that are generally speaking, people that are suffering with mental health, with PTSD, with battered spouse, these are all things I have. And for her not to exhibit anything, and like, if you watch the interviews, she doesn't exhibit anything at all. No emotions. Even when she was testifying, she's saying he was banging my head like this, but there was no emotion. I would have sobbed. Like, when I was in court for my domestic violence stuff, I was a disaster. Like, just a disaster. You're asking me to recount. I almost died. Like, I spent 2 months in a coma. Are you serious? They were like, well, we need you to try, like, the Crown was like, we need you to try not to, and no, I'm not saying that emotions equal guilt. No emotions what I'm saying is that she was stoic. Like, there was nothing at all.
Yeah, being asked to relive that sort of traumatic event should
she
have
didn't
had
shake.
something.
She didn't seem anxious at all. Like, maybe she's on really good head meds and I need to find out what those are. I don't know. But the other thing, I wanted so bad to call yesterday, but I was watching on replay. When Mrs. R.A. was on there, and I love her. I hope you got to tell her I love her. I know I've already told her, but anyways, I adore her. She's so great.
I do as well.
You guys are perfect. Man, when I grow up and I find a husband, I want to be just like you guys.
All right.
Anyhow,
well, just how we appear.
That I thought about,
how we appear. We've got plenty of our problems.
Right, but you guys know how to handle them. Like, you guys were in like full disagreement yesterday, but you couldn't really, unless you were paying attention,
I'll say this.
You wouldn't have known you guys were disagreeing.
I've learned a lot from Mrs. R.A., a ton, including how to handle disagreements. So she has helped me a whole ton. I definitely married up. Fractured, I love talking to you. I love that your Canadian accent leaks through as you talk. I find it beautiful. It's just when you say no and about and things like that. It's great.
Yeah, I'm Canadian. Eh?
You also said Crown, and that was a giveaway as well. But
oh yes. Yeah. Well, and then yesterday I wanted to comment on the whole, like, when she's like her control, like, she's controlled this whole court. Like, why is none of George's medical records, his DV, like, where he was the victim, why was none of that brought in there? She got them so that the jury can't know about her 8 different lawyers because that'll make her look bad. Well, I mean, but you've done it to yourself, little girl. I don't know what to tell you. Like, there's just so much that shows that she's the control freak. Like, she's and I am like,
yeah. I hear you. Some of that evidence, which seems like the jury should know, because of the rules of evidence, some can't come in, and it's like, but it's you don't see the whole picture without it. That's just the way the law works in some cases. If it's too prejudicial, more prejudicial than probative, there are things that just can't come in. But I hear you. I see all that. We see Sarah, her actions. It's not matching up with what she wants to tell the jury about what she was going through. It's hard to put those two together and see it the same. I don't doubt for a second that she was a victim of domestic violence, but her being,
I believe she was also a perpetrator, though.
Yeah, she was not the only.
And that's what's unfair to George. And like that video of him smashing the TV, he like. The way I took that video, or I think there was 2 different ones. One where he was saying, "You're going to help me take this out. You're going to help me take this out. You're going to help me take this out." And then the next video where he's smashing it, like, what's the context behind that?
Yeah, we could make some context.
Maybe if he wanted her to help him take the TV, and why was she only recording him in moments where he was like upset? Like, what about the happy moments? Like, I don't know. There's so many unanswered questions
about the context just for that video, just for somebody who can't imagine why it's so important. Yes, it does show him using the bat, violence against an object. We're like, wow, what a nutcase, right? Back up a little bit. There are two scenarios. One, right before that, he just threatened Sarah with the bat and said, hey, you need to film this. I'm going to destroy this property that, because Brian fixed it and he fixed the fire stick. And I hate having him over here talking to you because we're married and you shouldn't talk, or not, we're not married, but we're a couple and you shouldn't be talking to anybody else. And now I'm going to make you film me destroy your object. That could have been context number one. Or context number two could have been Sarah saying, look, the TV's broken. I think it'd be really funny if you hit it with a bat. I'll film it. It's going to be funny. And George is like, it's going to make a mess. And she's like, no. And then he says, look, you're going to help me take this out. You're going to help me take this out, right? You're helping me carry this out. Once I smash this all over the place. There's two different scenarios, and we don't know which. And it probably wasn't either of those. But the context is so important.
And MS Kim just said she stood there and filmed that. Oh, she was so scared. Exactly. Yeah. Exactly. Yeah. Like, if my abuser ever picked up an object, I was backing out of my house. Like, I'm fine but I'll climb out a window at my 250 pounds. I don't care.
It's straight to the flight mode, for sure.
Exactly. But she's there at TV multiple times, and she just stood there and reported it. But that's also instigating, right? Like, why are you recording me again? Like, what are you doing? And like, we saw that with in the Johnny Depp trial. She erased her name from my head.
Amber Heard. Amber.
She instigated Johnny all the time, doing stuff like that with the videos, like recording him all the time, and it would make him angry. And like, anyways, I've taken up more than enough of your time. I love you guys. Your chat, you guys are so amazing. So amazing.
You do an
I
amazing
love you
job. First of all, thanks for sharing. Thanks for sharing something that's very personal. It sounds like you were doing great. You did a fantastic job, both expressing yourself and answering questions and everything else. You're welcome to call anytime. Love it. Thank you so much.
Okay, thank you.
All right, we'll see you.
Appreciate you guys.
Bye.
Bye.
Mrs. R.A. is listening, and we've got another call here.
Call from Teddy Bear.
I missed the name. This is R.A. Who am I speaking with?
It's Teddy Bear.
Teddy Bear.
My real name's Claire.
Hey, Claire. How are you doing?
I'm doing pretty good. I heard fractious, and I'm like, yes, I totally agree, but I wanted to clarify something because I heard her say the Crown. Mm-hmm. And so I'm pretty sure she's in Canada.
She is.
And so psychiatrists are different in the United States because of insurance and because of cost. And so when you go, so I don't measure. I don't have 5 diagnoses. I only have 3.
It's not a
and
contest.
I love, but I've been seeing my psychiatrist for well over a decade, and I love her. But but most psychiatrists only see you in the U.S. will only see you for like 15 minutes, and they just prescribe medication, and then you go to either a psychologist or a therapist for actual therapy. Yeah, and it's all cost-based, right? Like a psychiatrist costs more than a psychologist. A psychologist costs more than a therapist. So there's a lot of different things. And so my psychiatrist, while she does a little bit of therapy, and I see her for an hour, she will mostly recommend, let's try this program. How about this therapist? This psychologist can teach you some good things. So it's just a little bit different in the United States because of insurance reasons.
Well, I love that you, here's my recommendation. You don't have to be like broken beyond repair to go get help. Okay. You don't have to be at the bottom of like, there's nowhere to go from here. That's anytime, the stigma around mental health is so terrible that I wish we could just banish it and allow people to say, hey, if you're feeling depressed today, talk to somebody. It might just be today. It might be a one-day thing. It might be something that's bigger that needs more treatment, but talk to somebody. Mental health is as important as physical health. And I love
Yes.
that you're willing to go and talk to somebody and get treatment. And you sound like you're doing great.
Oh,
So thank you.
Yeah, I am. I'm on disability for my mental illness, and that has like a ton of other stigma attached to it because it's just sort of like, you have these labels on you, and therefore you must be so broken and so gone. Like even my mom will call the police if I get into an argument with her. And it's sort of like, it's because I have a label. And so, yes, we definitely need a lot more work on the way people view mental illness.
Thank you very much. I appreciate it. Teddy Bear, thanks for the call. Good talking to you.
Awesome. Yes. Have a good day.
You too.
Bye.
See you. Bye. All right. My heart rate is still up, elevated from what we just watched in court today. The Sarah Boone case went to 1,000 really quick. Amber, I'm hearing that there's something you sent me that I didn't see.
Yeah, I sent you something that Mathis wanted you to look at. That's pretty epic. I just want to give actual, thoughts on the case.
Did you send it to the burner or the email?
No, it's in Messenger. DM.
Okay.
So while I understand the perspectives that have been given thus far on the phone, I also want people to consider this woman met and sat with Sarah Boone for 2 hours 22 days ago. The amount of trust that's usually required for people to really open up to anybody, whether it's psychiatrist, psychologist, doesn't matter, even just to their best friend. The amount of trust and comfort with somebody that has to exist for most people to disclose super intimate details about their life.
Yeah.
That's something to consider as well. She was forced into this meeting with this woman, and I'm not giving an opinion whether or not she's guilty or not. That's not why I'm calling. But consider what it would take you to talk to somebody about the most intimate details of your life. You've never met somebody. You're spent 2 hours with this person, and you're being forced to do it. Are you really going to be that open?
At that point, I probably wouldn't even share with them my childhood dog's name.
Well, and consider her experience with the. Can you hear me, Amber?
I can.
Okay.
Hi.
That means I plugged everything in right.
I know. It's always we're never sure. Consider her experience so far with authorities that right at the beginning, they, from the get-go, they're saying, you did it. It's your fault. She did do it. I don't know if it's her fault, but she did do it. And from the beginning, all authority figures are against her. Here's an authority figure that, if she's anything like she is on the stand here, is giving off vibes of being against her. And her biggest tell-all question is there anything else you want to share? I mean, I don't know. What?
Right.
What would you, about what?
And I see everybody saying that they would be open if they're innocent, and I understand that point. But when it comes to expressing,
it's not guilt or innocence,
anything
though.
related to DV, right? When it comes to expressing things of DV, most people are so afraid to talk about it because they don't want to be judged.
Yeah, they don't know what's wrong, right?
Right.
I am okay. I don't even want to get into my own personal stuff. I'm just saying.
Exhibit A. Exhibit A.
I'm just saying, from my own life experience, I would say you are less likely to share as a victim of domestic violence. You're going to keep it to yourself. And the idea of saying, well, it's because if you share, then it will be better for you. That's probably true. But you've kept so many things to yourself for so long, it becomes very difficult to even know what is normal, what is not normal. If somebody says, is there anything else you want to share? I would say no. And there have been times when I've read stuff, I'm like, wait a minute, are you telling me that's not normal behavior? I thought that was normal. That's my life experience. And you don't know what you don't know. You don't know what's weird. You don't know what's abnormal.
Could I share a weird analogy?
Is it about me?
No.
Go ahead.
My sister.
Well, only
my
if
sister.
Mrs. Dario was done talking.
I was done. Thanks.
I asked specific permission. My sister growing up, we didn't know anything was wrong with her eyes. Zero. And she played with everyone else, read, did everything else that we did, and there was no indication that she had any trouble with her vision until she, did some random eye test. I don't know what it was like at school or something, and they're like, you should probably see a professional.
Yeah.
And she went, and she needed very strong prescription glasses, and once she got her glasses, I remember vividly when she came back, and she was just looking at everything. And she's looking outside, looking up, and we're like, oh, there's nothing up there. And she said, I never knew there were wires between the poles.
Oh, man.
Like her normal,
yeah.
The telephone lines was an imaginary line.
Yeah. And can you imagine if the eye doctor is like, is there anything you want to tell me about these poles? And she'd be like, no, I mean, they're poles.
Yeah. Her experience, her normal is, nope, everything's normal other than that.
Yeah.
But she didn't know there were lines between the poles. So anyway. I'm not sure if that helped her.
So I want to make something incredibly clear because I see a lot of kickback in the chat. I'm not opining whether or not she's guilty or innocent. I'm not discussing that part of this. I'm strictly going off of the assumption that she should have disclosed everything to this woman that she just met, she's being forced to interview with, who only spent 2 hours with her and who is presumably against her. And after she's been treated the way she's been treated, whether she did it to herself or not, and you've got to kind of open your mind up a little bit to look at the bigger picture without your own bias coming into it.
And Brandon raised a good point here as well. She met with her 22 days ago, like 4 or 5 years after this. So yes, the symptoms could be much more muted. And now talking to her and seeing if she's living in constant fear, she might be for different reasons. Obviously, jail is not a place you want to be, but that is something that has to be taken into account as well.
Yeah, and I do think this is something that I've put a lot of thought into recently. Is that I am not comfortable saying that she's not guilty. It's uncomfortable for me. But you know what's more uncomfortable for me is saying I cannot accept that anybody might be not guilty or that anybody's self-defense might be a little bit ugly. I'm not okay with somebody doing something that is bad when I see that she's been abused, but because of how she responded to that abuse, and it just makes me uncomfortable because it's ugly, then I'm just going to walk away. I need to just get comfortable with being in that uncomfortable place and say, look, it is ugly. What she did is ugly. What am I hoping for? At what point would I say, oh yeah, poor little, what's her name, Sarah? Poor Sarah, I'm definitely on her side. She's definitely the victim here. I mean, wouldn't it be great if she was just this sweet little thing and everything was bad against her and she'd never done anything wrong in her life? Sure, that would be great. That would be innocent. That would be really easy to come to a conclusion. But this is life. This is real. She is not pretty. And at what point am I willing to say even the not pretty situations deserve respect?
By she is not pretty, you mean like the case, the facts around
the facts,
it. We're not talking about her looks.
No, yeah, I'm talking about what she did was stinking awful, and it makes me want to take a shower to be speaking in her defense because of what she did. But if I'm not willing to sit in that place and say abuse victims make bad choices, when am I going to stand up for an abuse victim and say, can you really defend yourself even to killing somebody to protect yourself in domestic violence? Do I believe that or do I not? I don't know. It's ugly in this case, really ugly. But what would the case need to be in order for me to be okay with that? Is that scenario even realistic? Is there ever going to be a domestic violence situation where the person is such a victim, they've never done anything wrong in their life, and then they have the strength to protect themselves even to that degree? Does that exist? And if this is what it looks like for a domestic violence victim to stand up for themselves, then that's what it looks like. Does it suck? Yeah, it does. I don't like it. But let's get honest. It was bad for her. It was bad for him. And at what point are we going to say domestic?
Completely toxic.
Yeah.
Yeah.
It's a tough one, and I do not envy the jury on this one.
Okay, and this
I
comment
have
really
two last points I want to make real quick, and then I'm going to hang up.
Okay.
Yes.
Crap. What were they? I
hate that.
So the defense witness yesterday, whether you believe her or not, whether you agree with her positioning or not, she had 9 different visits with Sarah Boone. 9. Not just 2 hours. That should also be considered. The second point I want to bring up is it really bothers me that this state witness has not listened to Sarah Boone's testimony or the defense's doctor's testimony
I think we're
before
going
coming to testify today.
We're going to get into that some more. That's basically where we left off the cross-examination with
That's
this
really
witness.
troublesome for me. And it's highly, highly unusual. I think that it's problematic, in my opinion.
It's more problematic because she's already said she didn't see enough to make a finding to reach that conclusion.
Yeah, I think she did not ask enough to reach that conclusion, and I don't know, just my opinion. One woman's seriously unpopular opinion in the chat right now.
Do you want to switch me chairs?
You want me to chain you? What?
Not chain me to a chair. I said, do you want to switch me chairs?
No.
Nobody's seen you.
Correct. While you guys are playing musical chairs, yes, the chat is correct. It was 9 visits over the 4 years' time, not just 22 days ago.
Yeah. It's gonna be interesting. I think Mr. Owens is headed down a path that Jay knows where he's going. Jay doesn't like it. I think it will help Mr. Owens and it will help Sarah.
Yeah, I really struggle with this because honestly, I look at her and I'm like, oh, she is so guilty. Obviously, she admitted that she was guilty, but my life experience is that it is just about impossible to get a hearing as a domestic violence victim. It's so hard. Juries don't want to hear it. And I didn't believe that until I talked to some people and I was like, listen, we've got to get somebody in my life. And I was like, we need to get some help here. And they said, you'll never win. You'll never win in court. And I said, what? She's clearly the victim here. Here's the evidence. And they said, it doesn't matter. Juries don't want to hear it. And that broke my heart and it made me angry and is definitely affecting me here today that I'm looking at this. And even though my head says, whoa, guilty, my life experience says, stop, listen, this is uncomfortable. Did you really think that the prosecution is going to make her look awesome? And I get it, guys. She made herself look bad. But I'm just saying, even if she was innocent as the driven snow, the prosecution is going to make her look as bad as they possibly can. That's their job. And the fact that that's coming up, does that make her bad? My gut says, yeah, did you see the video? But just be in that uncomfortable place and say, hey, juries don't like victims. Why? Am I a part of that group? Why? What is that inside of me that doesn't like this situation? Well, probably because it's grim. it's ugly.
Did we mention that Mrs. Ari has a YouTube channel? And I don't do anything like this. I've encouraged her to talk about this on YouTube. It's based on homeschool.
Yeah,
homeschool Ground Zero.
It's nothing about this. I don't know. I said this before, but it is what I just keep coming back to. What would it look like for a domestic violence victim to be able to truly protect themselves, defend themselves? All of my experience says they've got to run. That's the only thing they can do is run. And what would it look like if they actually stood up to their abuser? Is this what it looks like?
You have to come over and say hi.
Hi.
Everyone thinks you're just like a computer voice that I've programmed to talk in my headset.
Okay, I can't, guys. This is it. This is the full extent. Yes, he was abused as well. Guys, I know. All of this is true. He was abused. She was abusive. It's ugly. It's messy. I would love to be able to wash my hands of it and say, whew, definitely her fault. But if I do that, for me personally, this is just me, I'm being a coward. I'm not willing to sit in this uncomfortable place and say, let me see it from her side. Her ugly, uncomfortable, awful side. Let me see it and make sure before I'm willing to throw down a judgment call on this, because what would it look like for a DV victim to actually win?
And I differ with you on this one.
Okay.
I also we watched the video. We heard George sitting in a comfortable place, and heard her recounting that story. And for me, it doesn't add up.
Okay, and that's valid. That there's me saying, hey, I'm basically saying, what if this was my friend's turn in court? Wouldn't I want everybody to give her the benefit of the doubt, no matter what mud is slung at her from the prosecution? But it isn't my friend. This is a way worse situation. There are other things. So I'm trying to hold my own feet to the fire at the same time, saying I do feel like there's going to be a moment when I can release that and say, now that I've really been super honest and given her a fair shot, I'm going to take all of those other things into consideration that are really not pretty.
I think it's important that we approach every case with that open-mindedness. But I'm comfortable right now with where I stand, looking at Sarah Boone and saying I believe she's guilty.
So how come though? Like with the DV, how come she is guilty? Like logically, walk it through. She killed him. She has admitted this much. That has happened. Okay. So now we say we accept she is a victim of domestic violence. We accept that she has killed him. What's that connection point where we're like, and she's guilty even though she was a victim of domestic violence? How come?
As Mathis pointed out this morning, we have imperfect laws. We have imperfect laws, and our laws are imperfect, especially when it comes to this area. But we have it's the best we have. We have to use the best we have. In this case, I don't think there was a threat that existed. I say that because of the way she describes it, the way she tells the story about what happened the entire day, the way she bought the alcohol, the lies she's told about this. I don't think the threat existed to her, and with her coming up with literally once court began, coming up with the story that that overt act was him putting his hand out of the suitcase. Okay, literally fighting for air and his hand coming out of the suitcase, the one place air can come in to try to make the hole a little bit bigger. That to me is not, oh crap, he's going to beat me.
Okay. I can see that.
Real quick, I'm going to get off the phone because everybody's hearing my toddler and it's like lunchtime, so he's getting really loud.
Food, Amber.
Sinbad 333 had asked a super important question that I thought maybe, Scott, you could kind of expand on. The question was, why is the doctor able to listen to testify if the rule of sequestration is in effect?
That is a great question. I will answer that. Thank you, Amber. You make some food for your toddler. Thanks. The reason why an expert can listen into testimony and be in court even and not be sequestered is because they are an expert. They are called on to give their opinions about other people's testimony. That is one of the things they can be asked about. In this case, she didn't listen to Sarah Boone, which is a little weird because that's one of the areas where she specifically and only an expert can give that.
Call from Bree.
Can give that. Bree, how are you doing?
I'll let you finish. Keep your thought going.
Thank you, Bree.
You're welcome.
That was all I had. Go ahead.
Okay.
I'll finish right there. Bree, what's on your mind?
Mrs. R.A., I'm calling in because I'm probably going to be the one with you that I'm here with you on this.
This is the one time we agree, is that what you said?
Thing, all right. No, I agree with you. I'm just saying you said everybody else in chat isn't agreeing with you. I agree with you on this.
Okay.
All right, here's my thought. We don't know where her brain was in that moment. He crawled into the suitcase. She zipped up. They may have been playing. It may have started at that. We don't know what he yelled before the video. We don't know if it sent her into a place. We weren't in her head. We don't know what she was thinking because of all the stuff that happened before. Us, out of that place in a right state of mind, not being physically abused, coulda, woulda, shoulda. Could have left the house. Should have left the house.
Right.
Could have left him zipped up and left the house and called 911 so he didn't die. But we're thinking in a reasonable state of mind after the fact. We are looking at this as people who didn't experience what she's been through. I'm not saying that I agree that she should get off. I'm not saying that at all. I'm not saying, there's a lot of stuff in this. The one thing I would like to know and stuff like that is, they talked about how George had been married a couple other times and she had been married. Were there on other sides of other relationships, were there episodes of domestic violence that had happened? Meaning, did George abuse his other wives? Did Sarah abuse her ex-husband? Because my thing is, they're saying, well, she abused him. Did she abuse him? And I'm asking this question. I'm not putting it out there, but I'm asking, did she do that retaliation because he was hurting her? We don't know that. We don't know where her mind is. We're thinking we can evaluate it here afterwards. All I'm saying is I agree with you, Ms. Zar. We have to look at this as we have to look at the ugly side of what DV can do to anybody. And we don't know that. We don't know where her brain was. Maybe it was that moment she's like, oh my God, I've got him trapped and he can't get me. I'm going to tell him everything I feel right now because this is what he's done to me. We don't know.
Yeah.
And we don't know her brain was. And I'm not saying she was justified in leaving him in there and she was justified for hitting him with a bat. But we don't know with him saying he was going to effing end her what that did to her mind. And we don't know, and I don't think we ever will know. And, first time... Yeah, go ahead.
Can I fight the other side a little bit? We also don't know...
1 minute against 2 women, bring it!
We also don't know that he said he was going to effing end her.
Yeah, that's true.
We have
100%.
Sarah saying that.
100%.
So we have
agree.
Her believability factor coming into play for all of this, because so much of the scenario that we've been told is only coming from her.
Yeah.
100%. But you also have pictures, and don't get me wrong, he had a black eye and he's had bruises, but we don't have pictures of him getting stabbed, and we don't have pictures of if you look at some of the police reports and stuff from the hospital, what you're seeing, and I'm not saying it's right or wrong, because it could have been times that he just didn't go to the hospital. But if you're looking at face value, it's there with actual pictures and things, it looks like it was a little bit more aggressive on one side than the other. And again, we don't have all that proof.
Yeah. So, Bree, I'm going to say this with you here because we are in the minority. One of the thought experiments that I typically do in these scenarios is that I will switch one of the key components to see if I have some sort of bias that's affecting me. Scott's warning me.
Careful. We had this conversation.
I know.
Yesterday.
I'm going to leave out that part.
Right.
But what I would switch...
and with that, we have to take a break.
No, I'm going to leave that part out. But what I would switch in this scenario is, what if George was the one with the baseball bat and she was the one in the suitcase?
Yeah, switch the actors around.
We know that they're both abusing each other. We know, we have the video. If everything stayed the same except the actors changed, positions, then do I find George guilty?
Yeah, here's my thing, and I agree with you. And in my brain, I see that because they're trapped in a thing. I think the bat is where it takes a different tone. But again, with him, it would just kind of depend on. I don't know. It's so hard to go there with that. Because
it is so hard because he's a guy.
And it's hypothetical.
And men have more power.
He's also little. I'm just kidding.
Exactly. No, but that's real. That is real. They are the same size. And even though I do think he's probably stronger, they are still the same size. And so really it is justifiable to switch positions. Yeah. And if I do switch those positions, I'm not a chance in... Not a snowball's chance, right? No.
Here's my other thing with this. And this whole thing is what gets me, okay? He got in the suitcase. Look, he obviously got in. It's zipped. He's obviously strong enough, too. If they really thought this wasn't a game to start with, why did he let her zip him up? He could have fought it. He could have
if we believe Sarah's version of events, she could have hit him with the bat first and put him in unconscious.
Oh, I don't think so. That would be
there so been blood.
And then rolled it down the stairs.
There would have been more blood, though. There would have been more blood if she hit him with the bat.
He wasn't bleeding. He had. We didn't see the picture.
That's my point.
We had a big contusion over the left eye, a big old goose egg.
I'm just saying there would have been some, if you hit somebody with a baseball bat, there's going to be some blood somewhere. I don't know. Like, I'm just saying, like, I just feel, and if she did hit him and knocked him unconscious and he fell down the stairs, he still would have been a little too heavy for a girl that's that hammered to throw into a soup. That's just my brain thought.
Yeah.
I could be 100% wrong.
My brain
but
thinks
I'm just
so too.
like,
I think he got in voluntarily. I don't know that really matters one way or the other.
I don't. But my thought process is, I think about that though is this. I think part of it really, if this story is true, that he got in voluntarily and they zipped it up, like somebody said, they thought it was a game. He obviously didn't even think it was something that was going to be detrimental to his life. I don't think she did.
Right.
And so I guess my thing is, if you believe that thought process, and then you go to the point of, if he said something that triggered a DV moment in her brain, she may have not thought that this is something that could take him out. I'm getting out of here, and whatever. Like, she just went upstairs and passed out. Like, she didn't think this was a serious. She got away from it. She went upstairs like she always does, and she probably, let's be honest, passed out. She didn't fall asleep. She
would have had to. Okay, because that's the problem that's so hard for me. Well, so many problems with this, right? But that she is in this place of panic and then she goes to sleep. Like, no. No.
She passed out. They did, listen, 100% for, I've worked in bar industry my whole life, right? The wine drunk is a different drinking adventure. Go and have a couple beers. When you have wine, you just end up passing out over that. You know what I mean? You just kind of, you do. So I think she passed out, and I think that's why she slept all day, and that's why it took forever her to wake up.
That was hangover if I've ever seen one.
Yes.
100%.
And she really softened that part of the story.
Yeah, get me my Dr. Pepper.
100%.
I need my Dr. Pepper. That was hangover.
Yeah, exactly.
Bree, what I love about this is that we can look at this conversation and have these discussions and do it in a respectful way and not necessarily agree with each other.
Exactly.
But thank you for bringing that.
I appreciate you calling. I do feel very much in the minority. I feel like I'm having to stand here with my feet fully braced and say, no, I'm not getting pushed.
And can I say the one other thing that's really upset me about this case in general, and it even ties back to Karen Reed. I saw all over the internet, the other day after they did her, after she testified, people were like, "I'm so disappointed with this case. That attorney just didn't do anything." This is a woman's life. This is her having to testify whether or not she should be put in jail for a set amount of time. And people are on the internet pretending this is like a TV show, and they're mad it didn't give them the fireworks or the spark that they wanted. I understand that we watch this for a reason.
It's like watching NASCAR and not having any wrecks, right?
Exactly.
So thoughtless of those
drivers. The left turn, they took the right turn. But I mean, I was almost really disappointed in people. I'm like, look, there isn't anything he needed to do. She recounted some of the worst moments that she's had. She's admitted she drinks. She's admitted she's done this. There was nothing he's going to do with a gotcha moment to come out and get her. He did what he needed to prove. And for people to be like, oh my gosh, this just wasn't the case I thought it was going to be. I was almost offended to the point that I didn't want to watch, but I'm so invested in this trial and seeing what happens that I'm like, I have
turn it
to.
off.
I mean, I just want to see like what's the attorney's going to do, because I mean, I really see the DV side, but I also see that she probably went a little too far. But I'm just saying, as a person who watches true crimes and invests in this, for people to say it didn't give us what we wanted. It gave us exactly what we need.
Yeah, it's just real life we happen to be watching.
What I want in this case is justice, and it might end up at the end of the day that it's justice for Sarah Boone, and it might be justice for George. But justice is what we want at the end of the day in this case. So, Bree, thank you very much. Always love talking to you. You bring a lot of excitement on the phone. Appreciate you.
Never, not at all.
Thanks a lot. We'll catch you later.
Bye, guys. Bye, chat. Have a good day, everybody.
All of your viewers are listening. Sorry you all disagree with me. It's okay.
It's awesome. Hey, here's what we're going to do. I'm going to leave the phone off for a minute. This is our lunch break. It's starting at 1:30. We have 45 minutes. That'll give me time to get a little bit to eat. Somebody's calling in right now. Do you want to take one more?
So when you say turn the phone off, what do you mean?
I'm an addict.
Call from
Marcia.
Is it Marcia?
It is. How are you, Mr. R.A.?
I'm doing great. We've just got a minute here before I have to run and get some food. Otherwise, I'll die of starvation.
Okay, so I'll be as fast as possible. By the way, I'm calling from Portugal.
Welcome.
So here we go. Thank you. So this is the thing. When you are in a domestic abusive relationship, you got to walk on eggshells. If you've ever been in one, you know what I mean. She had to plan and postpone the drinking as much as she could till the end of the day, get him involved in other things so that he wouldn't drink as early. So that part I understand. Second part, she did not know that he was going to die in that suitcase. I mean, so I don't even think that I would be feeling myself guilty if I thought, no, he has enough space to get out. So whenever he wants to get out, he'll get out. So, and
I agree that she might not have known that he was going to die, but that's why we're charging her with second degree instead of first.
And also, Mrs. Ira, I agree with you. When it comes to violence, we don't want to hear from the victim because we always have that in mind. Oh, she could have left. She put up with it. She was there because she wanted to.
Which is actually victim blaming.
It is victim blaming, and that's horrible from our society in general to still to this day think like that with all the true crime that we watch, right? I mean, we see it all the time that the victim most likely doesn't even have strength to leave, doesn't even have a voice to ask for help. But yet, here we are as a society still victim blaming. What if it was the other way around? What if it was him doing it to her? Okay, what if she died in that suitcase, and now he says, no, she was in it because she put herself in it. She wanted to hide in the suitcase. It's her fault. You know, so I when I started watching this trial, and believe me, I know what domestic violence is because I watched my mom being beaten every single day and how she used to treat my dad like a king inside the house and watch every single word she would say to him because anything would trigger the bastard. I'm sorry about the word. But anyway, so you have to put yourself in her shoes. She tried everything she could to not let him drink as early as possible because she knew what he was like when he was drinking.
But what about
she
her?
was scared of letting him out of that case.
What about her buying
knew.
him the wine?
That's not hard for me. Victims of... Okay, I want to clarify here.
If she didn't buy him the wine, he would do it. So what was the difference? If she did not buy him the wine, he would have done it, and he would have been pissed with her because she didn't buy him the wine, Mr. R.A. That's how it works with domestic violence. He would still be pissed at her for not buying the wine.
I agree. I'm telling you, domestic violence is real, and what you're describing is absolutely 100% correct. I'm not convinced it's the case with Sarah Boone because the other things that are present so often in these cases aren't.
It's like
she had
way things.
Yes, so much control over him. So much control.
Okay, now I'm going to push back on that a little bit. And I need to clarify here because I feel like I'm getting stuck in a place where I'm the Sarah Boone defender. And I'm not, I have not decided that she's not guilty. I have not decided. I'm just keeping my mind open right now. But I do want to push back on that. And then I just forgot what I was pushing back on. Dang it! What did you say?
Welcome to my world.
I forgot. I was reading the comments.
I'm with you. She's not totally innocent. She's not a child that didn't know that a gun would shoot and kill somebody. No. The relationship was toxic on both sides. Yeah. She knew what he was like when he was drunk. Yeah. But I don't see her 100% guilty on everything. There's no way I can go through that. because I know what my mom went through. I know what an abusive relationship is. I've seen it. I know what it's like. And the fact that you have to walk on eggshells and watch every move and every single thing you say to not trigger the other person is absolutely terrifying. And
Marcia,
I know what it's
Marcia,
like.
thank you for sharing. First of all, thank you for sharing. I know that's painful. That is terrible, what you went through, what your mom went through. I appreciate you sharing that, and thanks for giving that perspective. I don't want you to have a huge phone bill from Portugal. So
right, I'm going to let
Mrs. R.A. answer the question about control. I just want to say thanks for the call.
I love you guys.
Thank you.
Keep up the great work, man.
Thank you.
Thank you. Bye.
Bye-bye.
I don't really have an answer about the thing of control. It's more like I have a question about it, that people who are the victim. Okay, here's my take. If you're being just the victim in a domestic violence situation, you will be incapable of fighting back. Your best hope is to run. That's it. But if you are more like Sarah Boone and you are being abused, but then you're also abusing, then you do have the option of fighting back. It may not end well. It didn't end well here. So my question is, in this new dynamic, this place where everybody's abusing everybody, is it weird that she has the phone? Because it would be weird if she was the victim where she has no power. But she's also an abuser. And is it weird that she has the powerful statements in her sentences that she says, I chose this, I did this, I decided to do this, I was in control? Is that weird, or is that just a natural part of this, what do they call it, a dyad, where they're both sort of equally terrible? I don't know. And if I accept that they're equally terrible, do I then say, all right, it's like we're starting out at ground zero, and now whoever ended up with the final killing blow has to go to jail, and the other person is in the grave?
It's like a hockey fight. The person who falls down loses and has to sit in timeout.
Right. Yeah, and that seems wrong too. So it is a weird dynamic that she is showing that she has this power in this scenario, and yet her saying, hey, I feel powerful, I do these things, is sometimes like your sister saying, yeah, I see light poles, I don't necessarily see the wires. It's normal. She verbalizes it as powerful, and yet if we were to experience it, we'd be like, that's not power. You're actually acting in fear. You're actually acting in all the time trying to protect yourself. So you say, hey, I chose to do this, but really what you were doing was just trying to mitigate the danger of that situation. True or false, I don't know. It's a different situation than I'm familiar with.
Yeah.
But I like I say, I have not decided, but I'm just trying to keep my mind open to the point where I can see. I feel like it's unfair to Sarah because so much of this information came out before the trial, and I'm on one side fighting to make sure that I hear all sides.
I want to say this. I want to thank Mrs. R.A. for sharing her opinion, as wrong as it might be. Just kidding.
Sorry, what was for lunch? It stopped being
apparently.
Soup. Now it's nuts.
Okay. I want to thank Mrs. R.A. Thanks everyone who calls. I realize we're only representing just a small fraction of the people who are looking at this trial and seeing it and from different perspectives. Thank you very much. I realize there are a million more perspectives that haven't been shared, and I realize, and I see many of them have been shared in chat. Thank you for doing that. I think this discussion is important, but at the end of the day, the jury's going to have to vote.
Yeah.
That may be as soon as tomorrow that this jury votes and brings back a verdict if they can all agree.
And I do think their experience is wildly different from ours because they keep getting sent out of the room, and they hear just the little snippets at the end of it where it's like sustained or denied, and you're like, I don't really, what's going on? I am confused.
Yep. We are going to leave the live stream up with the court as you see it right here. I'm going to be stepping away just from the desk just so I can go. Apparently I have to make myself lunch now.
No, we're actually having soup for real. We made
Real
chocolate
soup.
Chocolate
Yum.
noodle. Chicken
Yum.
noodle
Oh,
soup
chicken noodle.
last night. And
That's not as good as chocolate soup.
That's probably true.
Yeah, but all right, we'll be back. We'll be back here in just a little minute. We have the audio from court. We're not going to miss a second. As soon as this comes back, we'll continue with live coverage from Courtroom. Once again, a big shout out and a thank you to Aaron and Chris from Trial TV Live, who are partnering with us. Chris is down at the courthouse, running the tech outside the courthouse, bringing us the feed through LiveView, the miracle of technology. It's wonderful. So that's just what we try to do here to bring you the best video and audio that we possibly can. So we'll see you after the break. I'm going to do the outro, even though I'm not going to end the video, because I don't know how else to get up and walk away without feeling awkward. So we'll play the music and then go eat the soup. Thank you all. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe until we come back right after lunch. This live stream will continue. You don't have to go anywhere. Feel free to share it with your friends. Bring somebody that might be interested in what's happening here, because I don't think the courtroom drama is over just yet. Just know we also are keeping our eye on the happenings in this trial right here in the state of Georgia. We're recording that as it happens as well. We expect to be mentioned, like by we, I mean I expect to be mentioned in court today because of some crazy happenings that happened. We were following that case before Sarah Boone started, and as a witness was on the stand, and I made a comment, and I said, I think that's where the gun was from, the missing gun. The owner of that gun was watching our live stream, and she knew the gun was missing. And my comment saying it was Martha Jane's gun, that's where Melody got it. My comment made Martha Jane make a phone call to the detective, and she's going to be on the stand later today. We're going to catch up with that after the Sarah Boone trial. It's never a dull moment here. So you guys have a great lunch break. We will see you here on the flip side. And if you want to see that video on our live stream, a couple days ago it said something about, I think it's called "Did I Crack the Case?" ? Yeah, that's where you can get the information. Other than that, no spoilers on the Georgia v. Ferris case, please. We are going to catch up that together. Guys, enjoy lunch. We'll see you. Court resumes in half an hour, 30 minutes.
If they didn't, I would lose my mind.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the night search on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Because he's the guy. What more do you need to see?
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. I'm sorry, I need to find like a countdown warning before I just blast the volume here. We are back. We are about to be back in court. Let's jump there now. We are waiting for the second half of the Sarah Boone trial. Not sure why that isn't working, but let's see. I've got to figure it out. Bless you, counter. There we go. All right. Welcome back. Mathis says, if you have time to read the case law, the paragraph starting with the trial court attempted to cure any prejudice. I read it, Mathis. Thank you, by the way, for sending the link through Amber. Let's see if I can pull it back up here. Did I lose it? Basically, the case law that Mathis sent me, which we won't go into a ton detail, but let me summarize it if I could. It goes like this. They had an instance where a similar occurrence happened that we had today. Today, where an opinion was shared that had not been shared previously, expert opinion, and the court made a similar ruling to what they did this morning, where they allowed
video of roaches fighting. I don't know who won.
Don't know who won. Allowed the defense to do a little like in court, deposition as a remedy. And this case law out of Florida says that was not enough. That was not enough of a remedy. So there's case law that what the judge did to fix the problem didn't fix the problem. We're not sure if the defense is going to pursue that any further. I don't think they made any motions. It might be moot at this point because of that. But mid-trial deposition, check. We got that. So thank you for the case law on that one. Not enough to remedy the situation was the case law.
I saw a chicken.
I saw a chicken fighting. Let's see. We're going to turn the sounds down just a little bit. We expect the court to come back any second now. So the remedy is draconian should be the soundbite. What was the other? Oh, there was something. There was a couple things that were really, really funny. But there were some good sound bites out of this morning. Let's see. Are they listening to? I want to do something. I went to the P.O. box. I did. Stop before I do anything else. It's not Mountain Dew. It's Iron Brew, which is I believe it's Scotland's version of Mountain Dew. I think it's like a cross between Mountain Dew and Red Bull. Have not had one of these. Going to read the label very carefully before I do it. So thank you for the Iron Brew. Also got a little Christmas decorations. Never too early for Christmas decorations. So got some candy canes. They're green. You can't see them. They're pickle flavored. Pickle flavor candy canes. Thank you for those. That's one the kids hopefully will steal and think that it's candy and eat it. And also, thank you. I think this is Baby Bear we owe the thanks to on this one. Cowboy candy, 2 jars of candied jalapeno peppers. I know they're good because I've already had one. So thank you. It's delicious. Thank you. And a couple letters from the IRS. Thank you, IRS. I appreciate that as well. No, actually I don't, but I guess I have to address that. Let's see. Haley's fund went to $29,000. That's awesome. It's good to know. I've got the phone turned off for right now. Got the phone turned off. Glad the Iron Brew arrived out selling Coke in Scotland since 1901, says Sloth Life. Thank you, Sloth Life. It definitely did arrive in good shape. Possibly shaken. Probably shaken a great deal is my estimation. Yes, pickle flavor candy canes. I think I've had just about every pickle flavored type treat there is. Don't mention my name to the IRS. I wouldn't dream of it. Did have soup for lunch, by the way. No nuts, just soup. Mrs. R.A. makes a homemade chicken noodle soup, which is delicious. She made it last night in the crock pot, and I had the leftovers reheated today, and it was just as good. Add a little bit of the flat iron pepper flakes. Oh, so good. It was delicious. Yeah. I have to say, I like pickles a lot more than I like pickle-flavored things. Pickles are great. Big fan. Dill or otherwise. I like most types of pickles, but pickle-flavored things have generally let me down. Sorry, needs a cookbook. She gets, I posted actually, if you go on, I think it was yesterday's video. I was up last night, and I did post the URL for the recipe she made the night before that I was bragging about. That was so amazing. It wasn't her own recipe. She finds it somewhere else. But I posted that as a reply to one of the comments, so you'll have to dig for it. It's in there somewhere. Do you guys have Space Raider crisps in the U.S., pickled onion? No. Haven't tried those. Scott, stop. Pepper flakes are not within my reach. Lego, I apologize. I'm sorry for mentioning the world's most fantastic flavored pepper flakes. The seasoning that makes all dishes just perfect. I will not mention how good they are on just about any meal. How tasty they are. How the flavor profile is just perfect. How you can get it in any variety of heat. Even with a smoky flavor, I won't mention that at all. I'll leave that off completely. All right. I won't mention it. I'll just post a link for those who are curious. How about that? Give me just a second. I'll pull it up. They're so good. Oh, they're so good. Why is my Amazon acting funny? Apparently I'm watching the Vikings versus Rams now. I did actually put some of these pepper flakes on my my lunch. It was fantastic. Love supporting a small business as well. All right, hang on. I'll get you the link here. Okay, my phone's going nuts, and the judge is going to come in, and I'm going to have to. Let me answer this one call. It'll be brief.
Call from Angela.
Angela, you're rather persistent. How are you doing?
I'm doing good. I'm persistent. The only reason for that is because I have like a minute or two. I'm on a tighter schedule than the court. I have just one thing to say. Do you know where no matter how many times I learn this lesson, I do it again and again and again. So I somehow managed to be at the worst place you could possibly be when something happens. I was on the street when this happened this morning, like in the public. First I was on the bus, and then I was out on the street. I wish I was somewhere where I can be on somewhere that I can express how I feel, because that was wild.
It was a wild morning.
Also, also, if I need to go now, so that was the only thing to say. I need to go. I'll catch up probably the rest on the with the rewatch crew.
Thanks, Angela. Appreciate it.
I have to go.
All right. Thank you.
Yeah, bye-bye.
All the way from Sweden, Angela calling in saying she was out in public watching what happened in court this morning, and she just wanted to yell. So thank you, Angela. All right. I posted the link right there. Best pepper flakes ever. Absolutely. I love them. That is an Amazon link. It's an affiliate link. If you buy them, if you click on that and buy something from Amazon, Amazon may reward me a couple cents for that. Just to give you an idea, I'm not getting rich off this. We've had a lot of people use Amazon affiliate links that we've shared this past month to buy things. And Amazon is going to give me $32 next month as a thank you. So I appreciate that, though. It all adds up, and it does help support the channel. All right. And they'll change your life. They're just that good. Do you think the state has blown it? No. Shadow, I don't. And I think they've got very much a chance. Judge comes in carrying a laptop. He's flanked by two law students now. And here we go.
We are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Steve Castro on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Are we prepared to bring back in our jury at this time, state?
Yes, Your Honor.
Defense.
No, sir.
Yes, sir.
I want to make another motion. Judge, I've had a chance to read this transcript, and I'd like to draw your attention to a few pages.
Which transcript are we referring to, sir?
The October 4th, 2024 deposition of Dr. Tanya Werner.
Okay. Yes, sir. I have it in front of me.
May I sit?
Yes, sir.
I'm referring to page 38 at the very bottom, line 21. Answer, I need to go through my notes and think about it and process it. But I had other depositions, as you were aware, yesterday, so I had to prepare for those and go through that. So I had not had time to process through all of my notes prior to this deposition today. Page 39. Line 2, well, doctor, I'm not trying to inconvenience you. You know, the judge set for October 7th for jury selection. Line 5, she answered, okay. Question at 6, but I don't anticipate your testimony would be until later, you know. Maybe we could discontinue your deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and then you have other opinions that are not going to be covered. Then at 13, Mr. J says, what is your position? Then at 14, Mr. J, conducting discovery after the jury trial starts is completely unacceptable to me, so that's my position. If she needs to issue a supplemental report, or if there becomes a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once the jury is sworn and jeopardy attaches. Line 23, Mr. Owens, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. The witness on line 4, page 40. But if that happens, I can bring that forward, and then you can add to your deposition at that point. If my opinions change after having reviewed further. Line 8, Mr. Owens. Mr. J? Line 9, Mr. J, I think you need to plow ahead. This is our time with her. The court reporter is prepared to give us a transcript by the end of the weekend, and if something needs to be amended, then she can A, issue a report, And then B, if you need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Line 23, page 40. Mr. Owens, I'm not suggesting that, Mr. J. I'm suggesting that we just said at the very beginning. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnoses or opinions. Then Mr. J goes, I think he gets confused about an issue relating to a diagnosis of an adjustment disorder or anxiety disorder. So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest we go on. And then page 42, line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot and formulate any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely. That was our understanding. I've been ambushed by a new opinion that I was not made aware of by any kind of report. I was not notified by Dr. Werner. I was not notified by the state attorney, William J.
She said it wasn't a new
opinion. I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I moved for a total dismissal for prosecutorial misconduct.
Denied.
Whoa!
And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to, starts at page 21, line 21. The question preceding that is important. Question 14. So, from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues. Anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
But Judge, we go on, and I see what she's doing. That she's saying, hey, I got jammed up, I had a deposition yesterday, I didn't really have time between the evaluation and the deposition 2 days later. She had a deposition in between to really think about it, really review my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So yes, that was initially what she was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So
That's respectfully, sir, that's not what it says. That's specifically in line with the anxiety disorder versus adjustment disorder. That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously. Give me a moment. On page 59, line 22, question is asked, okay, and do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm, moving to page 60, line 1, asked. Page 60, line 11. Well, let me just start with 2 because it gives it more context. Question. Well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes some more to see if But in terms of right now, without any further reflection, without any further answer, yes, sir, question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert, anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. Anything else that I'm asked with regard to her diagnosis come into play with regard to her case, I guess? Question. What other opinions do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess. 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things were mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder, which are in the pages 58 and 59. But the overall thrust of that was any other opinions that were expressed. That was in good faith what we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my analysis and I may need additional information, just like he said the other day, Dr. Harper, if you get those additional medical records, Mr. Owens, about George Torres and give them to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished her
Because the court ordered you to take her deposition because there were concerns about being able to have all of this done prior to trial. And you had concerns about what she was going to testify to. And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
That prosecutor should have let me know. If he was going to ambush me at trial, I should have known beforehand about a new opinion that Dr. Warner was going to express, especially related to battered spouse, post-traumatic stress, and whether or not there was an imminent threat at the time of this event.
And the court's addressed that. Court did exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing. Analyzed the 3 factors as required by Florida law with regard to those and gave you the opportunity as a cure. And with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Denninghoff, and I can provide you a citation momentarily, states that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result. Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanction should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request, an inquiry of whether or not you wanted that struck, and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination, and I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she had, based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you. Is there anything else, sir, we need to address?
May I supplement the record?
Yes, sir.
Judge, this deposition did not end on page 40 or 41 or 42. Mr. Owens took a direct examination of this deponent for 68 pages, and then it was turned over to myself for cross-examination during the deposition. Beginning on page 75, I asked the deponent, what did the defendant say about the murder? What she said on page 78 was that, starting at line 13, and she said there was a suitcase and some clothes that had gotten out to donate, and they were trying to get that together. And it was on the floor in the living room. And that, as she was coming down the stairs, she saw him kind of slipping into the suitcase as a hiding place. As she said, I saw him in the suitcase, and I zipped him up, and we were laughing. She said then he said he couldn't breathe, and I remembered feeling I couldn't breathe when he was choking me or sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. And she goes on and on about what happened. Defense counsel was there. He heard this testimony that there was no imminent danger presented at the time that she began getting angry, shaking the suitcase, hitting him with a bat, so on and so forth. And he didn't ask her that question after she had specifically instructed him, if you need an opinion of mine, you've got to ask me the question. It's unfair to experts to be thrown with this catch-all provision of please tell me any opinion about this case that you may think is relevant. Well, what the doctor may think is relevant is different than perhaps what counsel thinks is relevant. So it's really an unfair criticism of the state and probably more likely self-reflective that this deposition, this opportunity to ask about this obvious issue did not occur. So that is what I would like to supplement the record with. The deposition was substantially longer than page 41 or 42 where it's acting like it's concluding and, is there anything else? The state would just submit, I understand very well what my ethical duties are. I do not have any ethical duty to provide him an unrecorded statement that is not inconsistent with prior testimony. This doctor did not give me any unrecorded statements inconsistent with her testimony. Thank you.
Thank you.
Judge, I'd like to add on page 79 that Dr. Warner claims that Sarah said he put his two fingers out and I hit them with a bat. So there was rule of completeness, but for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens, I've ruled, sir.
It's over.
I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any and all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd, 10055, located at pinpoint 1057, Florida, 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel?
No, sir.
Okay.
There's more.
I've got Earhart's Florida Evidence 2023 edition, Volume 1, Charles W. Earhart.
Let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here at Sidebar, to go into the facts that she relied upon and what it is that she utilized. I'm going to allow you, sir, as I said up here at the bench before the lunch hour, to go into those opinions that she didn't offer here today. And on rebuttal, Mr. J, I'm not going to allow you to stand up and say, may I voir dire, that wasn't one of your opinions today. You can address all of that in redirect. Is that clear?
Clear to state.
Judge, let me just review to see if, because I had several.
What you had inquired of me, Mr. Owens, up here, was that you wanted to go into these other facts, medical records, text messages, statements, and you said, if I can't do it now because he's going to object, I'm going to call her and assert rebuttal. And the problem, as the state pointed out, is that you can't use her as a conduit to admissible evidence on direct examination. And that if you want to do it, you got to do it now. And your argument was it goes to her bias, it goes to her credibility, and that you're permitted wide discretion on cross-examination. I agree with you. I agreed with you before the lunch hour. My ruling hasn't changed.
Do it now. Bring it up.
I'm going to absolutely allow you to go into those things.
I appreciate that, Judge. The other thing I wanted to readdress was...
Deep breath, Judge. Deep breath.
I'm taking care of it, Counselor. Give me a moment. Yes, sir.
Judge, I'm referring to Earhart's treatise, section 90.703, opinion on the ultimate issue. I'm on page 933. Testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. And in that section 703.1, it talks about that opinion testimony is not inadmissible solely because it includes an ultimate issue to be decided by the trier of fact. The provision is equally applicable to expert and lay witnesses. The jury has the power to accept or reject the testimony of expert or lay witnesses and is not bound by their conclusions. Merely because a witness expresses an opinion to an ultimate issue does not compel the jury to find that the facts to be true. The jury will be given the opinion. The jury will give the opinion as much weight as it feels the opinion deserves. Then it goes on. The abolition of the rule against opinions on the ultimate issues does not mean that all other opinions are admissible. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred. For example, a witness cannot express his or her opinion as to the guilt or innocence of a criminal defendant. Then I'm on page 940, 703.1 still. When a witness is asked to express an opinion that applies a legal standard to a set of facts, which Dr. Warner did, the opinion testimony is generally inadmissible. The danger is that the witness will apply a standard or definition which is different from that defined by the applicable law. The application of erroneous legal standard results in the opinion testimony being misleading and not helpful to the jury. For example, an expert cannot opine whether a nursing home was negligent in its care of the decedent.
It's exactly what we spoke about at counsel's table.
I know, Judge, but if you go on, it says an expert may not be permitted that a truck driver drove in a grossly negligent manner, whether the sheriff's conduct was unconstitutional, whether certain waters are navigable, whether the defendant's action constituted misapplication or concealment of funds, or the legal obligations of the parties to a contract, whether the testimony of the expert is a permissible factual conclusion or the impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with a trial judge. For example, the admission of expert testimony that certain investments, it goes on. However, the witness expresses an opinion about the intent of the accused. The opinion, this is important, one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Warner did, the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, Counselor.
But if I could finish.
Respectfully, Counselor, the citations that you're referring to are not at issue. Fluellen, error to permit arresting officer to testify that a quantity of cocaine possessed by appellant indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble, officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent with personal use and therefore intended for sale was inadmissible. 644 Southern 2nd, 1376 for Gamble, and Fluellen, 703 Southern 2nd, 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours based on what the defendant had said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines, based as looking all those things, the totality of the circumstances of what, in my evaluation, on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Judge, can I read a little bit more?
If you're just going to be reading from the treatise, I've already read it.
Okay, well, I just want to make mention, because it's talking about does not prevent a witness to testify about legal conclusions or express opinions on questions of substantive law. And I was about to finish this section when this testimony, and I'm on page 947, this testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Warner, and I wrote it down, she said based on what Sarah Boone told her, she was not facing imminent risk of harm.
He needs to tone down just a little bit.
That invades the province and function of the trial judge to determine the applicable law and to instruct the jury otherwise, which we haven't even done yet. You haven't made findings of law about which instructions apply. That's what she did, Judge.
Your objection's been made for the record, and the court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains.
Thank you.
Just because 9703 speaks for itself. So your objection is overruled as to that issue. Anything else we need to address, Mr. Owens, before we bring back in our panel?
No, sir.
State?
Nothing. Thank you, Judge.
Okay, let's bring back in our panel.
Jury. Okay, Mr. Owens, when I said swing for the fences, I didn't realize you were going to ask to have the case dismissed after jeopardy had applied, which means dismissed with prejudice. Wow. You went all the way. Quickest denial ever. Judge did not need to hear anything from the opposing side on that one. I didn't hear a lot new, even though he read a lot more. I didn't hear. This was the same argument. It was the same argument. He wanted to re-argue the same issue, and the judge saw that immediately and said, "We've discussed this."
You can just stay where you are, counsel. Let's wait for them to come in.
You can stay where you are. Judge is praying for patience, deep breathing, calming music. Let's do a little calming music here while the judge welcomes the jury. Everyone, deep breaths, deep breaths. Reset. The jury didn't hear any of this. They're walking in, just thought they got a long lunch. Jury, come on in. Welcome to our quiet, cozy, friendly courtroom. You didn't miss anything. Just had a little business to conduct outside your presence. Feel free to take your seats. Now, nobody talked to anybody else, right? Wonderful. Shall we begin? Shall we? Let's do that.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. All can be seated. Members of the jury, welcome back. Juror number 2, back row. He's already ready. I see those hands are raised. You know what's coming. Y'all complied to the court's instructions, right? Thank you. Record reflect all hands have been raised. Mr. Owens, you may continue your cross-examination, sir.
Now he gets to go into all those areas. And
Dr. Warner, I don't want to
prosecution can't
rehash it, but
object.
just for the jury's sake, would it be fair to say that the text messages that you were forwarded by the state attorney for you to review, you did not deem to be relevant to your evaluation?
Right. They demonstrate.
Ma'am, it's a yes or no question.
Yes.
It's getting spicy already.
Now, from what I understand, when the state attorney sent you the information, they did not send you any videotapes.
Correct.
So you have not reviewed any videotapes in this matter.
Correct.
The Suitcase videotapes, either one of those, you have not reviewed.
I have not seen them. Correct.
Okay. Or any body cam videotapes you have not reviewed.
They're described in the police report.
My question is, have you viewed any of the body cam videotapes relating to this incident?
I have not seen them, correct.
Prior incidences between the two of them, have you reviewed any videotapes, body cam videotapes of any prior incidents?
I have not.
Have you reviewed the audio tapes related to some of the questioning of Sarah Boone?
I have not.
Have you reviewed the autopsy report?
It's described in the incident report, but I did not see the actual autopsy report.
Now, you're aware that we have called two experts, Dr. Michael Brannon and Dr. Julie Harper. Is that correct?
Yes.
And you're aware that they are forensic psychologists.
That's correct.
And you are a forensic psychiatrist.
That's correct.
So they didn't go to medical school and you did.
That's correct.
And they don't understand medical issues, so to speak.
I don't have an understanding of what they understand medically.
Do you recall telling me that they don't understand medical issues, so to speak?
They haven't been to medical school, but I wouldn't understand their medical knowledge.
If you would look on page 22 of your deposition.
He used her words.
Objection collateral. Approach.
Objection collateral. If the bailiff is listening, wonderful bailiff, can you please go fix her mic? She's moved it so we can barely hear her, and it's pointed off to the side. She thinks she can talk into it. It has a pickup pattern that needs to sort of be pointed at her mouth. If you could fix that, that would be great.
Objection's overruled.
Overruled. Another win for the defense.
Dr. Warner, have you had a chance to review your deposition on page 22, starting at line 7?
Yes.
Could you read down through line 11 your answer?
Yes, I'm talking about psychologists in general, not with regard specifically to your experts, which is what you were just asking me about.
Okay, but you would agree, your opinion is psychologists typically do therapy, but they don't prescribe medication or understand medical issues, so to speak.
Correct.
Overruled.
Correct. But I wasn't specifically talking about your experts, which you were just asking me about your experts specifically, okay. and I said I didn't understand. I didn't know what their specific medical.
Right, that's what you said under oath, October 4th of this year.
Correct.
Sustained.
Now, is it fair to say that the majority of your work is in the field of competency to proceed and guardianship evaluations?
Actually, the majority of my work is in patient care. I work 7 days a week on the crisis stabilization unit, actually treating patients.
You work 7 days a week.
Yes, sir.
So, as a forensic psychiatrist doing forensic work, the majority of your work in that area is in the field of competency to proceed and guardianship evaluations.
As a forensic psychiatrist, correct. As a psychiatrist, I work 7 days a week on the crisis stabilization unit.
And where is that unit?
It's in located in Lake City, Florida.
So you work there 7 days a week?
Yes, sir.
And then you also do this forensic psychiatrist work doing competencies to proceed and guardianship evaluations?
That's part of the what comes under the umbrella of my forensic work, yes.
That's the majority of your forensic work?
Yes, that's the majority. That's the most common cases that we're asked to.
And then next in line would be sanity at the time of the crime.
Yes.
So you would make a determination and submit a report to the court as to whether or not a defendant, an accused, is legally sane or not at the time of the offense.
Yes, that's correct.
Is it fair to say that you also testify weekly as a treating physician through Baker Act Court?
Yes, that's correct. Every Thursday, we have Baker Act hearings with regards to our individuals who are being held in our crisis stabilization unit.
Is that in Gainesville or Lake City?
No, sir, that's in Lake City.
Now, Lake City from here is north of Gainesville?
Yes, sir. It's approximately 40 minutes north of Gainesville.
She works hard. A lot of hours.
Now, I believe you said you've testified in battering spouse situations in court approximately 5 to 10 times?
Yes.
Is that correct?
Yes.
And you often refer to that as intimate violence cases?
Yes.
Now, my understanding that after you had a chance to evaluate my client, Sarah Boone, and I believe you evaluated her 2 days before the deposition, so it would have been October the 2nd of 2024.
Correct.
As to your diagnosis as it relates to her, do you believe that she suffers from a generalized anxiety disorder?
No, sir.
Now, you're aware that she was previously diagnosed prior to you evaluating her. She was previously diagnosed with a generalized anxiety disorder.
She told me that she had previously been diagnosed. I did not see any medical records with that diagnosis in it, but she told me that she had previously been diagnosed with that.
Did you attempt to secure any other records to us?
Proper. Sustained.
Did you diagnose her with an adjustment disorder?
I did diagnose her with an adjustment disorder.
Do you believe that if she was diagnosed with a generalized anxiety disorder, it's really not that, it should be an adjustment disorder?
A lot of the symptoms overlap for the two diagnoses, and we see that quite often, that the different diagnosticians or physicians come up with different diagnoses based on a conglomerate of symptoms. So it's not uncommon for the two diagnoses to overlap based on the symptoms.
Do you agree back on October the 4th, 2024, when I took your deposition, that you could not make up your mind at that time whether she suffered from generalized anxiety disorder or an adjustment disorder?
I had not made a clinical decision at that time. I hadn't reviewed all of my documents at that time.
When did you make a clinical decision that she suffered from adjustment disorder as opposed to generalized anxiety disorder?
It was probably within the next week when I was reviewing all of the, going through all of the documents in her interview more thoroughly.
Dr. Warner, did you agree you did not notify me?
Judge, may we approach?
Yes.
Apparently, we haven't worked this through thoroughly. We're going to rehash this with every issue. I'm going to need more goats because these batteries are just going to wear down. But we now have a screaming goat match going. Yeah, it's been one of those days here. Holy cow. Or holy goat, I guess I should say. Mr. Owens isn't letting go. I'm seeing in Mr. Owens some traits I see in Sarah Boone. Sarah Boone gets hung up on specific issues that she feels she was wronged in. And I'm not saying she's not correct. She might be wrong. I mean, she might be actually the person who was wronged. But sometimes that issue doesn't really matter. Does that make sense? It's not relevant. It's collateral. Mr. Owens has been hung up on this deal that he had this agreement, this gentleman's agreement with the prosecution, that they would, if something changes, I'll tell you. And they didn't tell him anything. And he's like, hey, why didn't you tell me? It doesn't really matter. And maybe through testimony, maybe through argument with the judge, he can convince the judge otherwise. But as it stands right now, it doesn't really matter on those issues. And it shows especially when he is making an objection and he can't cite the legal objection. Instead, he focuses on the issue itself.
Dr. Warner, you agree that when I took your deposition on October the 4th, you had questions, in all honesty, about whether or not you felt like Sarah Boone suffered from a generalized anxiety disorder versus an adjustment disorder.
I was leaning towards adjustment disorder secondary to her being in the correctional setting, and I think I said that in my deposition. I didn't know that I had enough information from her because I only had information from her. I didn't have anything in the medical records to support generalized anxiety disorder. So I wanted to review that.
I'm just learning it now as you testified here today.
Sustained.
Is this the first time you've let the parties know that this is your opinion?
That I believe that she has generalized anxiety disorder?
No.
Or that I believe that she has
adjustment disorder.
Adjustment disorder, yes.
Okay. That might be a problem.
From your evaluation, you determined that she had a personality trait.
That's correct.
And you felt like that she had a grandiosity issue?
Yes, she has a narcissistic personality disorder trait.
A trait, one trait.
Correct.
Do you agree a lot of people have one trait?
Yes.
Okay. A lot of people have a grandiosity trait.
Yeah, that's correct.
That are not narcissists.
But I never said that she was a narcissist.
Is it your opinion that Sarah Boone has alcohol use disorder?
Yes, that's correct.
And are you forming that opinion based on Sarah Boone's admission to you that she was an alcoholic?
I'm going to refer to my notes. She has a history of being diagnosed with that. She also acknowledged to me that her use had been problematic.
A history of being
so
diagnosed.
You formed the opinion that she suffered from alcohol use disorder based on the history that she presented to you at this evaluation?
It was based on the totality of the information that I was provided. So the medical records demonstrating that she had been diagnosed with it in the past. Her ex-husband in his interview in the police report described her as an alcoholic, and in her description of herself having a problem with alcohol.
Do you acquire a tolerance over time if you drink on the regular?
That's one of the criteria.
Do people also have a genetic tolerance for alcohol?
They may.
Now, as it relates to battered spouse syndrome, would you agree that that is a recognized syndrome in the psychiatric community?
Yes.
And you have heard no criticisms of that syndrome?
No.
And you would agree that's a subset of post-traumatic stress disorder?
Yes.
And you would agree that Lenore Walker first developed the theory of post-traumatic stress syndrome?
Yes.
Now, I think at the time of this deposition, you were not sure you knew Lenore Walker.
I don't recall that.
All right, look at page 54.
This is collateral. There it is. Approach. I think this will be sustained. That she doesn't remember who was the founding, I mean, granted, it's brought up a lot, but who was the founding person that came up with PTSD? It's like forgetting that Edison created the light bulb. It doesn't, you can still be an electrician and not know that Edison created the light bulb, right? Oh. He's got bigger fish to fry, I think, than this one. I think it's PTSD, not BSS. I think they're still talking about PTSD. There might be an argument to say this goes towards her credibility because her familiarity with the topic, which she's supposed to be an expert in, should include the history of the topic. J-Lo, she's got to work. They have not started the video yet. We're still on the witness that was supposed to take half an hour. Half an hour with the state and half an hour with defense. And we might be here all day. I'm doing some breathing exercises right here. Owens is doing his job.
Objection is sustained.
Sustained. That's collateral. Doesn't matter.
Dr. Warner, do you recognize Lenore E.A. Walker's book, The Battered Woman Syndrome, as an authoritative treatise on battered spouse syndrome?
I do not, because I have not read everything. I haven't read it, and so I can't say that I agree with everything in it.
Interesting answer.
Is it clear to you that Sarah Boone was involved in a violent relationship with George Torres?
Yes.
Do you agree that there was a violent cycle that occurred during that 3.5-year relationship that Sarah Boone had with George Torres?
It's been described that way, yes.
Would you describe it that way?
It's been described that way to me, yes.
Do you have an opinion?
Sustained.
Do you have an opinion that that was a violent cycle between Sarah Boone and George Torres?
It's been described that way, yes.
Do you agree that George Torres was the abuser and Sarah Boone was the victim in that?
It was a volatile relationship. In the police report, her ex-husband actually describes her as being the aggressor.
Okay, I'm going to show you
Boom.
what's been identified
That's a good answer.
as Defense Exhibit I. Have you ever seen this photograph?
I have not.
Do you see the injuries on Sarah Boone?
I do.
Oh, we're going through the exhibits.
I'll show you Defense identification H. You see this photograph?
I do.
Have you ever seen it before?
I have not.
Do you agree that's Sarah Boone?
I do.
Are you aware that George Torres...
Objection.
Sustained.
There's going to be objection on each one.
I'm going to show you defense identification G. Have you ever seen this photograph?
I have not.
Did you ever read anything about George Torres using a curtain rod as a weapon against Sarah Boone?
I don't recall that specifically.
Identification F. Have you ever seen this photograph?
No.
Defense identification E. Have you ever seen this photograph?
No.
Identification D. Have you ever seen this photograph?
No.
Have you ever seen a videotape relating to this photograph?
No.
Identification A. Have you ever seen this photograph?
No.
Now, I believe at the time of the deposition, you had spent I think on October the 2nd of 2024, you had spent 2.5 hours evaluating Sarah Boone, and about half of that time was giving her a test.
No. The mental status examination takes approximately 5 minutes.
Okay. Did you go through her entire history of abuse over the 3.5-year period within the 2 hours and 20 minutes that you had?
No.
Now, I understand that you indicated you may take a couple more hours to go through your file and your notes and to come up with your conclusions. Did you do that?
Yes.
Have you spent any more time on the case other than that 2 hours?
I re-reviewed the documents.
Have you made any other attempts to go see Sarah Boone anymore?
Objection. Proper.
Sustained.
You agree that your opinions are subjective, not based on authority?
They're based on my education, training, and years of experience.
And you would agree they're your subjective opinion?
Correct.
Would you agree that Sarah Boone suffers from battered spouse syndrome?
I do.
Would you agree that battered women's experiences affect their perception of imminent danger?
They can.
Would you agree that victims of repeat violence may fear death in a situation others would not?
They may.
Because someone suffers from battered spouse syndrome, they have a heightened sensitivity to danger.
They may.
You agree that people suffering from depression and anxiety are predisposed to getting into a relationship with a partner who may be violent?
They may. Each individual is different.
Are they more susceptible to getting in a relationship if they suffer from depression and anxiety with a violent, intimate partner?
They may be.
Do you agree that the DSM, I think you have it there with you,
Yes, sir.
directs that the clinician should consider post-traumatic stress disorder if there was exposure to extreme stress? Do you agree with that?
Yes.
Did you do any testing to measure whether or not Sarah Boone had post-traumatic stress disorder?
No.
Is it your opinion that Sarah Boone suffers from post-traumatic stress disorder?
Again, she did not give me enough information to formulate an opinion with regards to that.
You agree that an intimate partner who commits acts of violence, physical violence, against the victim that could cause extreme stress in that individual?
It may.
Do you agree if that is the cause, the violence is the cause of extreme stress, that a diagnosis of post-traumatic stress disorder should be considered?
If they meet the criteria. They have to meet the diagnostic criteria.
Do you agree that there is a sense of learned helplessness when someone suffers from battered spouse syndrome?
Yes, that's part of the syndrome.
Do you agree that these women, these battered women, have learned the probability of receiving a beating, and they recognize specific predictive cues emitting from the batterers?
Yes, but it's not just women.
I understand, but you would agree the vast majority of intimate partner violence, battered spouse syndrome victims are women?
Yes, intimate partner violence, yes.
Excuse me?
Intimate partner violence, yes.
The vast majority, the lion's share, are women.
Yes.
And these battered women have learned the probability of receiving a beating by recognizing specific predictive cues emitted by the batterers.
Correct.
And many times, these predictive cues result in a high level of anxiety.
Yes.
And in that situation, the battered women may attempt to reduce through several different means, one of which is to avoid delaying the beating.
Yes, we talked about that with the cycle.
What is a basal instinct?
A basal instinct? I have no idea.
Primal fear?
Primal fear is just being afraid.
Is that a natural instinct that animals have?
Yes.
Fight or flight instinct?
Yes.
You don't even think about it.
Correct.
Do you agree that victims of battered spouse or battered woman syndrome suffer from self-isolation, suicidal thoughts, and oftentimes substance abuse?
They may. Each individual is different, so they may.
And they may show signs of physical injury and illness, such as bruising and chronic fatigue.
Yes, those can be signs.
The syndrome, battered woman syndrome, is the psychological effects of living with an intimate partner violence. They may have intrusive memories.
They may.
Or they re-experience past traumatic events in their mind.
Yes.
They have high levels of anxiety.
Yes.
Hypervigilant when something doesn't seem right.
They may.
It leads to this fight or flight response that we spoke about.
Yes.
They have problems with sleep.
They may.
They often go into denial,
They may.
minimizing what is happening to them,
They may.
numbing their emotions.
Some of them.
Disassociation. A battered woman may often develop a defense mechanism of being able to psychologically detach from their body during the traumatic experience.
Sustained.
Panic attacks, severe depression, very low self-esteem, poor body image, disassociation, learned helplessness. All these are symptoms of a battered woman syndrome.
Compound, facts and evidence.
Sustained.
You agree panic attacks is one of the symptoms of battered woman syndrome?
Sustained.
What are the symptoms of a battered spouse syndrome?
They can be numerous symptoms, from anxiety symptoms, mood symptoms. They can have psychotic symptoms. It can be any vast majority of symptoms. Substance abuse symptoms, any vast majority.
Do you agree fear is a symptom?
Yes.
Somebody in a constant state of fear.
Maybe, yes.
In terms of the abusive partner, do you agree that they would hit the victim?
Some of them, yes.
Kick the victim?
They may.
Punch the victim?
They may.
Choke?
Abuse takes all different forms.
Choke?
They may.
Burn?
They may.
Destroy their belongings?
They may.
Use weapons to hurt them?
They may.
Threaten to hurt them, their children, or their pets?
They may.
Take their car keys?
They may.
Take their debit card?
They may.
Take their vehicle?
They may.
Control where they go and who they see?
Yes, they may.
Force them to have sex when they don't want to?
Yes, they may.
Dr. Warner. I know you spent a short amount of time with her, and you're saying you didn't get some of the answers as to whether or not.
Facts. Facts.
Objection sustained.
If you'd have spent more time with Sarah Boone, could you have uncovered as to whether or not she suffered from battered spouse syndrome?
I agree that she met the criteria, or that she had battered spouse.
How about post-traumatic stress disorder?
It's possible.
Thank you.
Any redirect examination?
Yes.
You may proceed.
In your decades of experience, have you ever treated patients that suffer from trauma disorders?
Yes.
How frequently would you say you do that?
I have patients on my unit right now that I'm treating on a regular daily basis who have suffered from trauma.
How about patients that meet the criteria for battered spouse syndrome?
Yes.
How many would you say over the course of your career?
Probably 5 to 6 a month on my inpatient unit.
And that's a lot of months.
Yes.
How long have you been doing this?
Since 1998, when I began my career at the University of Florida on faculty.
Now, on cross-examination, you were asked about some diagnoses, correct?
Yes.
Right. Any of these things that you talked about, narcissistic personality disorder, adjustment disorder, anxiety, battered spouse syndrome, any stress or trauma-related disorder. If the state wanted to ask you those opinions, would you have been receptive to more materials before making any opinions about those topics?
Yes.
And is it your testimony today that you don't have enough information to necessarily make a complete and proper diagnosis on any of those things since you have not been provided those materials?
Correct.
Now, you've testified that she does meet the criteria for battered spouse syndrome.
Yes.
But you would be receptive to any evidence that you were provided, right?
Correct.
Going back to what you testified to on direct when the state asked you your opinion about this case, everything that you just talked about with Mr. Owens, does that change your opinion about whether or not battered spouse syndrome is applicable to the facts as Ms. Boone relayed them to you about this incident?
No, not at all.
And why is that?
Because again, she just...
Objection, Judge.
Asked and answered. I think it's asked and answered. The state's not worried about anything that Mr. Owens got her to admit to because, according to them, it doesn't matter. The way Sarah Boone told the story, it doesn't matter. According to this expert, how things unfolded that night was not a
Objections overruled.
Based on your conversation with Mr. Owens, you've indicated that your opinion did not change, and now would you answer why?
Yes. So based on my interview with her and the way that she described the incident to me, and that they were laughing and having a good time, it didn't play into relaying any kind of triggers or any kind of trauma.
Peter, thanks for
and
18 months.
Showing you what has been
Thank
marked
you.
for identification purposes by the defendant as I. Does this photograph inform you as to what happened?
No.
Does it inform you as to who was the aggressor?
No.
H for identification, same questions. Does it inform you as to what happened?
No.
Does it inform you as to who the aggressor was?
No.
Same questions for G.
No.
F.
No.
E.
No.
D.
No.
And A.
No.
If those specifics as to what happened and who was the aggressor is dependent upon the credibility of somebody, would you want to take into account all the things that can make a person credible or less than credible?
Yes, you would want to take that into account.
And you talked about alcohol use disorder. Would you take that into account if somebody is under the influence of alcohol or had been consuming alcohol when they relay a history as to things that happened?
We've had more objections today in this trial than all the rest of the trial put together. It's been spicy. It sounds like the state is wrapping up. They probably only have one or two questions left at the most, and then they'll be done with this witness, and then we move on to video. We have some video to see. It's a couple hours long. It'll probably take us to the rest of the day today, which means closings. Juror, well, maybe we can do a juror charge conference tonight. I don't know how late the judge wants to work. I want to know how many hours this expert billed for. 'Cause it sounds like she's very, very busy and didn't have time to do anything but make a quick trip down, visit with Sarah for a couple hours, and then leave.
Objections overruled.
Would you consider somebody's alcohol use and level of intoxication in evaluating the credibility of them as a historian?
Yes.
And you were asked about whether or not you did any testing for post-traumatic stress disorder.
Correct.
And you didn't.
Correct.
You already indicated, however, you believe that Ms. Boone meets the criteria for battered spouse syndrome.
That's correct.
Again, that doesn't change your opinion that you gave when talking with me on direct examination.
Object. Asked and answered.
Overruled.
Specifically about this question about the testing that you did not perform. Did this lack of testing have any change or effect on your opinion as to whether or not battered spouse syndrome applied to the facts of this case?
No.
You were questioned about insanity on cross-examination. Do you recall that?
Yes.
Would you agree that simply because somebody is mentally ill and meets the criteria for diagnosis such as schizophrenia, bipolar, any of those psychotic or mood disorders, that doesn't necessarily make a person legally insane?
Correct. The two aren't equal.
Likewise, even if somebody meets the criteria for battered spouse syndrome, does that mean every action they take against their intimate partner is justified?
Correct. That's not. They wouldn't be equal.
So even if you do have battered spouse syndrome, even if you are in an intimately violent relationship, that doesn't necessarily mean any action you take against your partner is justified.
That's correct.
No other questions?
There we go.
State, can this witness be released?
Yes, sir.
Defense.
You still want?
We got a phone number we can reach out to.
Okay. All right, ma'am, you're released, potentially subject to recall. Thank you.
Subject to recall. I don't think there's going to be any sir rebuttal.
State, you can call your next witness.
Judge, at this time, the state would move P for identification and evidence.
Here's video.
Is this a videotape or an audio tape?
He's a loud whisper. This is a digital CD. What it contains. Krista OG gifted a membership. Thank you very much, Krista. Oh man, P will. Yeah, these are costly.
State moves P for identification and evidence.
I'm not sure if we hit the million mark.
Got it. Okay. Any objection to what was pre-marked as P?
Yes.
Counsel? Any objection to what was pre-marked as P?
Permission of public?
No. He's offering it in evidence. Any objection?
No objection.
All right. What was pre-marked as P will be received into evidence without objection as states 21.
I'm not sure where Owens' mind is, but it wasn't in the moment. Any objections?
No objection.
What was pre-marked as V will be received into evidence without objection as states 22.
May we approach?
Yes.
Owens is getting his steps in. I think he's up to about 20,000 today, just walking back and forth from the bench. Sarah is at 15 steps. So Owens is winning. So what just happened is the state is done with their expert rebuttal witness, and it was quite heated from the start to the finish. Lots and lots of objections, lots of sidebars.
Members of the jury, it is 2:52 in the afternoon. The next part of the state's presentation are going to be some videos and other things that we read to you that may take a little bit of time based on the length of them. So we're going to go ahead and take our afternoon break at this point in time. Similar instruction I've given to you over the last couple of days. Please do not conduct any independent investigation or research if the person, places, things, or charge involved, and do not have any discussions with anyone or amongst yourselves about those things, and we'll bring in 5 after. Thank you.
Krista, thank you for the super chat. Membership train, go! I think we did that this morning. That was awesome. Dodie, we do that after the case closes. When it goes to the jury, that's when we do our poll on that, not before.
Y'all may be seated. Thank you. State, anything we need to talk about?
No, sir.
Defense? No, sir. All right, we'll be in recess till 5 after. Thank you.
We need some more soft music to decompress. We can play some soft music here for a little bit. The jury is about to watch a lengthy video. I think it's 2.5 hours long. I don't know if it's body camera footage. I don't know exactly what it is. It might have to do with injuries that George received from previous things. Because of that, the jury was invited to take a quick break to walk out, stretch a little bit, get the blood flowing, take care of any business they need to, because they've got to settle in for the long afternoon video session. So hopefully nobody gets sleepy here. That was pretty tense. Mr. Owens, I think, fought hard. I mean, Sarah should have no complaints, 0 complaints about how hard Mr. Owens went to bat for her. I guess going to bat is not a good example. How hard he... my YouTube just crashed. Luckily, I'm on hardware, not software, so... Let's see if I can turn that off there. There we go. I'll get it fixed up again. Get your comments back. Pop this back out. I think on days like today where we have a lot of people chatting, the memory just fills up of all the previous messages, and the computer just says, I'm done. I'm done. I'll take no more. All right, good music. Good music. I have to tell you, I so was tempted to play this music when Sarah Boone was, I think it was her. She was saying that you wouldn't understand if you've never been in love. Do you remember that part of the testimony? I almost hit the play button there. I told my mods, I was typing to my mods so that my hands would be busy so I wouldn't play this music in the background. It was so tempting. And people were asking for it too. And I'm like, I can't look at it. But wow, 2 souls becoming 1. Yes. Good. It's a beautiful song. We first debuted this song during the Mark Jensen retrial. Does everyone feel better? Deep breaths. Wake up, wake up, everybody wake up. It's a beautiful, beautiful song. I call that one Sad Piano. It's nice. Okay, we're going to move on from that contentious rebuttal witness to video and reading records. Can you bring the thumbnail up for a quick review? Let me see if I can. This laptop is maxed out. have to shut some things down.
Call from
Mathis, I got to say, keep it light. It's afternoon. We've all had lunch. I know
Yes,
your
very
schedule's different, but keep it light for us, would you? What's on your mind?
Yeah, I don't want to keep you from the thumbnail either. So I read some of those cases, and I think there's kind of an argument to be made that the judge got the second one right, where they were talking about the Dinkins opinion, but I think it's kind of close, and the law is not worded in such a way that it makes sense to ordinary people. And then the other thing is that I think I need to go back to see if Owens moved to strike the testimony, because the judge only talked about striking the entire expert.
He did not. He did not move to strike it. As a matter of fact, the judge brought it up and said, "Mr. Owens, do you want us to strike it, or do you want a curative?" And he said, "No, because I want to use it in rebuttal."
So I think that he was not consistent on that. I think after he did the depot, he said a bunch of other things. That's one of the problems where he takes some time to get to the point. But if at some point he did move to strike that testimony at the very least, or ask for more, an appellate court could still very easily find that the mid-trial deposition was definitely not sufficient. And if Owens asked for more afterward, the judge could be in big trouble, because it definitely is not sufficient to have a depot. And so the only question is if Owens didn't ask for the right remedy.
Well, they might have appeal grounds then. It might be there. Let me, while you're on the phone here, I want your opinion of this, if I can. I'm not sure if you can see. Well, now you can. This is our thumbnail as it is right now.
Mm-hmm.
Your thoughts on the thumbnail.
There's only one dog, and I think we need two.
Need another dog? We have one blind dog and one deaf dog, right?
Where's the other one?
I'm looking. I mean,
I only see the one that's dabbing.
I think that's the blind one.
Yeah.
Covering his eyes. We need a deaf dog. Okay, deaf dog is a suggestion. There's a lot on here.
I'm always for dogs.
Yeah, it's all right.
I see the chat saying steak knife, maybe some fencing.
Mm-hmm. I'm looking to see if we have a steak knife somewhere. I'll have to look when my eyes aren't so blurry. I've been staring at the screen for a while. Anyway, we're going to come back to court here in just a second. And so you're saying that the judge may have got it right, may have got it wrong. It's a little confusing.
It's very close to the edge, I think. On the second one, I could not find a clear case that covered a similar scenario where it's like, I think she said something like, in my opinion, she was not in fear. And I think if you asked her, in your opinion, was she in a reasonable fear of imminent harm, I think that crosses the line, because reasonableness is a legal conclusion.
And it's something for the jury to determine.
Yeah, that makes it a legal conclusion for the jury. Mm-hmm. So you can't ask that. So you can't ask if it's a reasonable fear. Yeah. But if she says, in my opinion, there was no fear, maybe that's admissible, at least if it's an opinion, because the case law on what makes it, like when an opinion becomes a legal conclusion, is not that explicit.
With the expert as well. And she's basing it on what Sarah told her. So she's saying, based on what she told me, there was no fear. Because Sarah didn't say she was afraid. So, Mathis, thank you.
I think that's not reversible error.
Yeah. I appreciate you doing the heavy lifting there. Thank you for digging into all the case law. You were born in the wrong country. You know, you should have been a lawyer here in the U.S. instead of Germany.
We'll see about that. All right. I'll let you enjoy your break.
Thanks a lot, Mathis. We'll see you. Bye.
Bye-bye.
Love Mathis. Smart man. Smarter than me in many, many, many ways. If he was born in America, he wouldn't have that glorious accent, says Culperistic. She never said she was afraid that I'm aware of until she took the stand, until she needed to, until they had to get more. I think the judge knows the case law. This judge is incredible with case law. That or he has the fastest judicial assistants known to man. They're really, really good. Because someone will make a motion in front of him, and in his ruling, he'll cite case law that nobody else has mentioned. Yeah, I would trust the judge on that for sure. Here's a number I haven't heard before.
Chris?
Hey, Chris, this is R.A. We've got just a minute before the jury comes back. What's on your mind?
Oh, yeah, how are you? I enjoy your show. I had a thought, and I can't remember if it was this case or another case. Did she get mad and kill him because he said he was fooling around with another woman or wanted to go with another woman? Was that this case? Am I wrong?
There are elements of that. But the way she tells the story, they were just playing games. Everything was fine. Everything was wonderful until he was in the suitcase. And then she remembered how she felt when he cheats on her and he chokes her. And I guess they've got more details.
Oh, okay.
there.
Okay. I thought that was the reason for her doing this.
Well, that's the big question. But there was
perhaps
in most versions of her story that she tells, there was no reason because this was unintentional. You can't have a reason and also say, but I didn't mean to do it.
I don't think she tried to kill him. I think she tried to show him, hey, don't do this to me anymore. I'm in control now. You better watch yourself.
That was what she said most recently. That's her version.
That's exactly how I see it.
Him a lesson so he would understand now how she feels, so that he could become a better person. But the problem is not intending for him to die. He was telling her that he could not breathe, and a reasonable person could conclude that not being able to breathe will
enough
result
is
in
enough.
especially an adult, a parent, nonetheless. Right. I mean, anyone who's had a child and has the child, choke on something, even if it's food for a minute, knows how urgent it is to get air. And and her being a parent and him saying, I can't breathe, Sarah, please, I can't breathe.
It probably went too far, and she's probably like, oh, if I let him out, he's going to kill me. What do I do?
CF2603, State of Florida versus Sarah Boone. State.
Okay, thanks. Bye.
Defense.
James Owens from Ms. Boone.
Kevin back on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. It's 3:05. We're ready to bring back in our jury, Mr. J.
Yes, Your Honor.
Defense. All right, let's go ahead and stand and bring back in our panel.
Just for the record, I'm also wearing the same clothing from this morning. I rarely change halfway through the day. Rebuttal is not a time to play the same evidence again. This will be new evidence we're hearing. In closing, we might, see the video, the suitcase video again or something like that. But this should all be brand new evidence we have not seen before. So I'm not sure what this video will be. Jurors, please raise your hands. Thank you.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Thank you. Y'all can be seated. Members jury, again, do you comply with the court's instructions during our break? All right, record reflect all hands have been raised. Thank you very much. State, you may proceed with the balance of your evidence presentation.
Thank you. Permission to publish what has been entered into evidence as 22, previously V as in Victor for identification.
You may proceed.
You've got mail.
This exhibit 22 has 5 folders on it. It is a DVD. Going into the first folder, OCSO 18-067501.
Counselor, are these audio or video files?
This first one, Your Honor, is going to be a video file.
Okay, let's go ahead and dim the lights, please. Thank you.
Mood lighting.
For record purposes, its file name ends with 0154-2.
Ooh, I like it.
You may proceed, sir.
I'm going to turn off my screen so you can see the full picture. I'm still here. Audio is going to burst on about 30 seconds into this, and it may be loud. I'll try to adjust it as needed.
For a year and a half, and he turned into a whole bunch of shit. Pardon me for saying that. No. Pardon me for saying that, but like, oh man, he let loose on my ass tonight, and I'm not having it. Okay. Right. I got kicked in the face. Okay. Kicked in the face.
That you know of, there's no guns, anything.
No. I know, baby. You guys are doing your job.
All right,
no.
Sarah here?
Yes. Go get him. I swear to God, there's nothing you guys can be afraid of.
What's his name?
George.
George, all right.
There's nothing you guys can be afraid of. I swear to God, I'm done with that too. He beat the fuck out of me tonight. And I'm done with it. I have to go to work tomorrow.
What's up, George? You want to talk to us? What's up? Talk to you inside.
For the record, this is redacted.
Are the videos in States 22 redacted videos?
Okay. You see my eyes?
I do see your eyes. Okay, tell me how it all went down from beginning to.
Yes, my love.
Okay.
Okay, so we were having a really good day, and we went across the street from Muldoon, and everything was feeling fine and dandy, and because I talked to another guy because he left, came in there and got so mad, because I asked for a cigarette from another guy because he took my license, my debit card, and everything, cigarettes, everything, took everything. Okay. So I asked someone for a cigarette, and it happened to be a guy. So he walked in and got super pissed because I asked for a cigarette from another guy. I came home. Mind you, my car is across the street still. Okay.
So you get home.
Tears for the car.
Home and let loose.
Okay, elaborate. So you open the door. What happens from there?
I'm a whore.
He starts calling you names? Okay.
When I say ragdoll, you know what that is?
I know what a ragdoll is.
Oh man, I was ragdolled.
Okay, but I need you. Okay, I need you to elaborate. Like, you walk into the house. Did you start arguing? He started calling you names. You said he was.
No, I walked out. I walked in and I walked to the back. I just wanted to smoke a cigarette and just go to sleep. I just literally wanted to. I'm smoking a cigarette. I'm gonna go to sleep.
And then as you're making your way to the back, what happened?
I got caught on the stairwell.
You got caught on the stairwell. So he caught you on the stairwell. And what did he get in front of you? Started confronting you, telling you anything? What happened?
It was bad.
Okay. Elaborate, Miss Sarah. I need you to tell me exactly what happened so I can help you.
My heart is like, I don't want him to get in trouble, but fuck, I'm tired of being beaten up.
Okay. I understand. I'm trying to help you out, but I need you to elaborate a little bit. So, in the stairwell,
dragged me downstairs. I went upstairs, tried to get into bed. I just want to go to sleep. I just want to go to sleep. I just want to go to sleep. I didn't make it to bed. I didn't make it to bed. He caught me in the upstairs.
like in the hallway?
Beating the fuck up. That's all I can say.
Okay, what do you mean? Like, I see your eye. What, you said he kicked you in the eye.
That's what I see it. That's what it is.
Were you on the floor when he kicked you?
Yes, ma'am.
Okay, how did you get to the floor? Did he push you? Did he pull you? How?
Normally what I do is, because he does it so often, I just go to the floor. So I'm pretty sure I don't really recollect. I went to the ground.
Okay. And then that's when
I'm
he
so
kicked
sorry.
you. No, that's fine. I don't mind. So you went down to the ground.
Yes, that's what I do.
Did he kick you with what? Do you recall which foot?
Right.
Right foot, okay.
Heel.
His heel. Okay. And you say you've been together for...
Because I asked for a cigarette. Because he left my ass in my car across the street.
Okay. You said you've been together for about a year?
And a half.
A year and a half.
Yes.
Okay. Live together, obviously.
Yes.
Okay.
I just recently went for a divorce. He's been there with me. He knows all the story, blah, blah, blah. But...
I know. I'm just trying to...
This sucks! And I could have worked tomorrow.
Do you want the fire department to come out and check your eye? No? Okay. Do you want to press charges? You can smoke your cigarette if you want.
Can I talk to you though?
You're talking to me with myself.
I don't want to be taken. Please put the finger of the police.
So you don't want to press charges? Okay. Do you want to fill out any paperwork? Do a statement? No? Okay. Smoke your cigarette, sit down, smoke your cigarette.
I don't want to be in trouble. What?
I know.
You guys have actually been out here twice now. Look at this shit. Look at this my shit all the time.
Did this happen today?
Yes.
Okay. Alright. Yeah, I see it. It's ripped and done a little bit.
I just bought this yesterday.
Okay, sit down. Smoke your cigarette. Do you think? No, it's fine. Do you have an ID with you? Is it in the house? Okay, we'll go find out.
I know my number if you want it.
Oh, that's perfect. Go for it.
B500-791-77870-0.
870-0, okay. First name is spelled S-A-R-A-H. Do you have a middle name?
Catherine. K-A-T-H-R-Y-N.
K-A-T-H-R-Y-N. R-Y-N. What's your last name?
B-O-O-N-E.
Date of birth?
10-10-7-7.
I get it. So you cannot space the arm anymore. Do you have a telephone number?
407.
407? 8684. Email address?
Sorry, I tried.
SKP.
SKP_100. 1-800.
Ayden.com.
Yahoo.com.
Sorry.
No, it's cool. I get it. Sit down, smoke your cigarette, try to relax a little bit. I'm going to take pictures of you in a little bit. Alright? No problem.
The sound you're hearing is the sounds of the
Turning now to folder OCSO 19-054.
The
Can the parties approach just for a moment?
The body cam makes that sound to remind the officer it's recording, so they know it's on. Judge asks the parties to approach in the dark. Just come up here and come sidebar in the dark. Judge just turned the lights down.
All right, sir, you may continue.
Within this folder, the first thing that will be published is a file that's an audio file, 911 call _R1.
911, what is the location of your emergency?
4748 Grand Square, apartment 3.
4748, what was the street name? I didn't hear you.
4748 Grand Square, apartment 3.
Okay.
He's nothing but a call, but I did. And he just beat the fuck out of me.
You said Frank Lane?
That's what it comes up as always.
Okay, and then what was the apartment?
3.
Okay, and what happened then?
He just beat the fuck out of me.
Who is he?
George Torres.
Is he still there?
Yes.
Okay, where's he at?
Up in the bed. I'm outside.
Okay.
I did not fight back.
Okay, do you need any medical attention?
No. I just have a bump on my head and I just got beat the fuck up. That's all.
Okay, what's your name?
Sarah. With an H.
Okay, and George, you black understand?
He's Hispanic.
What are you wearing today?
Oh gosh.
Just tell the sheriff's head, that's all I need.
I don't even recognize because he just showed up.
Okay. Do you have his date of birth?
February 13th, 78. 2/13/78. And I swear, I'm just going inside because he's not a police and he's not supposed to be here. But he's here.
How long ago did this happen? About how many
12
minutes?
minutes ago.
Okay.
I'm done.
Yes, sir.
I can't do this anymore.
Okay. And I just need a description of you so that I can identify you when they get there.
I'm white. I have 30 blonde hair and blue eyes.
What color is your pants you wearing?
Am I?
Yes.
Black.
Black shirt, black pants?
Pink shorts.
Pink shorts? And you're outside?
Please don't get me in trouble. There's no way that I can get in trouble for this.
No, just stay where you're safe. You said you're outside, right?
Yes.
Okay, does he have any weapons that you know of?
No.
Okay. And did he hurt you with anything, or did he just, was it only his hand?
Fist.
Just his fist? Okay. And you don't need any medical attention?
No, I always get over it, but this time I'm not getting over it.
Understood. Okay. Okay. We're gonna go ahead and set some help here, okay? And you can just give us a call back, okay?
Wait, can I sit out front though?
Yes. Definitely sit out front. Stay out front. I'll try to send you this.
I'm gonna walk around the house.
Okay.
Okay, thank you.
Yes, bye-bye.
Goodbye.
Now publishing a video labeled 19-054917_BAT_DV.
Once again, you get the 30-second silent film. The way these body cams work, they hit the record button, and that's right when the audio starts. But the camera always saves 30 seconds before, so it's a rolling save, so it saves 30 seconds of video before they hit the button. And from when they hit the button on, we should have audio. Looks like an officer just pulled up to her place.
Really, Marco?
What's going on? You called?
I did.
Okay. Do you want to tell me what's going on?
Pardon me, just a second.
Oh. We'll be shut. Is she still in there?
He's awfully, I actually got him off of his leaves because I don't want him here. And he shows this ugly mug over the walls and he comes over and looks for me and
Do you want to press charges?
what charges are you today?
Well, what's your relationship, man?
I guess boyfriend and girlfriend.
Okay, how long have you guys been dating for?
2.5 years.
Okay. And that's a current relationship?
No, it's on and off. Because I can't deal with this shit.
Okay.
I'm sorry.
When's the last time he stayed the night at your house?
2 weeks ago.
2 weeks ago?
And he figured it out.
Okay. So why is he over here today?
Because he was suing me over. Is what he told me.
Okay. So
I'm not allowed to leave him.
you're not that.
Tell me, fuck no.
Okay.
He's mad because I went out with my girlfriend. And she introduced me to another gentleman. He's not a gentleman. He's not a gentleman. And he got pissed.
So you came over today, you let him in because you're going to talk, right?
Yes.
Okay, then what happened?
got really pissed. Really pissed.
So you guys start arguing and then
No, I didn't argue. I can't argue. I was just taking down and just speaking.
Okay. So when you say taking down beating, just like describe it for me so I know. What did he do to you? Did he push you? Was he slapping you? Was he punching you?
All of the above.
Okay, you have to kind of explain to me what happened. Or tell me like step by step.
Doors.
Okay, so you threw you into the closet doors? Okay, you're upstairs, you threw you into the closet doors. Did anything break when you threw you in there?
My head? No.
Okay, but you said you don't need the fire department?
Trying to take the wind noise out.
It's really
It's
bad.
the best I can do.
It'll go away because I'm used to it. It'll go away.
Okay, let me see. Where is it?
Right here.
Can you just put your hair back a little bit?
There's a lump. Right here. Like you can feel it.
Yeah, I see it. Do you have any other injuries?
No. Because he's not on the lease anymore, I know that he can't. I got him off the lease to not come over here anymore. And I'm trying to get him out of here. And he's over here every day. And I have a guy who's going to come home.
Okay, so there's another exit to the apartment, so he could be gone?
There's the side of my store, and the really guy. He said that I was called the police, which I had done 4 times. You're the 4th one.
Okay.
He's gonna hop along, but I have a feeling he's upstairs now. Go get him.
Well, I'm going to, but I'm going to have to try to get somebody else here. What's his name?
George.
George?
I'm sitting here.
Okay. And I have to ask this too, when's the last time you guys slept together?
Had sex?
Mm-hmm.
3 weeks ago.
Okay. So, but you guys are kind of on and get off again. And you're saying as of right now you're off. But within, okay, but within like the last 2 or 3 weeks you guys were dating.
I would say no.
Okay. But at least there was some expectation. There's an expectation of intimacy when he came over.
Oh no.
But you said you
no. We were gonna try and figure it out.
Okay.
Oh.
But you want to press charges on us?
What charges can I press?
Right now, what he said he just hit you with hands and feet and pushed you?
I got a heel on my face.
Okay, you keep getting upset with me, but you're not really giving me the information I need. I'm asking you to kind of walk me through what happened, okay, because I don't know, I wasn't there.
I know.
Okay?
Yes.
Okay, so all you said, you guys were upstairs. Alright, but that means lots of different things. So that's why I need to know what you
This is
did.
why I have all of this over here, is because he continuously got to me, and he strangled me multiple times.
Today?
Yes.
Okay. Did you start to lose consciousness or anything while you were strangling you?
I couldn't breathe.
Did you feel yourself losing consciousness?
No, I didn't lose consciousness, I just couldn't breathe.
Okay. But for how long was he strangling you for?
Till I got him off of me.
Okay.
Look, can I tell you something before you call him whatever?
Mm-hmm.
I've been arrested before because I fought back. Look, I did my bad. I did my bad. So whatever he has or whatever it is, it's not me.
Did he hit you with any, like an object or anything?
No.
Okay.
He threatens me with a bat.
Today? I'm talking about today. Did he pick up a baseball bat and threaten you? Okay. Tell me about that. How far away were you when he had the bat?
I was in the bedroom.
And where was he?
In the bedroom.
Okay. Was there anything in between you guys at the time?
My dog.
Just a dog? And how close was he to you? Couple feet? 3 feet?
3 feet.
Okay. And how was he holding the bat?
Threatening.
Like, what do you mean? Was it down by his side? Was it up like this? How was it?
He's gonna swing.
So he had it up?
Yes.
Yes. Okay. Did he say anything to you while he was going back?
I dare you.
Okay. And what do you mean by that?
Because I technically left him 2 weeks ago, which is why he's not here now. And he's not because I have friends. I have friends. And my friends want me to get out of my gloomy, doomy bullshit. So they try to introduce me to nice gentlemen, whom he is not.
Okay. So he's holding the baseball bat, and 3 feet, you guys are up in the bedroom, and he says, I dare you. Okay. And you were scared. Correct?
I'm so scared, so why I'm hiding behind the car.
Okay. I'm gonna go see if I can get him to come out. Alright, if not, this is your place, right?
He's not on leave.
Okay. And we
Talk to
have...
the apartment managers. I haven't taken off the leave.
Okay. Alright, hold on.
Sir, what is your name now?
O'Neill.
What? The door is open.
Tommy. If there's anybody available, can I get 44?
Don't get me a phone.
Hey, George? Hey, George, Sheriff's Department, can you come on out? Just hold on. Hey, George, I can hear you. Come on out. George, Sheriff's Office, come on out. Hold on. What's going on, man? Come on here, talk. What's going on? Talk to me. What's going on today? Do you speak English?
Yes.
Okay, tell me what's going on.
Why are you here right now?
Because she called me. So tell me, you want to tell me what's going on?
What? This is Rico?
Where are these cuts on your neck?
That's near the end of that, huh? Is she over there? Alright,
do you want to talk to me about the cuts on your neck?
Yeah, now, baby.
Okay, do me a favor, turn around. Put your hands down.
What?
Why am I getting cuffed up? Talk my side. Why am I getting cuffed up, sir? Okay, 424, one is diagnosed here.
Why am I getting
Okay, come over here.
Yeah, why am I getting cuffed up?
We'll talk to you about it in a second, okay? Yeah, weapons on? No. I don't know. And do you understand what's going on right now?
Yeah.
Okay. So I'm gonna read these, okay? I'm just gonna need to answer yes or no after each time I ask you a question, okay? You have the right to remain silent, do you understand that? Yeah. Anything you say will be used in court as evidence against you, do you understand that? You are entitled to talk to an attorney now and have him present now and at any time during the questioning, do you understand that?
Yeah.
If you cannot afford an attorney, one will be appointed to you without cost, do you understand that?
Yeah.
Okay. Do you desire to consult with an attorney first or have one during this interview? Yes or no? Okay. If at any time hereafter you wish to remain silent and have an attorney present, all questioning will be stopped. You understand?
Yeah.
Okay. Has anyone at any time threatened, coerced, promised you anything in order to induce you to make a statement?
No.
Okay. Do you understand these rights as I read them to you?
Yeah.
Okay. Do you wish to talk to me at this time?
Yes.
Okay. So, tell me what happened today.
What is going on?
She said that you hit her and you choked her.
What? No, sir. No, sir.
Okay, she's got a lump on her head. How did she get the lump on her head?
I don't know. She just take me in. I don't know. I don't know.
Did you push her, hit her, anything like that?
No, not at all.
Okay, how did she get the lump on her head?
I don't know.
Okay, what brought you over here today?
I was trying to get my ID and my social and my birth certificate. And she's not trying to give me that.
Okay, but obviously you've been here for a little bit. I mean, your shirt's off, you've been drinking, so you didn't want to just come over here to get something. So, like, how long have you been here?
For a while.
Okay. So, so a while, like an hour or 2 hours? Okay. How long have you guys been dating for?
Oh, man, we've been together for 2 years.
For 2 years? Okay. Are you guys still dating right now, or are you broken up? Okay.
And I work right there at Ace.
Okay, so you came over here today, so for about a while ago, an hour or two. What have you been doing since you've been here? Okay, so just spending time with her, and then all of a sudden she decided to run outside and call it now? Why would she do that? You don't know?
She's nice, dude. She's nice.
Okay, that's fine. But
as you can hear her.
But what you understand what you're telling me isn't really adding up. Because she gave me her side story.
What she said?
And she's saying that you hit her. That's all I need. It's Ma'am, I'm doing my job, okay? You just sit there and be quiet. I'll be over to talk to you when I can. Every time you start yelling, you're interfering.
She's the one that she just snapped out of nowhere. She's mad because she took me out of the lease. She took me out of the lease. And I told these guys of the lease, like, I can't cash my check. I can't cash my check without her. So please talk to her.
Okay, so you came over to talk to her about cashing your check?
Yes.
Okay, yeah, you've been here for a couple hours. Okay, so what happened to make her run outside and call the police? Because I'm seeing cuts on you and I'm seeing bruises on her. But you're not telling me what happened. And you're the one sitting in the back of a cop car right now.
I don't even know what happened.
Did she hit you?
All the time.
Who hit who first?
She does all the time.
So she hit you first?
all the time.
But today, I'm talking about today. You don't know if she hit you today? Huh? Do you have an ID on you?
She has it.
She has it?
Yeah.
Okay. Can you grab his ID for me?
No. I don't have it.
He said it's in the house.
No. I threw it in the bushes.
Where in the bushes? Because I need it.
Frank, whenever I call her, oh my gosh, the front door is open and I don't even know where my dogs are. Oh, here, by the desk. I don't have his ID.
You said you threw it in the bushes. Where in the bushes did you throw it? Could you please go look over there?
So what's happening?
It's in the back of the car. You said he hit you, he beat you, you have a bump. Okay?
I don't have it. You can look up here.
Publishing portions of 19-054, pardon, 05/BAT_BAT_DV-2. For the record, it is about 47 minutes 20 seconds long. State will publish 000 to 2 minutes and 19 minutes to 22 minutes, and all evidence will go back to the jury with a scrub computer.
Wow. Free computer for the jury. Short clips here.
Where were you?
His brother and his ranting mother came over here, so it should be somewhere in here if they didn't find it. I don't have it.
There's an item needed because it makes getting his information a lot easier if I don't have to keep asking him questions and I can just get it out there.
I'm not making any more difficult than I could, friends. I'm not. I've already looked through here.
Okay.
Jordy, get your stuff done over there, and I'll get her started on all this. You want to sit down?
She also has my birth certificate.
What the?
Listen, she said that she threw it in the bushes. I'm trying to find it.
Sorry, I clicked on the wrong one there. Properly trimmed shrubbery was what I was going for there. They're looking for his IDs there. His IDs that she says she threw in the bushes.
If you're looking here, you wouldn't be meeting right now.
You told me I'm not going to get one. I love you. I don't know what it is that you're asking me for.
Okay, maybe he didn't get to it yet. That's why I'm looking to see it. Oh, yeah. It was the backside of this. If you get any more bruises that show up that you didn't see while we were here.
Can I show you all the other pictures that I have that I have documented?
I mean, he's going to jail for this, so the rest of that I can't really do anything about. But if anything else shows up, you can go take that paper down to headquarters.
It's not going to do anything else because you're taking him down.
I
Put
mean,
him under the jail.
He's going.
Under the jail.
Okay. We're all set then.
What else do you, I could show you bloody fingers and bloody faces and black eyes and...
I know, it sounds like you guys need to probably not hang out with each other anymore.
Hello.
I know.
That's why I left
but,
him 3 weeks ago.
but this also isn't the first time, so. With both you guys, with the cops out here.
No.
Okay.
I've had to lie to you guys 3 times.
And you shouldn't have to do that, so let's make this maybe the last time.
Now I'm not lying.
And I appreciate that, okay? And keep going, okay?
They're gonna come and kill me.
Who's that?
Just like I told the other sheriff, they're gonna come and kill me.
Okay. If you...
I want you to know that. Look.
If you're in fear, are you talking about
yes.
family?
Yes.
Okay. So
I want you to know, I am full blown. They're gonna come and kill me.
go down to the courthouse, okay, and get an injunction against them. Did you get the pamphlet, the victim's rights pamphlet? Okay, so you know that there's a place where you can
They're
go
going
tonight?
to come and kill me.
Okay, so you got the victim's rights pamphlet, you know there's a place you can go tonight then? It's in the bed?
Domestic. I'm gonna go sleep over her house.
Perfect.
Neighbors.
Okay. Do you have any more questions?
Can I get drunk?
This one. Not working. I get in trouble for that. Okay. Have a good day. Okay, that's good enough. I know. Thank you. Okay.
I love it.
This one. Okay. Have a good day, man.
And whatever the fuck he says,
Okay.
tell him
Yes,
to be a dick. Hey.
Okay. Have a good night. See you, man. Thank you. Okay. Have a good day.
Tell him to
Wow.
Publishing video file axon_flex_2_video. It's the only one that starts with that name in this folder.
Guys, please be kind in chat. The mods are going to start extending the timeouts for name calling and things like that. We don't do that here.
So, why don't you come over and give me a written statement about what happened?
Where did they turn?
I have it over here by my car. Sure, just stay right there.
This is the rare but always loved shoulder cam, or lapel cam as it's sometimes referred to as. No, it's an ear cam.
Now go ahead and get your stuff done over there and I'll get her started on all this. You want to sit down in here? Is you all right? Okay.
Mom! Don't leave!
Come on, let me call you and let's get this done.
I'm not getting arrested.
No, I'm getting a statement from you. You're not being arrested. So,
Okay, look, I'll come over and see you in like 5.
come on,
Thanks, buddies. They know.
let's get this done.
They know.
Okay.
Good.
Now, would Would you come in here so we can do your statement, please? And stop this. Sit down at the table and let's get your statement filled out.
He didn't believe I would ever do it. How much for the floor? Is that okay?
Sure.
Never thought I would do it.
Did you have
No, sir. What's your name on? Yes. I'm not getting arrested.
No, you're not getting arrested. I've already told you that.
Yeah. You can go to the couch. Go to the couch.
Need your ID, please?
Go to the couch.
No, ma'am. I just need your ID.
Okay, look. I can write better on the couch.
I will give you the statement to write. I need your ID, please. I don't need to sit on the couch to fill this out. You can. I sit down all day, and I appreciate the offer.
Yes, it's comfy. I just come down, sorry. Thank you, God. He's gone. Oh, man. Oh, man. They're going to come over here and try and kill me. I want you to know that. They're going to come over here and try and kill me.
Who's that?
His brothers and his mother and his father. They're going to come over here and try and kill me.
Don't open the door for him.
It doesn't matter. They don't go up there and rant and bullshit and everything, and then they cause a commotion, and then I get complaints against me. Anyway, my name is Sarah.
Hi, Sarah. I'm filling this out just a minute.
What's your name?
Jeff, Deputy Brown.
Jeff. Well, did he get caught up?
He will be. Do you have a phone number, ma'am?
407-716-8684. I'm not getting arrested.
Nope, you're not. Did you do something you should be arrested for?
No.
Okay.
For the last time I fought back.
Do you have an email address, ma'am?
S-U-Sam, K-as-in-Kate, P-as-in-Paul, _1800 @yahoo.com. You can totally come sit down over here.
I sit down all day. I appreciate the offer, but want to get this done for you. It's a little more comfortable for me to stand and do this.
I can't tell you how amazing it is. Oh, wait, I didn't mean to say that. Sorry.
Okay.
I'm sorry. Holy crap, the car is still there.
Okay, come on in and sit down so you can get this filled out. And what I need you to do is just print your name right where that X is, and then I need you to just write the story about what happened today.
Print.
Yep, please.
I don't even know what trigger it is.
So is this a husband, boyfriend?
Yeah.
Are you guys married?
No.
How long have you been together?
2.5 years.
Was he drinking or anything today?
Yes.
Both of you?
I have.
Okay.
Bless you.
Nothing wrong with that.
Here's my arrow set, but because I do artwork, but
Okay, I need you to show us it. Very nice.
Into artwork.
Very nice.
I have as many years as I do artwork.
No, nothing wrong with that. And who called the police? Did you call the police?
I did.
Okay. Call 911?
Yes.
Very good. Has this happened before?
3 times. The last one that came up and they were like, oh yeah, we read your statement, so know kind of who you are and what's going on.
So 3 times the police have been here? Was there ever, sheriff, were there reports written when they were here?
I'm not really sure about that. I didn't have to sign anything.
Okay.
I'm not really sure what he's saying. I'm not too late.
What does it say? Can you read it to me?
Flung me off the bed and beating in the head and stuff. Am I supposed to write all that?
Yep, everything that happened.
I'm supposed to write all that?
Yep, everything that happened.
All that?
Yeah.
You see my neighbors out there, because they know their children are allowed to come at the house and say no, who he is.
And what was your phone number again? 407?
716 866. I'm not getting arrested.
Nope.
She's not getting arrested.
Out in the car still.
County charge $25.
Okay.
Could you give me 424 case number, please?
Stopping publishing at 10 minutes, 0 seconds on that file. Proceeding to third folder, OCSO 19-055572. Publishing audio file 911 call, -first.
911, what is the location of the emergency? Well, I don't have an emergency here at my place, but my boyfriend was arrested, I think, last Thursday, and he has a no contact form, and he took it upon himself to come over to my house yesterday and took the bike that I bought for him, which is technically mine, and also my debit card. So, and okay, if he bought it, then it's a gift. Okay, that's fine. I need my debit card though. Like, I have my 8-year-old son coming over here and I can't get my groceries for him. Okay, then what's your debit card? My address is 4748 Branch, FRANTV, okay, 4. So what's your apartment number? 3? Your apartment number? 3? Okay, just to make sure I heard you right. Sure. Okay. Have you used anything else with the credit card? Yeah, he bought beer and cigarettes. Yeah. Sorry, ma'am, what's your name? Sarah, S-A-R-A-H. Okay, Sarah, you call back to 407-716-8684? Yes, okay. And he's at his parents' house right now, so if you need the actual address over there or whatever, it needs to be done. I'm sorry, Sarah, what did you say? He's actually at his parents' house right now, so I don't know. Okay, well, we're up to you to make a report, okay? Gotcha. All right, I'm gonna get all this information in here, but consider it done to you. I need to send it to you, okay? All right, so when did this happen? Yesterday. Ex-boyfriend? Yeah, I mean, technically he's my boyfriend, but yeah, at this point he's my ex. Alright, what's his name? George, J-O-R-G-E. Last name? Torres, Corres.
Okay, by chance, do you know how old he is?
He's 41. 21378.
Okay. If anybody's can recognize you, are you like black or Hispanic?
I'm white.
So what color shirt pants are you wearing?
Right now I'm wearing a blue shirt with white sweatpants. And there's a green pineapple on my door because it covers up the street.
Okay. Do you have any,
Did I hear that?
weapons on you or in your home?
Did I hear that correctly?
No. I mean, I have a baseball bat, but that's just only when I'm here by myself or me and my little 8-year-old.
And you said the pineapple covering the three?
Yeah, the green pineapple covering up the street that says welcome. And I have a little bird flag out front.
Okay. All right, Sarah, we're going to the detective available with WT, okay?
No worries.
All right.
Thank you very much for the help.
You're very welcome. Bye-bye.
Okay, bye.
Publishing audio file 911 call, -2nd.
911, what is the location of your emergency? I don't necessarily have an emergency. It's 4748 France Court.
4748, what's the street name?
I'm sorry, what?
4748 and the name of the street.
France Court.
And what's going on there?
It's no contact thing.
Okay.
He's over here again.
Okay, is it branch?
Stop me penetrating.
Okay, is it branch court or French court?
FRANTD.
What's the apartment number?
3.
And what's going on there?
Too much.
Okay. What's going on?
Oh my God, I don't want my dog. She's dead. Hold on a second, please. I'm sorry, hold on. Come on. No, guys, go on this way. I'm sorry, hold on one second. I'm so sorry to take your time. No, get out. Oh,
Ma'am, what's your name?
Sarah.
Okay.
Get out of here. You take my pantry.
Hello. Hello, ma'am. Do you need a deputy?
No.
Excuse me?
I'm sorry, what did you ask me?
Do you need a deputy?
No, not necessarily. I'm trying to get my dog. I have one dog and a deaf dog. I'm trying to get them in outside.
Okay, you're dialing 911.
Yes.
Okay, and you don't need a deputy?
He's here again. Take it. That's mine in full voucher. You're urinating in my pantry.
And who's this person to you? Hello, ma'am?
Yes. Well, the first hour you're going to send somebody. So, I'm okay. Regardless. I know how it works. I'm okay. That's not yours. Hello?
I'm still here.
Yes, ma'am. Thank you. Oh, thanks. Okay. Yeah, so... What do you want me to do? Put it back! Okay, you're just somebody you're over, so like do what you gotta do.
All right, have a good day.
Publishing the one video in this file that starts with file name Axon.
Whoa. She's yelling at her deaf dog. Sounds like she calls 911 just to chat. Sarah's not sitting in front of the car this time. It's her usual spots.
You speak to him, I'll speak to you later. Come here. So I'm guessing you called for a reason, right?
Only 24 hours. Yeah. Okay.
Yeah, but you realize he's here though, right? Have you been drinking?
I had a drink.
Okay.
It was raining.
I didn't drink.
Okay, well, disappeared in different directions from one area to one of the Hispanic males. And tattoos all over him, no shirt, no pants.
Yeah, after he's here.
Other one, tattoos.
Yeah, you can stay right here. You can stay right here. He doesn't know. He doesn't know.
Another black male, no description, foreign U.S. like, an area check.
Yeah, we left it earlier. We respected your wish earlier. Yeah, we respected your wish earlier, okay? But he's here. Okay?
24 hours.
That's the only reason why. Yeah, I have to make it up.
You can stay right here. You doesn't have to know. He doesn't have to know. He doesn't have to know. Transfer promote the address occurred last night.
Oh, you can sit back, it's not right. It's just sprinkling, it's okay.
Canadian very heavy mouth. Go if you want to.
Yeah, sure.
Hey, but I'm literally begging you, don't.
Yeah, but you know he's gonna have to. Shit.
Last week, we got into I guess a physical or whatever, I don't know. I got taken out of here without no shirt, no shoes or whatever.
And then you went and saw the judge, right?
Yes.
And what did he say?
13 on down 30 today.
The judge was like...
Was it a female or male?
Female.
Female? Okay.
Yes.
What, you know what she said?
He was bad.
Yes. My head hurts. So he's like, don't grab. That's a dog. No, this is a thin blue line bracelet. Okay. And the role is written on there.
I did not get it.
You didn't do it at all. Did you get any form of paperwork?
I got paperwork, but I didn't get.
What was that paperwork for?
Paperwork was X.
And what does this say?
No.
With who? With who?
With her. But she never said anything like that. It was just the judge that put it.
The judge is what matters, right?
Is it?
Is she? I believe so. She's above us.
Is she above her?
She's a judge. She's the law. Okay.
Guys, you guys want to put me in. I have no picture.
Is my other guy here? Okay. So here's the deal, man. Your paperwork says that you can't have any contact whatsoever with her. Okay. And if you do, it's a new charge. Okay. So. Has she been drinking today? Have you been drinking? Okay. How long have you been here since?
I'm gonna be honest. You guys came here. She called me.
We know. Because we went to your work of employment.
Yes.
And they told they told us that you just left. Yep. And we knew that she called you. We knew that. We knew she called.
Oh, it's just she called me and said,
Yep. You're correct. Okay, so you know what's gonna happen, right?
Yes.
Okay. Stand up, please. Stand up, Rockwell. You can take one last phone.
Yep. Please?
Yeah, one last. Go ahead. There, just put it out real quick.
Alright. Wait, one more.
Wait, no, what?
Never make sure.
Relax. Okay? I want you to be off your head. I want you to be all around us.
Right, you promised.
I don't think they promised you that.
I was doing it earlier.
Well, that was earlier. This is a transaction. Issue, right?
I didn't call.
You didn't say you called.
See, I told you.
But you did you call him earlier?
See, I told you.
Because he just told us. And we know the store told us.
I told you. Wait, is there anything that you do?
You're good. You can stay right there.
No, is there anything that he's not?
No, man, you know he has no contact order on a judge. He can't be here.
Okay. That's sometimes.
Alright, buddy.
You need her for anything?
No, we don't. We have her information already. So here's what's gonna happen, bud. You're gonna take the ride back down, and because it's almost 2 o'clock in the afternoon, you're gonna see a judge tomorrow morning. You're gonna be able to see her today. And it might be the same judge that gave you no contact order. Okay? That's it. From here on out, but until that case is resolved, you cannot come here. Okay? Or have contact with her, even if she invites you. Okay? She called us earlier, told us that you guys had no contact order. Okay? She didn't want anything. Charge nothing. But we told her because it's domestic, send it for the has to. Okay? So, alright, but just make sure he's got nothing on him. Hey, you don't have anything on you, right, bud? No, okay. We'll make it as cordial as can be. Okay? We promise, man, alright? What you say?
I'll do it right here.
I love you, babe. Don't take it easy. You hear me? I love you. Call Private Mom. Don't get out. It's alright, man. George, give me your mom to your photos. It's not there. I don't know it. You don't know it. Tino, Sarah. What's the charges against?
So, the domestic battery charge that you got hit with last week or whatever it was, he was given a no contact order by the judge. Okay, whether she invites him or not,
I know.
he knows he can't be here. So he was here this morning, and she called us this morning, okay? He's now back. And he knows by the he can't get my contact. No, he gets a phone call anytime. Yeah, he gets when he gets in. Well, if you have a piece of paper real quick, you can get it for me, and we'll give it to him.
You don't know your mother's number? She had.
If you can get it real quick, we'll give it to him.
Can I get his mother's number?
Okay, make sure that.
Publishing from folder OCSO 19-078009. First item is a PDF of photographs.
Why is the state entering this information? No witness on the stand. This is evidence that has been admitted, and now they get to publish. See maybe some red marks. Thought maybe they could probably at least put these right side up.
Second item is the single video starting with Axon.
Goes another one.
Oh, I have been here.
Yeah, I thought you looked familiar.
Because the last time I was here, you guys had a fight at the bar. And you home, I thought.
No, we haven't.
Oh, he came home from a bar. Someone came home from a bar. Hey, who's that? What? Hey, George?
Yeah, watch out for the blind line. Is she there? She's dead.
Cop's like, this looks familiar.
No problem.
What's going on, Ty?
You didn't think I'd call.
Go, sis. Okay, come on, George. Off couch.
Go out there. No, they're not staying on there.
Okay. And then you think this is rally time? No.
No, baby.
Sarah, are you serious?
Yeah, I don't want to be punched in the neck.
Are you kidding?
Told you I will not hesitate.
That's okay.
Setting up here to more money, but
Alright, come on in. Because they won't about outside the people clubs.
Oh, he's nice enough to actually give you your shoes from last time. Ma'am, you want to get driving for me? Yes.
Sarah, are you serious right now? Sarah, you see?
Am I allowed to shut my door so not talking about?
Yeah, you can. I'll be right back with you.
We're gonna go talk down here.
Can you grab the paperwork?
Yeah.
Okay, we're gonna sit right here and punch up. And now you guys go. Don't go nowhere, all right?
You sure you don't want me to watch him?
You can, come on. That'll work too.
She's the one that hit me, and I was the one that just liked her.
I said, she's the one that hits me.
Down to the bottom of it, okay?
I'm the one that gets locked up.
Alright. George, I want to talk to you. I want to ask some questions. I have you in handcuffs, so I've got to read you something real quick, okay? Do you understand?
Yes.
Alright. You have the right to remain silent. Anything you say will be used in a court as evidence against you. You are entitled to talk to an attorney now, have him present now, or at any time during question. If you cannot afford an attorney, will be appointed for you without cost. You understand these rights as I've read them to you? Okay. At any point hereafter you wish to remain silent, have an attorney present, all questioning will stop. Do you understand that? So even if you want to talk to me at first and you change your mind, just let me know. Okay? Alright. Has anyone at any time threatened, coerced, or promised you anything in order to induce you to make a statement? Have I promised you anything? Have I bribed you? Have I said, hey, if you tell me, give me a statement? Has any of that happened? No. Okay. Do you understand these rights as I've read them to you? Yes. All right. So, what were you two fighting about tonight?
We weren't fighting at all.
Okay. What are you fighting? I'm going to take that in there so that.
COA, step 5, step 0, country, circle number 8.
I'll take the statement and get the statement done.
Oh, with him?
Huh?
For him?
No, for her. That way you can fill this out while you're 10-12 with him.
Sarah.
I'll get her information from her. Okay, listen. So why is he so angry? What happened?
I don't.
Okay, can you explain the bruises she has? Let's look up and go.
That would drive me nuts.
I want your version of what happened. Okay, so you did hit her. You did hit Okay, so she did the face and argue and get her to keep her away from you?
Looks like Sarah's driver's license. Copying some information down. 867-5309.
All right. You keep saying that You use it all the time, but you're not. How does it do something to her? You know, you're going on the fence, no. You just said it wasn't the fence. So if you get hurt, you get it set up, and you figure you can set it. That's fine. Okay. Sarah? No, you stay there. I know, I've been out there before. If I don't throw it, let me know. I think you're fine. Why happen?
20 million, those means an hour ago. Today, 6 complainant, 3028 Riverdale, 3028 Riverdale, an hour ago, via text message, code 32013.
Sorry about that. You have any broken, friction, sickness? Okay. Make sure. Sarah! Stop calling for it. Not welcome down there. I know, but I'm not going to change things. I know why. Because you have a phone. Not a battery. And when I try to get the straight story, you don't want to give it to me. I'm sitting this chair, please. You have your chance. All right. I've tried. All right. And now that you're going in the back of the car, you want to give me a story. It doesn't work that way. I've been nothing but polite to you, trying to talk to you, trying to get straight answers, and you're beating around the bush. I'm not. Yes, ma'am. Do not start kicking and banging on things, okay?
Sarah, what's your phone number? What? What's your phone number? I don't know your phone number. Sarah, what's your phone number?
It's not him asking, it's us.
You said 8 what?
867-5309.
Outlets of Verbal 711 and 10601 Narcoosey at Moss Bar, complainant versus the business, reference recon, out of 2017. Complainant is a female, pretty sure we see a great non-CRB.
Can you guys not put on meeting? Okay. Please.
Fifth folder, OCSO 19-079759. First file is a PDF starting 48-2019.
Those eyes were dilated.
Second file is an audio file, 911 call, publishing.
It's not technically an emergency, just you guys have been there so many times before. I'm not there, but I'm just trying to go home.
What is the address?
4748 Brant's Court.
What was the street name? Brant's Court?
I think the law student's sleeping.
F as in Frank, R-A-N-T-Z as in zebra.
Oh, is it France?
I don't know if it's there or not. I'm sorry?
Ma'am, is it France Lane?
I'm guessing so. It's Brant's Court, but it always comes under France Lane.
Okay, what exactly is going on?
I would like to go home, but but I can't go home because he's there.
Okay, do you have some sort of restraining order against him, or?
He has a no contact.
Is there an apartment number?
3.
1 second.
I'm at my former husband's house right now because I can't go home. I don't even know if he's there or not. He was there earlier, but I can't go home.
Okay, so do you want us to do a standby with you?
What do you mean?
Like escort you to the residence, or that I'm not understanding what you like.
If I could, please, can you guys go over there and just see if he's there? I'm pretty sure he locked me out earlier, so I think he's probably there still. I'm not going over there with him then. I'm not.
Okay, does he live there?
No.
Okay, so how is he inside the residence then?
He has a key that he took.
Okay, so is he breaking into the apartment?
He's not breaking, he's already in the apartment. As far as I know, I don't know, like, if he's there or not. He knows where I had my key.
Okay, what we can do is we can meet you a block away from the residence and go with you to the residence.
I don't know. I tried calling him to ask him to leave if he's not already. So I have my 8-year-old that I'm trying to watch out for right now. So I'm not really sure what I'm supposed to be doing. I just want to go home.
Okay, if you want to go home and you're not sure if he's there or not, we can meet you when you're about 5 minutes to a block away and go with you to make sure he's not there.
Okay, well, okay, I'm about to be honest with you, kicked out of my apartment because you guys get calls so often, and like the bodega comes and there's not everything, and like the neighbors complaining about everything, I'm trying to avoid that. I just want to go home.
Okay, regardless, the deputies are going to go to the apartment, whether it's with you, what I'm suggesting you do, or it's what you want to do. Just have them go to the apartment. So regardless, people are going to see that there's deputies going to that address.
Okay, so when I called you guys like a couple of days ago, and they didn't make not a ruckus, but they made it incognito, which is what I need, because I'm going to get kicked out of my place.
Okay, when we do a standby, ma'am, all we're going to do is accompany you to the address and the deputy to make sure that he is not there, and then they will leave. If that's all that's going on in this situation right now that you're calling for, it's not going to be a big deal.
And what happens when he is there?
If he is there and you don't want him there, you can have him trespass. They're going to make sure he can leave. I mean, if he does not live there, like you're saying, and he should not be in there, you can trespass him. You already have a no contact order with him. They will remove him.
Okay, well, there was an altercation earlier, and I'll be honest with you. There was an altercation earlier. So that's when he came in, the altercation happened. So that's when I left. I fled. Barefoot. Now I'm at my former husband's house.
Okay, would you like the officers to meet you where you're at right now?
That's not going to work for
I don't
me.
want to get arrested. I don't, because I fought for myself, and I have my 8-year-old, and I just want to go home and sleep in my own bed right now. But I did fight back. I'm not going to lie. So.
Okay, well, I mean, if you're wanting us to meet with you or go to your house, I mean, I don't know what they're going to do. If they're either going to arrest anyone, arrest you, arrest him. That's all up to the deputy and what he concludes from the situation that's going on. So it's right now it's just up to what you want to do right now. If you want to do a standby, we'll accompany you to the residence. I mean, it's really just what you want to do.
I know. I think I have to take my time to school tomorrow.
Or what I could do is I can have the deputy call you about the matter if you want to speak to a deputy directly, and if you want to do that first before having us respond out there.
Yes, please.
Okay. What's your name?
Sarah.
1 second, Sarah.
Thank you for your help. Actually, more ways than one.
And is a good phone number for you 407-716-8684?
Yes, ma'am.
Okay.
Thanks for your help
I'm
in
going
more
to
ways
make a
than
call
one.
for a deputy to call you over the phone, so you can talk to them directly and see what they say about the situation. And when they call you, it'll be from a blocked or restricted number. So if you get a call like that, just make sure you answer. It's going to be the deputy, okay?
Yes, ma'am.
All right. If anything changes or you decide you just want us to come out and give us a call back, okay?
Yes. What was your name?
My name's Rachel.
Rachel, thank you so much for your help, and I've got the phone right here on the line.
Okay, perfect. Bye-bye.
Thank you. Bye.
Publishing the one video in the folder, starting with 1924, from 0 minutes to 20 minutes, and 41:30 to the end.
Oh my goodness. Thanks for your help in more ways than one. What does that mean? And once again, I don't want to get arrested because I did fight back. Sounds like she's luring him to the apartment and then calling the cops to get him arrested. Cover your ears. Here we go. In 3, 2, 1. Chirp, chirp.
I'll take this with me for about it.
Yeah, both of these?
Just, I can't get out.
Tell me already.
No, I can't.
Is there a back door or a side door?
Yes. You mean,
No. If you go to 10-12, just let us know. Well, thought that was open for a second.
Yeah, it looks like it.
Locked. That's open.
and he wants the back too.
Yeah, the back's locked. Anyway, you want to call your ex-husband? You got a phone?
It's about to die.
There's a charger in that.
It's not in the house.
Excuse me?
It's not to say it's not in there, just because the doors are locked.
I don't understand. You think he's inside?
Yes.
Okay, well, we need a key so we can get inside so he's inside. That's what I'm getting at.
gonna die, there's a charger in back on the back side of the porch.
Oh, yeah.
The keys in the house is not coming at the door, but you have my spare key. I can't get in. If there's no other way of getting in the house. Unfortunately, can you please bring me my spare key? Yes, please. The front door and back door. I have no way of getting in.
Where'd you live on then?
I'm sorry?
You said that's your ex?
Last night, right down the street.
Oh, perfect.
He'll be here in like 2 minutes.
Perfect. Thank you so much.
No, thank you.
Is your this your who you think is your ex-boyfriend? Is that correct?
This is my place.
Okay.
Your boyfriend or ex-boyfriend?
I don't know what's going on.
Somebody you dated?
Yes.
Okay. Did you know that he wasn't?
No.
Okay.
No.
He was arrested last week for bad eating.
Hey guys, I just want to take a picture right here. You can see that.
Saw he was arrested before. Was that also like
last week?
Yeah, but that's why I called you. And again, I was sleeping.
How much did he have to drink tonight?
Oh my God knows.
How much did you have to drink tonight?
2 drinks. And that was what, 4 hours ago?
So what's the layout of the house? Is it both floors? Is this part here? Or is that so these 2 windows right here? What kind of vehicle does he drive?
That's a bike that I bought from.
See a little bit of movement on the drive.
It's about my dog. I have a divine dog and a French dog.
Oh, gotcha.
So I have a feeling it's probably text. Just the that one.
Does he have anywhere else to go? Or is this the only place he has?
He has his parents' house.
Where's that at?
80-30-15 Baja Boulevard. It's on the street next to where the street is. You know where that is.
Oh, gotcha.
Guys, can I say something now?
Sure.
If both doors are locked, he has to be in there.
Why is that? You can't lock it from the outside?
No.
Doesn't he have a key here for you though?
Unless he took my spare key, which I'm pretty sure he probably did, he has to be in there. Especially with the back door.
Is the spare key, was the spare key in the house?
No, I headed outside because he locks me out all the time. So I'm going to say that then. If both doors are locked, he has to be in there. Y'all can have to see, y'all can open the door.
Hey, you're gonna stay outside till we make sure nobody's inside.
I'll get back. Thank you so much.
He's hanging out here.
I am. I'm not going in there. There's no weapon. There's no weapon.
Ask for minimum. Ask for minimum.
That's Lucas.
Reference building search.
I know.
County 124 Charlie.
I'm just telling them.
Thanks, sir.
You're welcome.
Can we get minimum traffic for a building search? Everybody make an announcement? Yep.
You guys don't have to do that.
Man, we have a way to do things. Just let's do our thing, okay? Sheriff's office, you in there, come on out. Little louder, little louder. Sheriff's office, you in there, come on out. I got a dog. George!
Dog's deaf. There's the bathroom.
Yeah.
There's a puzzle room.
Plants on the right side.
Just when you get to the stairwell, just poke your go right up, or don't go up, but when you got up. George! Please! If you're up there, let us know. Because we're coming up anyway.
We're coming up.
Go ahead. Run whenever you're comfortable.
Yeah.
Got your 6.
Open door right there. I think that's the kid's bedroom. Okay. Just get that way for me. I got it. Someone come in. When you going that way? Boy! Show your hands. Come on with your hands up. George, step out with your hands up. Put your hands behind your head.
Hey, turn around. Face away from me. Turn around. Walk back to me. Walk back, walk back. Just paint his name right now. Why did you tell us? Huh? I don't think you hear it. There's a reason you're sitting in the bathroom. That's what. Alright.
And once you're trying to run off, go back normal.
Hey guys, can I?
Before you go, we're not doing anything right now. Alright, we're not even taking out a room. I'm gonna sit down on the bed right here.
Okay. Okay.
Alright. Let me ask you a question.
Yeah.
What happened today? You got a light here?
Yeah.
You just got a full thing?
Yeah.
What happened?
I don't even know what the heck happened.
There's a reason you're hiding the bathroom, so don't act like we're not here for no reason.
No, I know that.
Okay, so
I'm hiding in the bathroom because we had a discussion and as usual, and I am in the room.
Okay. Why?
I am with what is it called? It's called
No contact for it.
no.
How long have you been here? How many days since you got released? When did you get released? Because you were arrested last week, right?
Yeah.
Alright, when did you get out?
Let's say 3 days ago or something like
It
that.
was on the weekend?
Yeah.
Today's Wednesday. Or was it Monday? Or was it this weekend or was it Monday?
The weekend.
Okay. After that, did you guys talk, come back here? Yeah. This weekend?
Yeah.
And everything was fine between you two? Till tonight? What happened tonight?
I don't know what happened tonight.
George. So you're constantly in front of you. You're hiding in the bathroom.
Yeah, I know that.
Okay. That's not for no reason. Right?
Wifey is nuts, and she always freaking starts stuff, and she.
So that's what I'm asking. I'm telling you. Tell me what happened.
She puts it on me
Okay. She puts it on you.
all the time.
Oh, you're not. None of that gives me any insight as to what happened tonight.
Nothing.
You both are very big. She's very big. You're very big. Any more than big.
What is she being big about?
I can't discuss what she's discussing until you discuss to me. Right?
We just want to hear your side of things, bud.
Oh, everybody wants to hear my side all the time.
George, I didn't know you. Okay. Because this isn't the first incident between you two.
Oh, I know
She's
that.
been arrested as well, hasn't she?
Yes.
Okay. Let's tell me what happened. You all drinking?
Yes.
Both of you?
Yes.
Okay. I can smell alcohol on her, so I know that's, I already knew that, obviously. But,
we've been going through a lot. Right now, I work at Ace right here, across the street. We're going through a lot, and they're about to shut down and whatnot.
At Ace?
Yes.
Okay. Just tell her I'm coming back.
May I please have some water?
Just wait. There's a, you can't drink that for right now? Oh, you can't come in here for right now. Okay, you're gonna have to wait. Give us a couple minutes.
She's down there ringing the doorbell.
But I'm not gonna.
Are you injured in any way?
No.
No. Did she injure you today? Did she hurt you? Maybe emotionally or whatever? Any physical injuries? No?
I'm the one. I'm always the one.
You're the only one saying that. You're not saying that.
I'm always the one.
But you're the only one saying that. Nobody here's saying that. But if you don't help me, how can I help you? If you don't tell me what happened, how can I help you?
That's my woman.
Okay. Sometimes that's what it is. Is that as much as you want to give me?
What's he saying?
George, I told you I can't say that. You're not going to tell me what's happening. I'm not going to tell you what she told me just so you can know exactly what it is. I can't feed you information. Why don't you ever call us?
Why?
Why not?
Would you call him? Would you call him?
Look, I've never been in that position, so I can't say.
That is your beefcake.
It ain't like that. My girlfriend's mom, she's crazy, so.
I am, what am I going to say? I'm actually wrong right now.
You're wrong right now?
Yes.
No matter what way you're saying you're wrong, no matter what way you cut it?
No way, shape, or form, you know that I am.
I can respect the responsibility because most guys won't even take responsibility.
You're going to take me in no matter what.
Well, that ain't actually necessarily true. I take girls in jail all the time, but that battered you all the time.
No, you're going to take me in because I did the no contact.
You know what that no contact said?
Yeah, I'm fucked.
What did it say?
I am fucked.
What are you not supposed to do?
Oh, man. You're the one that took me this time. How you?
I think it's
That wasn't me. I don't work this time.
They're not. They're a little similar. They're like a little.
Our hairstyle's the same.
Yeah. Yeah. It's not the same guy. I promise.
No, I promise you. I will remember you. It's not me. But what did the no contact order tell you? What did the judge tell you?
Not to get in contact with her at all.
What about in relation to this place? Are you allowed to come back?
Oh, yeah, no. Yeah.
Let me ask you this. Do you just have no place to go?
No, I've got a place to go. But
your mom's place?
Yeah.
They still over there by the Twisty Tree?
Yeah.
I do my homework.
But before you guys take me, can I get at least shoes on?
What kind of shoes you want? You want some comfy ones, some fly ones?
Like those, no fly ones.
These? I like these leather ones.
Get the blue ones, please.
This one right here?
Yes, please.
What shirt you want?
And that black one right there.
This black shirt?
Yes.
You want socks?
Yes, they're right there.
You got a wallet? Phone?
My phone's downstairs.
That's it. Have a wallet.
Not that shirt.
There's another black shirt that's comfy. What's this one? Is that the other one? They're both inside out. I don't know.
The Ace? Yeah.
You like the Ace one?
Yes.
Alright, we'll do that one.
Can I, please, sir?
Please what? What do you need?
So I can put them on?
Oh yeah, we'll handle that in a second. Let's get the shoes on.
Okay.
Where do you say the socks were?
Yes.
Is black or white?
The white ones.
Okay. How long you guys been together?
3 years.
3 years, really? Has it always been like this?
My phone's somewhere in that house. It don't really matter.
I'll ask her. Okay. Just step up right here for me, please. I just gotta get in the Are you okay? Oh, what? Oh, okay. Okay. Yeah, no, it's okay. Just a quick question. He's asking about his phone. Do you know where that'd be?
No, I don't know where it's from.
Okay. You don't have it in your vehicle or anything?
I do not.
Okay.
I happened to find my gun. Wait. I need my car keys.
Okay. They're not on here. They're inside the house somewhere.
You seen them?
I haven't seen them, but they're in there somewhere. They're not on here because I had to search him before he got in the vehicle.
Is it too much to ask? If you could ask him where they are, please?
Okay.
I only have one, sir.
Okay. You don't know where his phone is? Okay. She's asking about her car keys. She said should we ask him right now?
He doesn't have enough in progress, so.
Okay. Where is she? She's up behind your vehicle.
Yeah, do you want to just take now?
Okay, yeah. Hold on. Huh? No, he didn't have anything in his pockets. We can take pictures real quick, if you don't mind. We're gonna take one overall.
No, they are.
Man, do you mind? Yeah. Stay right there. Actually, a little more this way, so we can get the police car in.
I heard we please, if you don't mind.
You said what? You want me to shine a light on it? You get close? No, actually, okay. He didn't have anything in his pockets.
I'm gonna go on the sidewalk.
Yeah, no, absolutely. They're gonna be coming this way, so if you want. Okay. Yep. One dog's sleeping downstairs and one's in your bedroom.
Coming from the area. Someone else seen or heard?
You have any other questions? I'm sure they're in there somewhere.
That's it for that exhibit. The state is at the pleasure of the court and the jury if we want to proceed.
Can the parties approach for a moment?
Let's approach one more time. That was a lot of video. A lot of painful audio video. I think Sarah has proved that she lied that initially that she can get drunk. And that she smokes in the house. Yes, that's also true. Debbie. She came out with the lit cigarette. George also smoking in the house. One of the times where they arrested him on the couch, not the time he was sleeping, but the other time, they came in, they gave him one last puff, and then he had to put the cigarette out, and then they arrested him. So they definitely did smoke in the house. All right.
Members of the jury, thank you so much for your attention this afternoon. The state still has some additional evidence to place into evidence. It's about an hour or so. Now, I know I got a note this morning, we can't stay past 5:30. So the question I have for y'all is, are you okay with staying until 5:30? Or do you want to go ahead and call it an evening at this point in time? I leave it to you. It's 5 o'clock.
They're asking what time.
5:03, exactly.
What time is it now? Let's go.
I say keep going. Does anyone reject?
If Lauren can stay.
I think we can stay.
5:30, correct, though? That's my understanding. Okay, thank you, sir. All right, State, you may continue.
Commission unpublished 21, which was P for identification.
You may proceed, sir. Are they audio or video?
We heard it, thank you.
Are these redacted, Counselor?
No.
Okay, thank you. All right, members of the jury, I have an instruction just to read to you with regard to States 21 that you just saw.
That was 22.
I'm sorry, States 22, forgive me. Members of the jury, you have viewed and listened to video and audio recordings. The court instructs you that the recordings have been edited to eliminate irrelevant portions that would not add to your understanding of this case. The fact that the recordings have been edited should not concern you in any way and must not impact the way you viewed, listened to, and consider this evidence. Thank you. State, you may proceed.
States 21's DVD and its main folder is labeled a folder of attachments, and then there's a file labeled extraction going into folder attachments.
Law students like, I'm out of here. This job is not for me.
First file being published is IMG_0665.MOV.
It's a still image.
Date modified metadata indicates 12/3/2019, 2:05 p.m.
Whenever you leave the house, just let me know where you're going.
And you're gonna let me leave?
Yes. Just let me know where you're going.
And I get to leave the house?
Yes.
Exit?
Just let me know where you're going so at least I know where you're at.
Anything else you'd like to add?
I love you.
So it's not yank me back in the house and sit the fuck down and shut the fuck up?
No.
Yank.
No. Just let me know where you're going so I know where you're at. So if you don't come back, there's no certain time. You don't have to come home at a certain time because I'm not. You're grown up. I just want to know that if it does surpass a certain time, that's like shit. Where's she at? I know where you told me you were going to be at. So that way I can go and.
So I'm not allowed to have friends?
Yes, nobody said you can't have friends.
I can just go see Boo.
You can go see whoever. I just don't want you to go frolicking with male friends by yourself because you know what's happened already. You understand what I'm saying?
So I get to go see Boo.
Do you get what I'm saying?
I get to go see Boo.
I don't care about Boo. You can go to see Boo. Do you understand what I'm saying, though?
Next video is a long file name that starts with 2A494, and it's the only one that will show up with that search. Date modified indicates 12/29/19, 12:26 p.m.
Hi. Fuck you.
I don't know what the fuck you talking about, dude.
Let's just tell everybody you got crumpled on the bed.
Crumpled? Crumpled. The word you're using is crumpled? Alright. Alright, so this is my Jesus, you gotta put it all over my face, dude. I know you're filming me, but you gotta put it all. What the fuck is that? Stop.
Bum rushed.
Yeah, you're bum rushed.
I bum rushed you.
Yeah, whatever. Anyways.
What was the choice?
So, the choice was to beat your ass or get my ass beat or whatever.
No.
Huh?
Twas.
Huh?
Twas.
Twat?
Twas.
I like twat. I've been trying to get twat from this woman. I've been trying to. Hurting me. The phone. I've been trying to get some of that right there. She's on some other shit.
Content.
I don't know what's going on. She's trying to film me, filming her, and blah, blah, blah.
I'm cooler than you.
No, yeah, you are. You are cooler than me. You are cooler than me. She is cooler than me. She is beyond cooler than me.
Oh, I want to get this on film tape. Did I take your cigarettes tonight?
No.
Did I take your cigarettes to the beach?
No.
But who was blaming on?
You. I blame it on you. Sorry. I apologize. Can I walk around this way and actually film it better? I don't want darkness because you're not dark. Ah! Oh, there she goes. There she goes. What are you filming? You filming me filming you? You filming me filming you?
What's the latest thing you've done me wrong by?
Man, I watched porno. Hey. Wait. It stopped.
My husband.
What's up? I was watching porn with my she don't like that. I'm not shrugging my shoulders or anything like that. Like it's not no big deal.
After you begged and pled and cried.
Yeah.
We trust you.
I know. I'm not shrugging my.
Say it. Begged,
Yeah.
pled, cried.
You begged.
I didn't. You did.
Well, whatever. Okay. Yeah, I did.
Say it.
I begged and
Pled. And cried. For me to trust you.
For you to trust me. But again, I'm not sure. Did I watch porno again? Yes, I did. But
good.
Whoa.
Next is a video starting with 3BB0C. Metadata shows date modified 12/29, 12:36 p.m. of 2019.
Yeah. So you remember this. Are you drunk right now?
No.
How much alcohol did you drink?
Enough to be drunk.
You're slurring your words. You're sleeping up against the door right now.
Yeah, because I want to be next to you.
Did I not tell you to not bother me?
Yes, ma'am.
So what is it you come up and do? What time is it right now? It's 1:20 a.m.
Okay. I haven't bothered you since then. I just go to sleep.
But didn't I tell you before at 9:30 to not bother me at all?
Yes.
Because why?
Yeah, don't work tomorrow.
Nope. Because I've been up since 4 a.m. since yesterday when you fucked with me.
Yes, ma'am.
I know how much vodka was in that bottle. And what's the bottle now?
Kind of to throw it out. Maybe
What does that mean?
one more drink.
The bottle's empty. I know how much vodka was in there. Enough for 2 people to have a really good time. And who drank it? I want it to be documented that I'm leaving you, which means that you're getting out. You're getting out. You're getting out.
Nobody's leaving nobody. Stop.
And the reason why you were even downstairs and weak enough to get drunk was because you don't give a shit about me. You don't listen to what I say. Special things that I keep on my front page of my phone so I remember to tell you about it because of how special and fun it is. I always bother you. I always bore you. You don't listen to me. Yesterday was my first day at work, remember? And I ended up 90% hearing about your day and 10% about mine.
You don't bother me or anything without talking. Sometimes you just you overwhelm me. That's the problem. You overwhelm me.
By telling you about my first day at work?
No, dude, you just overwhelm me about every other thing too. It's not just first day at work.
So I'm overwhelming you by telling you about the 4th highest paid baseball player. That's a client of ours.
I'm not starstruck.
I don't even know who the guy is.
I don't need.
So the reason why, so you fully admit now that you didn't care and you did brush me off in the car. Midway sentence. Because you're not into baseball.
No, I didn't. I'm just saying.
I want to go to sleep. Go downstairs.
Yeah.
I'm leaving you, and I'm going to try and cancel plane tickets.
No.
Because I don't do special things for people like you that are doing this like to me
After I asked you at 1:21 in the morning, I wanted to be asleep. I wanted to stay asleep, which is why I got in the bed at 8:30.
I know I'm not doing it.
I told you not to step foot in the bedroom. So what do? Nonetheless, you're drunk. The amount of alcohol, I know how much was out. I know how much was there. That's why I could smell you in the bed before you actually got me up. I can smell you from here. You're despicable.
I'm not despicable. I'm not even doing anything.
Leave me alone.
Okay.
You're not gonna remember shit. Okay.
Yeah, okay. Well, I'm not doing nothing right now.
Get away from me. Get away from me.
I'm not doing nothing to you.
You do everything to me all the time. All the time. Heartache and pain is what you cause me. Heartache and pain.
How is that?
Keep going. And I dare you. I dare you. I dare you. You get on your fucking little bike and go to fucking work tomorrow. Don't look at me. Don't come close to me. Don't touch me. Do you understand?
What do you mean?
As of this moment, and until I can get you out,
Get the fuck out of here.
I dare you. Yep, look at it. Wait, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder. I will scream bloody murder. Get away from me.
Dude, nobody's doing anything.
I'm gonna fucking hurt you.
Nobody's doing anything. And you're filming it.
Let me go.
Nobody's doing anything.
I'm asking you, George, to get away from me. Please get away from me. Get away from me.
Yeah, I am. That was your function, dude. Malfunction. No, your malfunction is you, dude.
Okay, whatever you say. Whatever you say. Holy shit, the whole hallway just reeks of you up here. First it's shit, now it's alcohol. Don't step foot in this bedroom. I can't even breathe. Like, it's disgusting. Like, it's disgusting.
Keep filming me with this looking money. Good night, Sarah. Love you.
I don't love you. I don't like you. I don't want to be with you.
Next video starts 456. That's the only file that starts with that. Date modified metadata 12/29/2019, 4:04 p.m.
And I'm not going to have no Hindenburg situation, no Titanic situation, okay? So it's going to be a good day. Yes, I'm missing my mustache right now. And later on, everything's going to go off. Truth. Facts. Truth and facts. All of this is going to be missing later on. We'll take another video again later on when it happens. Love y'all whoever watches this video.
No, that's not approved.
The FDA says it's approved.
So it's gonna be a good day all day.
Yes, it is. Even when
All day.
I shave all of this
All
off.
day.
Yes. Even when I shave all of this off.
All day.
It's gonna be an amazing day.
It's what time right now?
Shaboing boing.
I would say 9:30. 7 o'clock maybe.
Shaboing boing. That's what we're doing later on. Shaboing boing. You can stop filming now.
Not good enough.
It's gonna be a great day. Today's a great day to have a great day. Boom. Cut. Somebody come in with a. Can somebody come in with a? Can you not?
Next file is image_093.mov. Metadata date modified 1/3/2020, 2:48 p.m.
It's 6:13 and I asked him not to play music. Because I told him that I was going to go to shit.
Pretty proud.
We might have to turn this down. Apologize, we can't have music playing.
Next file is img_0975.mov. Metadata shows date modified January 19th, 2020, 2:58 p.m.
Time.
Sirens, 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 sirens. Sirens and sirens and sirens. And this cop car.
How about you get an umbrella and call me Camille underneath it?
Yeah, how about we forget about that? No, we won't.
I'll never be.
No. How about we keep going on? Okay, how about this? When beautiful Lucas is here, we don't listen to none of that. I don't want to hear sirens. It's just beep, 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 all that, whatever. I want to listen to that. It's every single day. Beeping and we hear enough of it. Out here in reality.
Are you gonna be nice tonight?
Yes. Yes. I promise you. I just
go for a walk.
By myself?
Yes.
No.
Go for a walk.
No, I'm just gonna chill out. If that's the case, I'll just chill out. So much like this.
Don't ever be a woman.
How can I be a woman?
Don't ever.
I can't. But I can somewhat understand.
Don't ever.
I can somewhat understand. Somewhat understand. I can somewhat understand, yes, where you're coming from. But when you have a child and it's like right now, this is too much. But we had a blast with him. Amazing.
Then you got out of sorts and pushed me, and you stole my phone and called
I
Greg.
got out of sorts. Why is it that I got out of sorts?
You pushed me.
I pushed you. I didn't push you. How do I get out of sorts all of a sudden? I don't want to hear it.
You drink too much and you're upset.
Drink too much.
Go get your fuck card shit.
What are you talking about?
Your retard paper. Don't hit women.
Have I hit you? No. So where are you going with this?
I'm turning this off.
Tell me whatever else you have off. I get it. You can film me, take a picture of whatever you want.
You can tell you're on my phone.
I'm not doing.
Do I forget a button? No, I don't.
I'm not doing anything to you.
No, I never do.
I'm not doing anything to you, Sarah.
That's my name. Don't wear it out.
Sarita. I'm not doing anything to you.
Yet.
It's not a yet. I will not.
Mr. J.
It is 5:28, and we have 3 minutes and 49 seconds of videos if the jury is capable of staying.
I got a thumbs up from the jury. You may proceed, sir.
Next image or movie is IMG_1011.move. Metadata shows date modified 2/2/2020, 11:42 p.m.
Hi, my fan. This is what happens. I'm going upstairs to ask for where my car keys are. Because it takes a little time. Where are my car keys? Where are my car keys? Where are my car keys?
Where are you always at? What are you talking about?
No, they're not. You took them.
Sarah, I didn't see your car keys. Damn it.
Where are my car keys?
Where they at? All the time. What in the world are you talking about? They're in the... They're there where...
They're not.
Sarah. They're at the...
No, they're not. You took them. I watched you walk away with them.
Why would I take your freaking car keys?
Oh, you're not going to curse now?
What are you talking about?
You took my car keys.
I didn't take your car keys.
You did.
Movie starting with file name B51, long file name. Metadata shows 12/29/2019, 4:04 p.m. modified.
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and it got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, If you can.
Dismiss.
Dismiss this case.
Closed.
Drop it. She is not the type of person.
Good person.
Great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sign it.
What?
And they did.
Good, I love you, baby. Wherever you want to. God will prevail and will take us out of this situation. Love you.
End it good. I love you. What else do you want me to
today,
say?
Judge?
All right. Get your lights back on.
Wow.
Members of the jury, it is 5:33 p.m. I thank you again for your time and your service in this matter. I'm going to give you another instruction before I discharge you for the evening. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we'll see you again tomorrow morning here at 9 a.m. and 12 Alpha. Thank you so much.
And just like that, we're back where we started, where I remember saying that the strongest evidence against Sarah Boone was going to be her own voice on her video. I just didn't know it would be that bad.
Y'all may be seated. Bruce. Thank you. Y'all can take a seat. Thank you. State, how much additional presentation do we anticipate tomorrow, sir?
It's just reading from the 108-page PDF that was on that last exhibit. I haven't practiced reading it in front of the mirror, so I'm not too sure, but not too long.
Okay.
4 minutes.
40? Okay. All right. And then you'll be resting at that point in time, correct?
Yes, Your Honor.
All right. Defense? Wow. What, if any, positions do you have at this point in time?
Other than the defenseless one.
Judge, I don't think we're going to put on a server rebuttal, but we'll think about it overnight.
Okay.
But I anticipate no.
Okay. I'll certainly let you stew on it this evening. I know it's been a long day for all of us. Where are we and how do we want to address the jury instructions? Because that is going to take some time.
I say, I was thinking we should have had the jury come in at 10. I can take care of that ahead of time.
Well, the other alternative that I can suggest is I can be here at 8. I can get here at 8 and we could start working on jury instructions at that point in time, at least so we can move forward through some of it. And then we could try to just move forward from there.
Guess up for an early morning. Cameraman, can you help us out?
I'm here for y'all. You tell me what you want.
It's fine with starting the charge conference at 8.
I mean, my worry is it's going to take us some time, and if we start at 9, 9:40, and it's going to take some time to work our way through these jury instructions. I don't want them sitting back there for 2+ hours just hanging out. We can at least get ahead of that.
Could we let them know to come in later?
They're still here. I'm fine with that. State? They're gone? Okay.
Yeah, they split.
What I'm hearing is maybe closing arguments start at 1.
Yeah, that's possible. That's possible, if we can get through all the instructions. Mr. Henderson?
If I could compromise, how about 8:30, Judge?
I'm up at 5:30. It makes no difference to me. All right. 8:30 it is. We'll see you all at 8:30 tomorrow morning, and we'll start to go through the instructions. Anything else, State, we need to address? No. State or defense? All right. Thank you all very much. We'll see you tomorrow morning at 8:30. We're off the record.
That was terrible to watch. When this began, we've watched hours of video and audio, and most of it, as we started, was body cam footage, 911 calls, and at times I was thinking, why would the state introduce this when they have, this is Sarah complaining that George has attacked her one more time, that it's happened again. I'm like, why is this coming from the state? And then we saw the other footage. And the other footage is what Sarah filmed on her phone. And it was controlling, it was manipulative, it was abusive. And in every instance, George was the victim. It showed him being compliant, agreeing, self-deprecating, being willing to repeat anything she said, even to a judge under oath, that she was, she would never do anything. This is a one-off. It was my fault. She's the best thing that's ever happened to me. It'll never happen again. This. She wakes him up in the middle of the night to say her keys are missing. And he's like, why would I have your keys? I've just been here. They're not missing. She orders him to go downstairs, to stay away from. This is a guy that suffered a lot. Sorry, put some headphones on. I'm not sure if we're going to take phone calls right now. Hang on.
Okay, so I have a kid who needs my attention, but I just wanted to come in here and say, if I had the courage to listen to her side, I've got to be courageous and face up when I am done. I'm wrong with that. Okay, done. Here's the thing. That's over. There is no part of her actions on those films, on those videos that said abused. It all said abuser. It all said, and I'm glad that I kept my mind open and willing to listen, but from watching that, it's done. It's over. She's guilty, 100%. Not just guilty of doing it, but she's guilty of being the abuser. She's guilty of being, like everything that we were worried that he might be doing to her, she was doing to him. And yeah, that was just, that was bad. In a way, it is relieving that it was hard to try to see it from her point of view, and now I don't feel any obligation to do that anymore. I'm like, okay, that's that. Wow, every bad possibility, she did it, and that was heartbreaking.
The state kept that in their back pocket. That was their ace in the hole. The whole time they knew these videos. They got these videos from Sarah's phone.
Yeah.
The same time they got the videos of the suitcase. They had access at that time. They've known this entire time that this was out there.
Wow.
And so has she.
I do have to go. I've got a kid who really needs me. But
all right.
But there you guys go. I'm done. I'm done standing for Sarah. I'm done trying to see it from the other point of view. That was it. Nail in coffin. Over. She's done. She's going to be found guilty, and she deserves to be.
There we go. Mrs. R.A. is awesome. Love her. That was really disturbing. Watching that was, honestly, when we're watching that, I'm not sure which was worse. Seeing that happen and seeing him cower in front of her, or hearing him begging for his life in the suitcase. It was just another episode of what had been going on. We're on that front. I do apologize. I know a lot of people want to share some things, but emotionally, I'm spent on this, and we probably need to sleep a little bit. When there are hard days in court like this, we probably need to rest a little bit. We're gonna have a podcast tonight. We're gonna do the Not Relevant podcast. It's going to be a break from this. This has been heavy, and we're gonna step back a little bit and have some lighthearted fun tonight. With on the Not Relevant podcast. It starts here on this channel, 8 o'clock. I'd love for you all to be here. Please, one of my incredible mods, Thomas, and I run the podcast. He is the best. He's the best host. I'm a good co-host, but he's the best host you could ever want. He's a great example, a mentor to me as well. Please join us. We'll have some fun. We'll have some lighthearted fun. It's live, just like this. We ask you to come up and participate. Bring a friend. It's 8 o'clock. Ring the bell, click the subscribe button, and come join us. Just don't expect court talk, because we probably won't mention it. Besides just a brief mention, and just come out and hang out a little bit, and let's lift each other up a little bit, and have some good memories today, because that was something that was pretty disturbing. So, Pizza, welcome to the gallery. Pizza's always good. Thank you very much. Welcome. I want to say thank you once again to our amazing partners on this one. Down in Florida, they are Trial TV Live. There's Trial TV Live. Top Mark Media is my company. The two of us have partnered together to bring you the live court footage on this trial. And I appreciate all that they do down there to make that possible. Thank you, Aaron and Chris. Look forward to working with you on more great adventures as we move forward. Thank you, everyone. Thanks to the amazing mods who help run this channel. I could not do this without them. Because of that, I am fiercely defensive of them. And y'all don't say anything about the mods. Nothing. They have silenced their opinions in many ways, just so that they can represent the channel without sharing something. So they mute themselves as far as their opinions go, and instead just help out with the channel. And they do it day after day. Incredibly a wonderful job. So if you say something bad about the mods, you expect to be timed out. And I push them. I tell them to time you out for at least 24 hours. That's my call. If you got less than that, it's because they went easy on you, against my wishes. But thank you very much. Thanks to all of you. This is a wonderful community. I appreciate every single one of you for being here. Thank you. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe. We'll go live again tomorrow morning. We're going live tonight with the podcast, 8 p.m. And then we'll be back tomorrow morning with what may be the final day of the Sarah Boone trial. I didn't think we'd ever get there. Thank y'all. Have a good night. We'll see you.